Scottish Government's Planning and Environmental Appeals Division. We're here today to continue the inquiry into the application under Section 36 of the Electricity Act 1989 by North Lowther Energy Initiative Limited for a wind farm. Now, we're all fairly familiar with the inquiry proceedings now, so I don't intend to go over those. But in terms of housekeeping, again, there's no fire drill today, so if the fire does go, please leave via the nearest exit and assemble outside the building. If you have a mobile phone, if you could keep that on silent or off during proceedings, that would be greatly appreciated. Again, there are wires trailing around the hall. If you can just watch yourself that you don't trip over those. Now, I think there were 2 points of clarification that Mr. Bell was going to give, and I assume that's why he's sitting in the witness table just now. So we'll get on to those in a minute. The only other procedure matter was to do with the table, showing differences between the landscape witnesses. Do we have any progress on that, or a date when that might come?
Dr. Wimble's made some progress on it. He's coming later this morning, so he will produce a draft which we can circulate to see, A, whether it's roughly what you were seeking, and B, whether the other parties, the other landscape consultants, can think it's roughly what you were seeking too, and if so, he can carry on and produce that and circulate it, have it agreed, and then provide it to you.
That sounds like a good plan, thank you. So today we have a few witnesses. First up, Mr. Bell, I guess as part of his re-examination on the policy matters. We'll then hear from Mr. Robinson and Mr. Godfrey on policy matters. And then my understanding is we'll hear from Mr. Bell, Mr. Welch, Mr. Halfhide and Dr. Wimble in terms of S&H procedures, followed by, or inserted at some point, Mr. Mundell MP on socioeconomics this afternoon.
Yes, sir. That immediately sounds a lot of evidence. At one point it may not matter, but Mr. Welsh will actually go before Mr. Bell in relation to the SNH issues. A couple of procedural matters for me, if I may, sir. I would like to lodge 2 plans with a view to saving time at the inquiry. One is a simple plan showing the 50k exclusion zone around Eskdale Muir. I can obviously ask questions about that to establish that, but in fact a plan would make matters much simpler and quicker. And in relation to the other matter, it relates to the core plan as drawn by SNH, which was accepted by Mr. Wimble to be, I think, significantly defective and misleading was his evidence in the matter. In any event, what we have done, sir, is to overlay an accurate position. Again, I can take this in oral evidence if needs be, but it would be infinitely quicker and easier to have a plan which immediately identifies the significant flaws, if you're agreeable to that, sir. I've only just got copies of these this morning, and I'm tendering them now.
Mr. Finlay, any comments?
So far I haven't seen anything, so I would ask for some time before it sounds entirely sensible. I don't accept known friends. Summation of Dr. Wimble's evidence, but no doubt he didn't expect me to anyway. But I will like to consider them, particularly I've no objection to the first plan. Eskdale Muir made an appearance yesterday and will no doubt can deal with that in closing submissions. It's the second plan I would want to at least have the opportunity to look over before agreeing that it be put in.
So could I propose that the learned friend sees it now? His witness and our witnesses are not likely to be on in the next hour or two, so he would have the plan certainly over the coffee break in the morning and probably over lunchtime. I would have thought a few minutes looking at it would suffice, and Mr. Welsh can explain it in chief if there's any difficulty about the matter at all.
Yeah, I'm happy for the plan to be handed over and for Mr. Finlay to be able to have a look at it over the break. I think that's reasonable, and we can accept the first plan, the Eskdale Muir exclusion zone. That's absolutely fine.
I think that would be document NLEI 29. And if accepted, the other one therefore will become 30.
Now, I was also approached by Ms. Gibb. I think she had further questions for Mr. Bell, but I understand that instead you might put those to Mr. Godfrey during his evidence. Is that right?
No, I actually wanted to ask Mr. Bell for some clarifications to some points that he raised yesterday, if that would be acceptable.
Well, as we said before, that's an unusual form to take because it's come after the re-examination. Mr. Steele, any comment?
Sir, I really don't mean to be difficult with the local community, but they've had every accommodation. Mr. Bell has finished his evidence and his re-examination. He's simply returning to clarify 2 points, very briefly, that you asked him about, nothing more. And if we reopen questioning now, there'll be more re-examination, and it is quite contrary to the rules, and the locals have had every opportunity, in addition to which, sir, there's pressure of time, and we are trying to get the evidence finished today. I'm in your hands. I don't want to be difficult, but on the other hand, this is contrary to the rules. A lot of slack has been cut, and I have to leave it with you, sir. I'm tempted to object, but on the other hand, I'm not sure that's appropriate with the local community. But if there was another way of dealing with this, there's evidence still to come from Mr. Godfrey, and I've no idea what's coming, but we need to make progress, sir, and every opportunity has been afforded.
I think from my own point of view, I agree in the sense that the opportunity has come. I think there is still the opportunity for your own witness, Mr. Godfrey, for you to pose questions during the examination in chief to Mr. Godfrey, and he may be able to answer for you. So on that basis, can we move forward? Mr. Bell, 2 points of clarification, I think, forestry plan and attendance at the community engagement event.
Yes, sir. Firstly, the community engagement event, the document I referred to yesterday was the pre-application consultation report. I've had time to review that in more detail overnight. There is no information on numbers attending the events, but on page 5 of the document, there is a list of the public exhibition days and dates and locations, and I've taken the opportunity to speak to the project manager for the applicant who was in attendance at those events to get a handle on the estimate of numbers, so I've got those. I could simply give you the numbers for the dates and events. I think that's the best I can do. So the first round was One Lockhead Community Centre, 20th September 2015. Estimate is 60 to 80 people over the day. That's between 4 and 9 p.m. Round 2, Sanquhar, 28th September 2016. Approximately 20 to 30 people over the event, 2 to 7:30 p.m. 28th September 2016. Also the next day, the 29th September 2016, One Lockhead Community Centre, 2 to 7:30 p.m. Approximately 40 to 50 people. And then round 3, 11th April 2017, Sanquhar, approximately 20 to 30 people. The same day, Crawfordjohn, 4 to 7:30 p.m., approximately 5 people. The next day, 12th of April 2017, One Lockhead Community Centre, 4 to 7:30, approximately 40 to 50 people. That completes that information.
Thank you for that. And in terms of the forestry information?
The forest plan with wind farm is shown in Appendix 4.2 of the ES. It's Volume 3, 2017, CD 1.20. And the change to forestry in the move to the FEI was the removal of riparian planting, 3 areas that came out. And that is shown on Plan 6 in Appendix 4.2. So the numbers that I went over yesterday still stand, and they didn't change in the move from the ES to the FEI. The only change was the removal of the riparian planting.
Thank you for the clarifications. Okay, if we could switch over the witness then, it'll be Mr. Robinson. Thank you. Sorry, Mr. Steele, may I get a copy of NLEI 29?
Sorry, sir, I thought you had that.
I'll let Mr. Robinson get comfortable in the witness table. Mr. Finlay, if you'd like to take your witness, thank you.
Mr. Robinson, for those who weren't here yesterday, you're a senior planning officer at Dumfries and Galloway Council, and you were the case officer in this matter.
That's correct.
I don't want you to read all your recognition, just a number of paragraphs. Could I ask you to read paragraph 2.5 to begin with, and then 3.1?
My inquiry report recognises the clear drive of internal and national renewable energy policy to cut carbon and greenhouse gas emissions and meet strict targets. Developing more renewable technologies, such as but not limited to onshore wind, is identified as a key driver to help meet these targets. The contribution that the North Lowther Energy Initiative proposal would make to meeting both EU, UK and Scottish renewable energy and decarbonisation targets is noted and is material in the determination of the proposal. However, I consider that, as summarised in section 4 of my inquiry report, policy reiterates that support is on the basis of development in the right place and not at the expense of environmental considerations. Paragraph 3.1. Planning policy at a national level is set out in National Planning Framework 3, CD 6.2, and Scottish Planning Policy, CD 6.1. Both NPF 3 and SPP share the same vision and planning outcomes, which are to create a successful, sustainable place, a low-carbon place, a natural, resilient place, and a more connected place.
Sorry, move on to 3.7.
My inquiry report recognises that facilitating the transition to a low-carbon economy and supporting the development of a diverse range of electricity generation from renewable technologies is a key aim of SPP to achieve the outcome of creating a low-carbon place. However, protecting, enhancing and promoting access to environmental resources is also key to creating a natural, resilient place.
My apologies, and continue to the end of 3.9.
The general support provided in SPP for renewable energy developments has to be balanced in the context of the other considerations set out, particularly those listed in paragraph 169. Whilst the potential socio-economic benefits of the proposal and contribution to renewable energy targets were recognised in paragraphs 4.79 to 4.85 of the committee report, the landscape and visual impacts of the proposed wind farm, assessed in detail in paragraphs 4.24 to 4.58, further assessed in the Council Landscapes Architect's response in CD 3.40, and is set out in Dr. Guy Wimble's evidence, DS5, are considered to be such that would have a significantly adverse effect on the natural environment. I subsequently do not consider that the proposal constitutes development in the right place and that it subsequently fails to meet the principles of sustainable development as set out in paragraph 29 of SPP, namely that it fails to protect and enhance the landscape and the wider environment. And it should be noted that the Council's development plan is in date, and therefore the tilted balance presumption, as stated in paragraph 33 of SPP does not apply. As such, I consider that the proposed development does not accord with SPP.
Thank you. If we then move on to section 4, and can I ask you to read the first 3 lines and 1 word of 4.4 and then the remainder of section 4 till the end.
Section 6.4 of my inquiry report provides a detailed, up-to-date assessment of the implications of the proposal against proposed LDP2, or now LDP2. As stated in my report, there is a likelihood that this will be the adopted plan at the time the inquiry commences. Moving on to paragraph 4.5. Whilst the wording of key policies IN1 and particularly IN2 have changed, there is a stated emphasis of supporting wind energy proposals that are located, sited and designed appropriately. Policy IN2 still requires that in respect of landscape and visual impacts, the extent to which the landscape is capable of accommodating the development without significant detrimental landscape or visual impacts, including effects on wild land, and that the design and scale of the proposal is appropriate to the scale and character of its setting, respecting the main features of the site and the wider environment, and that it addresses fully the potential for mitigation, remains and reflects that in policy IN2 of the LDP. Therefore, the Council's assessment of landscape and visual impacts and that it fails to comply with policy IN2 remains pertinent. In respect to the balance against renewable energy benefits and socio-economic benefits, paragraphs 4.79 to 4.85 of the committee report clearly set these out. Proposed policy IN2 will be accompanied by statutory supplementary guidance in the form of supplementary guidance on wind energy development management considerations, which will provide further guidance on the criteria to be met. The SG will also include the DGWLCS as an appendix to the SG and will therefore also form part of the development plan. As stated in paragraph 6.4.14 of my inquiry report, the reporter in paragraph 58 on page 180 of the examination report for proposed LDP2 raised no objection to this approach, notwithstanding that the criterion requiring the extent to which the proposal addresses the guidance contained in the DGWLCS has been removed from the criteria within the main body of the policy. The SG and accompanying appendices will importantly provide the requisite policy hook referred to in paragraph 138 of Circular 6/2013. The contents of the DGWLCS is therefore still entirely relevant in the consideration of this proposal, and as noted in paragraph 6.4.22 of my inquiry report, the draft DGWLCS does not propose any changes to the currently adopted version, or was at the time I wrote this, that is of relevance to this proposal. The content of paragraphs 4.26 to 4.31 of the Council's committee report therefore remain pertinent. In summary, I consider that LDP2 would not result in a substantial change to the Council's assessment of the proposal under the LDP.
Thank you. Just a number of points to pick up on that. You referred to the renewable energy policy. Can I just ask you to have a look at the Statement of Agreed Matters on Policy, which is CD 15.17. Mr. Innes may be able to help you with that. If you look behind you. It's been taken and not returned. I wonder whether Mr. Bell has it, because he was looking at it yesterday. Anyway, perhaps I can just lead you through it, subject to any objection from my own friend. Section 3 deals with energy policy. It sets out the relevant documents about which there's no dispute. It's agreed the seriousness of climate change and its potential effects, the seriousness of the need to cut carbon dioxide emissions, and the seriousness of Scottish Government's intentions regarding deployment of renewable energy generation and the need to achieve net zero by 2045. Do you recall that?
Off the top of my head, I do recall contents to that effect.
And then culminates in paragraph 4.4. It is agreed that renewable energy policy is a matter that should be afforded significant weight in the planning balance in this case. As far as you understand, is that the agreed position between you and Mr. Bell?
That's correct.
Okay. Then if we turn to the new LDP, and you recall yesterday, I think Mr. Bell was, which is CD 611, if we turn to page 179 and 180 of that, recall that Mr. Bell drew attention, as indeed you've done, to the rewording of policy IN2, and he had included paragraphs 55 to 57 in his report. I believe you want to draw the reporter's attention to paragraph 58.
Yes, that's correct. I have touched upon it in the precognition, but it is to draw attention to the fact that the reporter indeed stated the supplementary guidance wind energy development has been prepared in accordance with section 22 of the Act and regulation 27 of the development planning regulations. Proposed plan policy IN2 provides the requisited policy hook referred to in paragraph 138 of Circular 6/2013 development planning in relation to landscape and visual impact and cumulative impact. I consider that if the status of the DGWLCS is clarified in the way I've suggested, which is actually in the paragraph 4.109 of the adopted LDP2, there is no reason why it should not be appended to the supplementary guidance and referenced in the proposed plan.
Now, moving forward from that, can you tell the reporter the current timetable for bringing the new or the replacement SG forward?
Yes, it's intended to report the supplementary guidance or the draft supplementary guidance that was published for consultation at the same time as LDP2 back in January 2018. It's intended to report that to full council next month, the 19th of November. Depending on the outcome and what members agreed, those draft supplementary guidance where reporters accept recommendations, it will then be sent to Scottish ministers, who will then have 28 days to confirm whether or not they have any comments to make on it. So it is estimated that draft supplementary guidance will start to be adopted early in the new year.
And then let's take that guidance in two parts. As far as the wind capacity study is concerned, I think it's agreed position. There are no significant or material changes to that from the previous wind capacity study. What weight do you suggest the reporter should advise Scottish ministers to apply to that study, providing it's applied in the proper context?
The summary of changes, and it's entitled Revisions to Guidance Adopted 22nd of June 2017 for Consultation 2018, is on pages 2 and 3. And there's very few changes proposed, none of which are of relevance to this proposal. So in that sense, I don't see there being any change, and consider that it should still be given significant weight.
Then in terms of the new draft supplementary guidance, there are bits of that supplementary guidance which really merely repeat what went before, but there are more significant changes to that guidance. First of all, has that guidance... we know that guidance has been approved for consultation purposes. Are you aware of any proposals within the Council for significant change to that guidance before it's taken to committee in the next month?
No. Understandably, the beginning sections will have to change, which directly quoted what was the proposed policy IN2, so that will have to change. But in terms of the other contents, I'm not aware of any significant changes at this stage.
It may be academic, because that guidance may be part of the development plan by the time the reporter finalises his report, depending on whether he accedes to the applicant's timetable. But it may certainly be adopted by the Council by that stage. What weight do you consider you should apply to it now, and what additional weight, if any, do you think he should apply to it if the Council approve the guidance in November?
At this stage, because it's been approved by full Council and for consultation, and that consultation has finished, it's a material consideration of considerable weight at this stage. Once it's adopted, it will obviously be forming part of the development plan and therefore entitled to full weight.
Thank you. Sorry, there was discussion yesterday about, last week about cumulative sensitivity zones, I think CS said. And there was a technical paper, I think, dating from 2014, at least I think that's the date on the paper. Does that form, even before the new LDP, did that form any part of the current suite of guidance or supplementary guidance that the Council would have regard to?
No, the history of the cumulative sensitivity zone actually dates back to, I think it was interim planning policy for wind energy, which was a sort of a stopgap between the previous plan and when the local development plan was adopted. And the community sensitivity zone was very much drawn at that stage, and it responded to an emerging pattern of wind energy development at the time of late 2011. So it was very much responding to that. But then whilst the LDP was being prepared, it was examined, and then SPP was published, which really gave the spatial framework approach, which the CS said didn't comply with. So it effectively came out of date.
Thank you. Insofar as there's guidance on cumulative impacts, is that to be found within the supplementary guidance and the wind capacity study?
Yes, taking the supplementary guidance first, it's the draft supplementary guidance is section B, which explains cumulative and visual considerations. To paragraph B4, for example, or B3 explains cumulative landscape impacts. B4 explains cumulative visual impacts, and it goes on to state about whether they be in combination, in succession, and in sequence. And then paragraph B11 contains criteria for cumulative impacts on patterns of development, which is an additional section.
Thank you. That's very helpful. One last question on the planning position. There was a question from the reporter yesterday about the relevance or otherwise, firstly, of South Lanarkshire's plan, and secondly, its associated documents, such as the SLAs and its capacity studies. What relevance do you say they should have to the reporter's decision?
I would say, given that this is a Section 36 application, it is relevant to consider. I think there's four turbines proposed immediately on the boundary, and if they were to have an impact on a designation in the adjoining area which has a policy covering that, then I would say it has to be taken into account.
And then as far, I think that suffices for my purposes. Just, I think one last topic, been much mention of the Upper Nithsdale Community Trust. Does the Council consider that a community representative body?
No, they're not officially recognised as a community representative body. The Trust administers wind farm funds in the area, and it's agreed that any wind farm benefit funds provided to Sanquhar is administered through that fund and shared equally between the two communities, but they're not a community council.
Thank you. I thought that was the last one. Just one point. There was mention made yesterday by Mr. Bell about the community ownership position. What weight do you consider the reporter should advise ministers to place on that?
I think I made reference to it in the inquiry report for the socio-economic So I'll just refer to what I actually said, if you just bear with me. Yeah, it's paragraph 2.8 of the socio-economic inquiry report. I said, in respect to shared ownership, the benefits for this and the fact that it is a material consideration is noted and accepted. In the absence of any further details of what this would be, no further comments or consideration can be given at this time other than to acknowledge that it would be a positive benefit if delivered. So I would say it is a material consideration, but of limited weight without any scheme before us.
Thank you. Perhaps if you wait there, Nadat, I know friend has some questions for you.
Can I just interject there slightly? I think Mr. Steele is going to refer in closing to a legal matter to do with the Pollution Control Act, as it was a matter of law. May I ask both the QCs if they wish to also put in closing, because Mr. Bell reported yesterday that the use or not of South Lanarkshire LDP policies would be a matter of law and could indeed not be lawful. So I'd appreciate if you could address that matter as well. Mr. Steele, if you'd like to take cross.
Yep. Yes, sir. I wonder if there are any points of clarification from the other parties at first. I hope there are not, but it may be there are.
Mr. Godfrey, any points of clarification?
I've got no points of clarification, thank you.
I just have one point of clarification. You mentioned the Upper Nithsdale Community Trust, and you said that it was there to administer grant funding from wind farms. Given the very name Upper Nithsdale Community Trust, and that Wanlock Head is actually within that catchment of Upper Nithsdale, would it surprise you to note that they are not representative of Wanlock Head?
Quite possibly, yes.
Thank you for your clarification. No further questions.
Okay, Mr. Steele, if you continue.
Thanks, sir. Mr. Robinson, good morning to you. Mr. Robinson, I'm going to try and get through all of this as quickly as we possibly can, and I'll require your cooperation to keep your answers as brief as you reasonably can, giving, obviously, a fair answer. I'm not trying to cut you short as the point I'm making, but yes or no will suffice for many of my questions. Now, Mr. Robinson, let's see what we can agree about first, please. There is a statement of agreed matters which you've been taken to, and I'll take you back to it in a moment. You, so far as landscape and visual matters are concerned, you rely and adopt the evidence of Mr. Wimble. Is that correct? Rely upon and adopt the evidence of Mr. Wimble.
Yes, and also our own council landscape architect.
Yes, but your council landscape architect, as I understand it, has not given evidence here, only Mr. Wimble.
That's
that
correct.
So I don't need to ask you questions about landscape and visual because that's been dealt with by Mr. Wimble. So far as the evidence of Mr. Blackett, socioeconomics, Mr. MacArthur and Mr. Moody, no questions in cross-examination were asked about them. Therefore, can we agree that Dumfries and Galloway Council accept that evidence?
Before he asked that question, it's not fair, this witness. Fair question. I think what I'm very happy for the witness to say that Dumfries and Galloway have no objection on the grounds on which they gave evidence. It's quite another thing to say that do we accept everything they said in their evidence, because we simply haven't considered that because we didn't take any part in the sessions. So I hope that's an agreeable way forward, and it gives my learned friend what he wishes. But I'm maybe seeking to bite off a little bit more than you can chew.
So I'm trying to make progress with this. No doubt if the witness isn't happy with the questions. Let's try that again, if we may, Mr. Robinson. So far as Mr. Blackett, Mr. MacArthur and Mr. Moody were concerned, is it factually accurate that there was no cross-examination of these witnesses on behalf of Dumfries and Galloway Council?
That's correct.
Thank you. Are we also in agreement that there is no relevant reason for objection in relation to the topics that they gave evidence about?
That's correct.
And would it be your understanding, or not, Mr. Robinson, if there had been disagreement with their evidence, they would have been challenged about that?
That's correct.
Thank you. Now, can we also agree that so far as the relevant community council is concerned for the appropriate geographical area, that is the community council of Sanquhar?
That is correct, but in under planning legislation, all adjoining community councils are also part of the process.
Well, I'm not disputing that, Mr. Robinson. Again, I'm just trying to make progress, but so far as the geographical area is concerned, can we swiftly agree that Sanquhar is a relevant community council? I'm not trying to diminish anything else, but that's the relevant council.
The proposed site lies within the Sanquhar Community Council area, yes.
And as a matter of fact, can we agree that they are supportive of the proposal?
That's correct.
Can you confirm the number of residents that they represent in Sanquhar in very broad terms?
I can't give a definite answer, but I think it's somewhere in the region of 2,000 residents, the population of Sanquhar.
Well, we'll not quibble about that too much, but it is several times more than the residents of either Lead Hills or Wanloch Head or both of them put together, is it not?
Judging from the comments the other day, yes, that is correct.
Are you aware that there were a number of, separately from Sanquhar, there were a number of letters of support for the proposal?
Yes, I believe there was about 500 representations, of which 100 were in support and 400 were of objection, but I couldn't say the addresses of where they were from.
I can challenge you in the numbers if you want, but my question was a simple one. Are you aware that there are a number of letters of support? I didn't put a number to you.
Just badgering the witness. The witness has answered yes. He said yes. My learned friend is repeatedly badgering the witness. I prefer if he really wants to make progress, there's no need to.
Well, so that's really not a very helpful comment.
Well, I agree. I think Mr. Robinson answered it. He said he couldn't tell the addresses of the letters of support. I'm just wondering, this seems to be covering ground that we've covered previously.
Yes, sir. I'm trying to make progress, but trying to reach as much agreement with this witness as we can, as speedily as we can. So, Mr. Robinson, sorry, I'm completely lost with all of that. Is the position this, that there are a number of letters of support out with the support of the Community Council? I'm not interested in addresses or indeed precise numbers, but there are a number of letters.
I believe there was around 100 letters of support.
Thank you. Robinson, if you feel I'm badgering you, whatever that may or may not mean, please let me know. Now, can we go to the SPP, please? And again, I hope we can agree this swiftly. There's already been agreement that we're in a Group 3 area, and as a result of that, we are likely to be acceptable, subject, of course, to detailed considerations against policy criteria.
Yes, I agree with that.
And in relation to detailed policy considerations, your new very newly adopted LDP gives us some assistance, does it not?
I asked to clarify assistance in what way?
Assistance in knowing what the detailed criteria are. Let's look at your inquiry report at pages 23 and 24. Policy, paragraph 646, policy IN1 still has a general presumption in favour of a proposal such as ours. Does it not?
Yes, the policy IM1 in LDP2 states the Council will support development proposals for all renewable energy generation and or storage which are located, sited and designed appropriately.
And policy IN2 has introduced considerations or additional criteria, as you call them, in relation to socio-economics, infrastructure and so on and so forth. That's set out at 6.4.10 of your main report.
That's correct, yes.
And weighed in that balance, it must be the advantages spoken about by Mr Blackett, Mr MacArthur as well. Would that be fair?
Yes, anything except for reference to community benefits, yes.
Yeah, we're not at community benefits, yes. I'm just trying to reach agreement, Mr Robinson. So far as the evidence of Mr Blackett and Mr MacArthur is concerned, if it is accepted by the reporter and the ministers, that would tie in with the criteria at IN2 in relation to the various benefits. Is that so?
Yes, that's correct.
So that, trying to summarise where we are at the moment, Mr Robinson, there are some rather significant advantages in favour of the proposal, subject, of course, to landscape and visual issues, which must be weighed in the balance in the decision-making process.
Any potential socio-economic benefits that are stated within the supporting submissions has to be taken into account, yes.
And that's in favour of the proposal, as is the fact that we're in Group 3 and I can't remember the wording, but is it likely to be consented? That's all in our favour as well.
Yes, if the decision maker considers that they are of such benefit to override any adverse landscape and visual impacts, then yes.
Now, can we look, please, at the landscape capacity study, which is NLEI 21, and firstly, can you confirm that that was prepared by more than one suitably qualified landscape architects?
I believe it was prepared by a professionally qualified landscape architect, yes.
Who are well known in the area of wind farm work?
I believe so, yes.
And again, I'd like to take this as briefly as we possibly can. But if we look firstly at character type at 19, which is one of the areas we're concerned with here, is it not?
Yes, yes.
Do we see some support for this size of wind turbine in area 19?
Sorry, Mr Steele, could you draw me to a page number?
Well, I wish I could, sir, because the pages are unnumbered. But if you look through the document, much more than halfway through, sir, to character type 19, it goes from areas 1 to whatever it is. you have a page number in your...
I have that now, thank you.
So, just to confirm where we are, character type 19, southern upland type, is the area that we, or one of the areas we're concerned with here. Mr. Robinson, is that correct?
Just to check, I'm on the right page number. I'm on page 329. Was that?
The problem is I don't have any pages on mine, but I have the page head. The section starts character type 19, southern uplands type, and then there's an introduction.
I think, just concerned, Mr. Robinson may be looking at the wrong document. Mr. Steele's taken us to the 2011 version, which is NLEI 21, and it may be Mr. Innes will have to give you a copy of that.
In front of me.
Right, have you got the relevant page, Mr. Robinson? Right. And just to confirm, we're looking at area 19, which is one of the relevant areas.
Yes, we're looking at area 19, yes.
Yeah. If we turn to the table, which I hope is over the page. Do you have a table, sir? Do you have an assessment of character type 19 in any format in that document, Mr. Robinson?
The unit as a whole, just on page 139, where it just says character type 19, southern uplands type.
Yeah, I think we're looking at the main report, which is, it has some plans in it, and then the remainder is text. The tables aren't in that particular document.
I think I know. If I remember correctly, this document was in two parts. It had a more detailed second section. That's probably where you're looking from, so I'll just try and find that.
That's helpful, thank you. Certainly, I have unnumbered pages, but I'm much more than halfway through the document.
Yeah, okay. Right. The difficulty is there's two NLEI 21s, and one in my electronic version is named A, in Fries and Galloway, Wind Farm Landscape Capacity Study 2011, A, Appendix Report. I think that's what we're looking at.
That looks, Mr. Robinson, like you're just about at the same place as me. And that's the latter section of the document, is it?
I think we're there. Yeah, it's the second document that was involved.
I was hoping to take this briefly, Mr. Robinson, but we seem to have got caught up with paperwork. The simple point is this: is it accepted in the study that there is some ability for wind turbines of this size to be accommodated with this open and large-scale landscape? And indeed, if we look at the table, is that the precise wording at the topic scale and openness? Tall turbines could relate to this generally open and large-scale landscape without dominating, etc. Do you have that?
Yes, I've got it. I was just checking the character types, and under scale and openness, it says assessment of when this document was relevant, assessment of large typology. It says tall turbines could relate to this generally open and large-scale landscape without dominating the height of the hills.
Thank you. And if we turn the page to land cover and landmark features, do we again find some encouragement for this type of wind farm development? There is an absence of pattern, which would theoretically be less sensitive to wind farm development, although the openness of these uplands contrasts with the densely forested 19A. Some encouragement there as well, isn't it?
That's what this document said at the... Yes, it's what it says when it was relevant, yes.
Well, this is the professional opinion of a firm of landscape architects well renowned in the industry, is it not?
That's correct, yes.
Thank you. Settlement and archaeology, there's some scope for this typology to be accommodated without conflicts of scale and impacts on the setting of settlements. Is that also set out there?
It does set that out, yes.
If we then turn on to the summary of capacity, which is a couple of pages later, is that drawn together? In the second paragraph, while the scale of these character types could relate to larger typologies, this distinctive landform, etc., is as set out there. Again, is it accepting that there may be some capacity for this size of wind turbine?
I wouldn't fully accept that. It says, are you reading the second paragraph?
I was trying to read it brief to save time, yes.
Yeah, but it says, yes, it says, while the scale of this character type could relate to larger typologies, the distinctive landform of these uplands where hills are pronounced and often form steep, rugged edges to adjacent dales and upland glens is a key constraint to development.
To the Southern Uplands, Nithsdale and Northwest Lowther unit, broadly speaking, do we see the same professional judgments there? And we can go through the various detailed findings as well, but they are broadly similar, concluding a few pages later at the summary of capacity, which says, while the large-scale, generally subtle landform and simpler landform cover of these landscape units could relate to larger typologies, there are some characteristics which increase sensitivity. I can go through the tables one by one if needs be, but the broad point is this: is it accepting some capacity that may be available because of the large scale and form of the land?
Yeah, that's of relevance to the Northwest Lowther and Nithsdale
Yes,
units.
indeed.
Yes.
Yeah, I was anxious to make that clear at the outset. Absolutely. If we then go on to the interim spatial framework map, which is in NLEI 22, can you just remind me who that was drawn up by?
I actually don't know who that was drawn up by.
Well, would it be
Off the
fair,
top of my head, I don't know.
Would it be fair to assume, do you think, that it was drawn up by a suitably qualified landscape architect?
I would assume, but as I say, I'm not 100% sure who it was drawn up by.
Very fair. Can we agree, as a matter of fact, that if we look at the plans, maps 3 and 4, we were said by whoever it was that drew this up to be out with the cumulative sensitivity zone and also out with an area requiring significant protection?
Need to find the document. Which document are we in? The
22.
Oh, it's technical.
And within that, it's maps 3 and 4. It's the next one in the folder in front of you.
Mr. Steele, I'm conscious of the fact that a lot of this has been covered already with the landscape witnesses.
Indeed, sir, but this is the policy witness for directly for De Vries and Galloway, and obviously I'm trying to build up a picture and then get to the end as quickly as I possibly can, sir. I apologise if I'm taking too much time.
map numbers were again, sorry, maps
Maps 3 and 4.
3 and 4. Okay, yeah, I have them in front of me.
And do you agree with the points I put to you briefly a moment or two ago as to where we're located?
Could you just repeat the points you made again? Sorry, I've got the maps.
Located. We're not in the cumulative sensitive zone, nor are we in the area of significant protection.
That's correct, according to these maps. Yeah.
Mr. Robinson, trying just to draw that together in terms of the planning position and policy position, insofar as the professional judgment of the landscape architects that have drawn up the earlier document and have probably drawn up the latter document, would it be fair to say that from a policy point of view, we are in a reasonably strong position? Not the end of the matter. Detailed considerations have to be taken into account, but we're in a reasonably strong position.
I wouldn't say reasonably strong position, because the capacity study at the time still raised constraints, quite clear constraints regarding that unit. But I accept that the site was not shown in a cumulative sensitivity zone at the time.
And surely you would accept that the capacity study showed the area in which we are located and the area adjacent to it as having some capacity subject to detailed considerations.
It gives more scope in the adjoining northwest Lowther unit.
Yes, that may be, but it still gives scope in the area in which we are located, as well as northwest Lowther, did it not?
I would say very limited. It highlighted a key constraint.
Right. Can I go back, please, to the question of support from government? We've already looked at the statement of agreed matters, which concluded that it was agreed that the renewable energy policy is a matter that should be afforded significant weight in the planning balance of the case. That was put to you, and you agreed. We have a document available if you wish to check that. But
yes,
that,
I think
I think
we've agreed that renewable energy policy is material consideration.
Could I also ask you to have before you Mr. Bell's inquiry report, pages 11 and 12.
Got that in front of me, yes.
Do you see there that he sets out further details from the Climate Change Committee and the latest UK position, where he sets out factual matters at pages 11 and 12?
I can see that, yes.
And do you accept what is said there, Mr. Robinson, and do you accept that that is material to the consideration of our application?
I don't have any reason to disagree with it. I think there was a point Mr. Finlay raised yesterday about the weight and what its status is, but I don't have any reason to disagree with the comments put there.
Well, the weight will be a matter for the decision maker, but you don't dispute what's here, is that so?
I don't have any reason to, no.
Thank you. Now, if we look, please, at 2.6, which is at page 13, we see the decisions quoted there, firstly from Penclow, and I think the reporter was Mr. Boulia, the senior reporter, and Hopsrig, the reporter was Mr. Bryan, also a senior reporter. We see there quotations of how they treated support from government energy policy. You will have read that. Do you accept the findings of these two senior reporters?
I note what they say, but we have other appeal decisions that have taken slightly different views, of one of which Mr Finlay referred to yesterday in the Blairmore decision.
Well, do you accept or reject these two reporters, Mr Robinson?
I accept the comments that they've made, but as I've said, there's other appeal decisions that have taken slightly different views on the matter.
Well, apart from the one at Droomba/Blairmore, which other decision do you say took a different approach?
In this council's area, there's been Anna Bagleash wind farm, there's been Longburn wind farm, these are all in court documents, and there's very recently been Glen Shimmerock wind farm and Cornharrow wind farm, which was refused, and the reporters in that case didn't, or with a key message that came over is there is no policy shift in terms of whether it's still the right development in the right place.
No, Mr Robinson, we may be at cross purposes. Of course, one has to consider the detail of the right development in the right place. There's no dispute about that. What I'm asking you about here is the support that is to be derived from government policy in relation to renewable energy. No more and no less am I asking you about. So do you accept, because this is a balancing exercise, do you accept what is said by the reporter at Penclow in that decision and at Hopstrigg in that decision?
The general support for renewable energy, I accept, yes.
Now, can we please go on to consider some matters in a bit more detail? We've already talked about the northwest Lowther area, but is it accurate that there was a decision there which is lodged before us, CD 7.53, in relation to the Spangle application?
I'm aware of the Spangle decision, yes.
And is it correct that Dumfries and Galloway refused consent for a wind farm in northwest Lowther for a variety of reasons, which
That's
we'll look
correct.
at in a moment?
Yeah, that's correct.
Yeah. Are you familiar with this, or do you wish to have the document in front of you?
I've just loaded it up now.
7.53.
Yeah, I've got the committee report. Yep, I've got that now.
Right. I'm going to try and take this briefly as I possibly can, Mr. Robinson. Is it accurate that this was refused for a number of reasons, including impact on the SPA and SSI?
Correct.
And concerns about the SPA and SSI would apply to any wind farm proposal within that area, northwest Lowther?
That was definitely the case with this proposal, yes.
Thank
I
you.
couldn't say any ones coming further forward, though.
And in addition, there were reasons given in relation to landscape and visual issues.
That's correct.
As well as effect on the northwest Lowther unit and the character type.
That's correct.
Visual receptors were an issue as well, including residential interests, nearby settlements, road rail users, and the Southern Upland Way.
That's correct.
In addition, a concern in relation to Upper Nithsdale and the Upper Valley landscape character type. Reason 4.
Yep, that's correct.
these briefly. And for good measure, there was a problem with radar as well, aviation issues.
That's correct.
Yeah. And that's likely to apply not just to this wind farm, but to any other one near at hand within that geographical area, is it not?
No, because a developer could get a mitigation strategy with gnats. In this particular case, the developer didn't progress with that very far.
Well, do you not think if the developer could have got agreement with gnats, they would have done so before having their application determined? That would be pretty stupid not to do that.
Well, generally wind farm developers do, but this particular one didn't.
Yeah. Well, does that not tell you that there might have been a problem?
I couldn't say, because generally my understanding is there's normally a solution with gnats, but for whatever reason this developer didn't do it.
No wind farm developer properly advised and acting rationally would allow a matter to be determined when there's an aviation objection from gnats. If they could solve it, would they?
I think I go back to what I said before. My understanding is there generally is a way that wind farm developers can come up with a mitigation with gnats. The developer in this case didn't proceed that far.
Right. And for good measure, at reason 6, there's a refusal in relation to the inventory of ancient and semi-natural woodland and so on at reason 6.
That's correct.
Fair to say, pretty comprehensive reasons for refusal, Mr. Robinson. Full kitchen sink here, is it not?
Could describe it as that, yes.
And many, if not all of these reasons, would apply to any other wind farm in that general location.
Well, in the position where this particular wind farm was proposed to be sited in the unit, yes. And, of course, the scale of the proposal that was put before us as well.
If we then turn to consider Glenmuckloch, which is out with the SPA being just to the south, but still in the northwest Lowther unit. I think I'm right in saying, is that so?
Yes, that's correct.
Is the factual position that the professional judgment of the planning department was that should be refused?
That is correct.
And not on one occasion, but on 2 separate occasions, that was the professional judgment of the planning department?
That is correct.
And the reasons that they recommended refusal were, again, diverse, but included landscape and visual reasons, and the effect on the landscape character type and the valley in which it effectively was situated.
Do you have a core document reference number for that?
I don't, I'm afraid, sir. I'm not.
Oh, I'm looking.
I'm not sure that there is one.
It seems to have gained a greater importance as the inquiry has gone on, Glenmuckloch.
If it would be helpful.
I think I may have a copy of the report somewhere anyway, just to try and...
If it would be helpful to you, sir, no doubt one could be supplied.
I think it should be now, because it has been referred to several times. I think on 2 occasions, there's two decisions on that, so if those could be submitted and given a core document reference.
If that's to be done, sir, perhaps between us we can lodge it rapidly, and I can come back to it after the coffee break when it is hopefully available. I don't know if the council have got copies available or could get a copy just now.
So I'm concerned about this. Not only do we need the reports, we'll need the decisions, and then you're going to have no opportunity to hear evidence as to the what you should take from the fact that officers said no but members said yes. If it was going to be a significant part of an friend's case, it should have been produced earlier. I'm not objecting to the documents being produced, but they can be produced. We can make submissions on them in closing, but I do object to this witness being held over to be asked about documents that could easily be made available beforehand. We've got to make progress today.
That's very curious. I was trying to make progress, sir, and I didn't refer to the document. It was indeed yourself who found the document would be helpful to you, and I'm very happy to go along with that. And I was trying to assist the witness and yourself by dealing with it after the coffee break. My learned friend prefers me to deal with it now. I will do so. I was simply trying to be helpful and make progress.
Well, I think the question can still be asked. It was asked of Mr. Bell yesterday, so I think you asked the reasons were diverse and included LVA reasons and the effect in the valley in which it was situated. If the witness is aware of that particular case, then I'm happy for him to answer. But in terms of the documents, I don't need them immediately, but if they could be submitted very soon, and then you can refer to them in closing, that would be appreciative, because obviously I don't have them, and you have mentioned them, so it would be useful for me to read the context.
Sir, thank you. Mr. Robinson, you, I think if I can read your screen correctly, have that document in front of you. So you're not disadvantaged in any way, is that correct?
I've got the second scheme recommendation in front of me, yes.
And can we agree briefly that the reasons that I suggested to you are indeed some of the reasons that your professional judgment of your department, and no doubt yourself, was that refusal should be the outcome?
Yes, but I would clarify that in respect of the second application, direct landscape impacts was not actually part of the reasons for refusal. So not a direct landscape, it was an indirect landscape impact on effectively adjoining landscape characters.
And that was the second scheme, increasing turbine heights from 133 to 149.5.
That's correct.
Actually 149.9.
That's correct.
Is that correct?
Yeah.
Yeah. And indirect effect, on which adjoining area?
It was the Upper Dale landscape character type.
So that's the valley going through Nithsdale at lower
correct.
level.
Yeah.
And clearly that concern would apply to any wind farm application within that area.
Well, where Glen Mucklock is cited, yes, but not necessarily in the entire Northwest Lowther unit.
No. I'm only asking you about, because I've covered Northwest Lowther unit, I'm asking you about the area to the south, out with the SPA, but between the SPA and the valley floor. So these considerations would apply to that area, that subsection of Northwest Lowther.
Yes, but obviously there has to be, it depends on the scale of the development that's put before us. Yes.
Scale and number and so on and so forth. But in general terms, can we agree that that would be a consideration, significant consideration for any application in that particular sub-area?
Yes, it's a clear constraint that any development proposal would have to take into account and try and mitigate.
And as a matter of fact, consent has not yet been issued because the Section 75 has not yet been signed for whatever reason.
That's the current position, yes.
And the resolution to approve was in February of this year, and we're now many months after that.
Yes.
Can we then look, please, at NLEI 29?
That's the Eskdale Muir exclusion zone. Mr. Innes, could you give the witness a copy of that?
Now, Mr. Robinson, this shows the Eskdale Muir nuclear test facility, or however it's properly called, I'm not sure, and the 50-kilometre zone round it.
That's correct.
And did you hear the evidence yesterday of Mr. Bell that in current circumstances the 50-kilometre zone is in fact, as things stand, an exclusion zone?
I heard Mr. Bell's evidence, yes.
and no exception or challenge was taken to that evidence. Is that correct?
That's correct.
And on the basis of that, does this disclose that a very, very substantial area of Dumfries and Galloway Council area would be excluded from the possibility of wind farm development as things are at the moment, as described by Mr. Bell?
That could well be the case, yes.
And are you aware that we have the advantage of having agreement with the MOD, whose nuclear facility it is, and have no objection from them?
That's correct, and there are also schemes that are located in closer proximity to that core, which has a similar situation.
So that insofar as any potential wind farm applications in the 50-kilometre zone is concerned, there would be a prohibition as a result of the Eskdale-Muir consideration.
It's a constraint, but it's by no means a given that the MOD would object to development proposals within the 50-kilometre. I mean, we've had a number of, particularly just west of Langham, there's a large cluster of wind turbine development which are located in closer proximity, which the MOD have not raised objections to.
And you heard the evidence of Mr. Bell yesterday, which was not challenged, that as things stand at the present time, there is an effective exclusion zone within the 50-kilometre because the budget has been used up. Now, that was not challenged. I thought...
With respect, I'm not sure that's entirely the case. I put, for instance, to Mr. Bell that Harryburn, which was closer, had no apparent issues with Eskdale-Muir. It was an entirely new issue from a learned friend in examination in chief, which was not forecast or in any sense in Mr. Bell's written evidence or his precognition. Didn't take objection to it at the time, but I do object to the line my learned friend is taking to now. If he wishes to spring new evidence on parties without any warning, he can't expect their full case to be prepared and ready immediately. I don't consider it to be particularly relevant, which is why I didn't ask for an adjournment. But I certainly consider it to be inappropriate to exclude this witness from answering questions by reference to presence or absence of cross-examination.
Sorry, Mr. Finlay, to confirm, are you saying you're objecting to any questioning along this exclusion zone?
No, I'm not objecting to questioning on the exclusion zone. What I am objecting to is the witness being his answers having to conform somehow or other to my presence or absence of cross-examination yesterday when the counsel was taken by surprise. I didn't object to that line at the time for the reasons I've indicated. But I'm very happy for the witness to answer questions on the exclusion zone, to give his evidence, but he should not feel constrained about the counsel's presence or absence of cross-examination yesterday, for the reasons I've just given.
I think that's fair. Mr. Steele.
Thank you, sir. Mr. Robinson, Mr. Bell gave evidence yesterday that there was, as things stand, an exclusion zone 50 kilometres around Eskdale-Muir. I think you heard that, and I certainly heard that. Now, if that evidence is correct, that has the effect of sterilising this entire area, large tracts of which are within Dumfries and Galloway, does it not? For wind farm development, obviously.
It would appear that may have an effect, yes.
And as a matter of fact, we have agreement with the MOD and no objection from them.
I believe that is the case, yes.
Do you think, in planning terms, it is an acceptable situation that a vast percentage of Dumfries and Galloway, for practical reasons to do with Eskdale-Muir, cannot be...
So this is a wholly new point, and if my own friend was going to make submissions on this point, it should have been forecast in his evidence. Mr. Robinson has not had the opportunity to consider the implications of this vast area that the Learning Friend is referring to, which is not just Dumfries and Galloway. One can see it extends almost to Edinburgh. If this was going to be a significant line of the Learning Friend's case, we should have had notice of it, in fairness. We haven't. So I do object now to this line of questioning.
Well, so I hadn't even finished the question.
Respect to my Learning Friend, he can make facetious points if he wants, but it was very clear where his question was going.
Sir, we laid evidence about it yesterday. As a matter of fact, the evidence given yesterday was not, as I understood it, challenged. It is clearly a material consideration that is before you, and Mr. Bell gave evidence about it. I'm afraid I don't see what the difficulty is. I would have thought that you have to know about this and the ministers have to know about it.
Well, evidently I do. I think the question here is to do with any constraints that might be on where wind farm development may or may not proceed in the area, and I think that is a fair question to ask in terms of what this exclusion zone means in terms of the application site.
Thanks, sir. Do we have agreement about what the exclusion zone means, Mr. Robinson? It means that, and I'm not interested in England or Edinburgh because you're not representing those areas, but so far as Dumfries and Galloway are concerned, vast parts of Dumfries and Galloway are embargoed for wind farm development. Is that the consequence of this, if Mr. Bell's evidence is correct?
That's correct, but it has been for a number of years. But that hasn't stopped wind energy development coming forward and indeed been supported in this area when available budget has been available.
Yes, but that's the point. So I think you do understand it's a question of budget, isn't it?
It is, which obviously as a council we are not in control of.
And the entire budget for Eskdalemuir has been used up, has it not?
I'm not aware of what the budget implications are. We do not pay any regard to it.
And if this be correct, this has the effect of having an embargo on wind farms over vast areas, but including in particular vast areas of the Lowther Hills, does it not?
That may be the case, yes.
Just look at the map, Mr. Robinson. Is that not factually accurate?
I have no reason to dispute that it is.
Does that in any way, do you think, support further our wind farm being consented when others elsewhere in the Lowther Hills appear to be embargoed for reasons we've discussed?
No, for the simple reason that that situation could change at any time. It's merely a budget situation that could change.
What evidence do you have to give us that that situation is going to change any time soon, Mr. Robinson? Or is that speculation?
I don't have any evidence, and I'm just merely acting upon what we heard yesterday.
Can we look, please, at Harrisburn decision? Again, I'd like to take this as briefly as we possibly can. And can we agree, firstly, that obviously each case must be determined on its own merits?
Agreed.
Secondly, insofar as the production of renewable energy is concerned, in broad terms, our output is about twice that of Harrisburn.
That's correct.
And therefore, in the balancing exercise in relation to renewable energy, we would or should enjoy about twice the support because we're producing about twice the amount of renewable energy.
The production of double that is because the scale of the proposal is double the size, so it's no coincidence that that is the case.
Well, that may be, but we would enjoy much greater policy support because our output is about twice that of Harrisburn.
No, that has to be balanced against the scale of the development. I mean, to put it in simple terms, the larger a wind farm, of course, it's going to have more megawatts.
Well, that, of course, is true, Mr. Robinson, but at the moment I'm merely asking you about the advantages of generation of renewable energy. Surely, if we generate twice as much, we gain much more support in that regard. That's not to say there might not be other things at the other side of the balancing exercise, but we enjoy much greater policy support, do we not?
It's clearly giving more or generating more renewable energy, so in that sense it would be concluded that it is generating more than that scheme was proposing.
And therefore we would have more policy support in that side of the balancing exercise, surely?
I don't entirely agree with that. As I say, it has to be balanced against the scale of the development.
We're coming on to other matters shortly, but on the positive side, we must enjoy more support, surely, than Harrisburn, whose output was half of ours. Surely.
It would be acknowledged that your scheme gives more output than that scheme, yes.
Thank you. And can we agree that in relation to Harrisburn, there were different landscape and visual issues in play? I'm hoping not to go into the detail of it, but there were different landscape and visual issues in play.
From what was discussed last week, it would appear that there are a number of similarities, but there are some differences as well.
And two of the main differences were the effects on the two glens at Glenconner Water and Elvin Water. I only ask you that as a matter of fact. I don't want to go into the detail.
Could you refer me to a paragraph number? Where
Yes, 3.127 under the heading Reporter's Conclusions.
Clearly that would be of relevance to the Harrisburn scheme, yes.
And clearly does not apply to our scheme.
I would appear not, no.
Thank you. Now, if I'd ask you to turn to the Chapter 4 Cultural Heritage at paragraph 4.11, can we agree 4.11. Can we agree that there were a significant number of SAM's Schedule Ancient Monuments that were to be affected to a greater or lesser extent, and a number of undesignated historic assets as well?
Judging by what's listed, yeah, that would appear to be the case, although I must say I don't know the detail of
No, and I'm not asking you about the detail.
I accept that's what's been listed there, yep.
In short, can we leave this decision on this basis, Mr. Robinson, that there were a significant number of issues that were rather different in relation to Harrisburn than those that apply in relation to our site?
In respect of cultural heritage, it would appear so, yes.
In addition, I think we just agreed in relation to the two glens, which were thought to be relevant and important. They've got no application to us, and were, if not determinative, very important at Harrisburn.
Yes, that would appear to be the case.
So I note it's 11 o'clock. It might be a useful place and appropriate. It's about...
Okay, how long do you think you still have in the
Well,
process?
I'd like to reassess matters over the break, and I'll give you an answer to that, sir, afterwards, but not a lot longer, I think.
Okay, on that basis, we'll take a 15-minute break just now. Mr. Robinson, you understand you're in Purda? Yes. Okay, 15 minutes, thank you.
Can we go, please, to your new local plan, policy IN2, wind energy, please? have that?
Yes, I do.
The Council will support wind energy proposals that are located, sited, etc., and the proposals will be assessed against the following considerations, plural, sorry. What is the first consideration that has to be assessed?
Renewable energy benefits.
Well, it says a little more than that, does it not? Does it not say the scale of contribution?
I'm happy to read that. Yeah, the scale of contribution to renewable energy generation targets, effect on greenhouse gas emissions and opportunities for energy storage.
Does that not mean, therefore, that if one scheme has a scale of contribution at twice as much as another scheme, it will enjoy at twice as much support in terms of your policy IN2?
I don't necessarily think that's the case. Scale has to be measured against something, yes.
Mr. Robinson, why would it not attract twice as much support if it has twice as much, the scale of contribution is twice as much? There may be other things to weigh against it in the balance, obviously, but surely that must be so.
Well, I suppose it depends what, where the term, whether it becomes a significant. Normally, decisions will say whether it's a useful or a valuable contribution, and that's really as far as it will go.
Yes, but I'm asking you about your new policy, which requires an assessment of the scale of contribution. Surely, Mr. Robinson, it is not difficult to accept that if the scale of contribution is twice as much as another proposal, that proposal, the first proposal, will enjoy twice as much support in that regard.
I'm not aware that it could mean that. That's the way you've interpreted it, and I'll accept that is a way that it could be interpreted.
Okay, thank you. And the next one, the next criteria is the net economic impact under the heading socio-economic benefits, including local and community benefits, employment and the like. That has to be assessed in the balance as well, does it not?
Yes, it does.
Can we also look, please, at the SPP? Document 6.1, CD 6.1, and at page 45. Paragraph 194.
So I have it in front of me.
And these are the policy principles that the planning system should seek to achieve. Is that correct?
That's correct, yes.
Could we look at the bottom two bullet points, please? The second bottom one being seeking benefits from biodiversity from new development where possible, restoration of habitats and the like. We can see for ourselves what it says. Is that not precisely what we are doing according to the evidence that we have led?
I'm aware that there was an outline conservation management plan, but I would say when the Council considers these Section 36 consultations, we only respond to matters within our remit, and given that we did not have a Council biodiversity officer when the FEI came in, we couldn't provide any comments on the change.
Does that mean, therefore, Mr. Robinson, for reasons you've explained, that you have attached no weight to the clear advantages of our conservation management plan?
I wouldn't say we've attached no weight because it was recognised at the beginning, but I would have thought that was, and I think I've mentioned it in my inquiry report for the socio-economics, that would be something for S&H to look at as part of their balancing duties.
Indeed, we'll ask S&H about it shortly, but does the Council not also have to weigh it in the balance? And
if we were the decision maker for this application, absolutely, yes.
Where do we see that weighed in the balance in your report or in your current evidence in relation to the advice that you're giving to the ministers through the reporter?
The committee report.
Right. Well, would you like
It's
to...
mentioned in the section 2 point... Hold on a second. I'd refer to, is it CD 3.34? We don't have a page number, sadly, but it's section 2.6. And it's the last paragraph, so it's effectively just above where section 2.7 starts. And there's reference to the Hen Harrier Conservation Management Plan there. Welcome it, but consider that implementation of such a plan would have a greater probability of success if it did not start with unnecessary negative impacts on the species, which are likely to result from the proposals as outlined above. And then there's the caveat beneath that then explains that the biodiversity officer wasn't imposed. So unfortunately, we could not provide any greater or any more comment on that.
Do you accept now, Mr. Robinson, having heard the detail of the evidence, that really doesn't properly explain the situation, nor does it attach proper weight to what is on offer? It may be because you didn't have the appropriate officer at the time, I don't know.
I don't accept that the appropriate weight wasn't given, but as I say, we couldn't give it any more consideration on its merit without that advice internally.
Right. Well, Mr. Robinson, I don't want to prolong the point, but it's pretty obvious that appropriate weight was not attached to it, maybe for the reason you've explained, that there was nobody there to assess it properly, but is that not a fair assessment?
I would say that it's not carried through into the reports because we didn't have, there was obviously concerns raised as to its merits at the beginning, and then that moved on. But I'm sure somewhere...
Can we leave it this way, that you accept it's not carried through into the report?
I'm just double checking that. I thought there was something on ecology. I'd accept that there's no reference to that in the actual content of the report.
Thank you. Right. Be that as it may, Mr. Robinson, do you now accept that in terms of the SPP, we would enjoy some support from the second bottom bullet point in light of the evidence that we have led?
I think it would be the case, yes.
Thank you. And insofar as the bottom bullet point, enjoying and learning about the natural environment, would we also, given the evidence we've led about the intentions for the officer, enjoy support in that regard as well?
Which officer is that, sorry?
The officer, Mr. Robinson, that we've offered to pay for, the Hen Harrier officer, who's going to tour schools and community centres and the likes to discuss the Hen Harrier problem as we led detailed evidence about that officer.
Okay, well, I'll accept that, yes.
So insofar as these two bullet points are concerned, we enjoy either support or very considerable support as a result of our proposals. Fair?
I'd accept that's fair,
Thank you. Climate change emergency. Is it correct that Dumfries and Galloway declared a climate change emergency on the 1st of July 2019?
Yes, it was following a full council meeting on the 27th of June, yes.
And is it therefore correct to understand that Dumfries and Galloway Full Council attach very considerable importance to tackling head-on the climate change emergency as they perceive it?
That's correct, yes.
And would consenting our scheme be one measure of assisting in addressing the declared emergency?
It would help, yes.
Thank you. And in terms of what was agreed at the meeting, was it declared that there should be an urgent review of all policy and practice across council directives and departments to identify ways in which we can move further and faster on carbon reduction measures? Was that one of the matters requiring implementation?
Which point, which of the 12-point plan, which
4.
one was that? Number 4. Yep, that was one of the 12 points, yes.
Would urgently approving our scheme be entirely consistent with that requirement?
It's premature to say at the minute because, and I would say that this hasn't been submitted as a core document, but I'm happy to answer the question. Point 10 actually states we will produce a climate change strategic action plan, which hasn't done yet because we're in the very early days, and that is to actually how that will incorporate the obligations under the climate change bill and effectively set out a strategy of how all these points were taken forward. So at this stage, it's premature to say that.
You're claiming a prematurity in the face of a declaration of emergency which requires urgent action. Is that the position, seriously, Mr. Robinson?
I'm saying it's premature at this stage because of all of these points that have been raised. There is a clear strategy to go forward as to how all of these will be taken forward.
Does not your full council require further and faster action on carbon reduction?
It does, yes.
Yeah. Would we assist with that if consent is given?
But also, well, the council also has priorities of protecting the environment as well. And on the same day, the council also approved Local Development Plan 2 for submission to Scottish ministers and accepted the reporter's finding, which has a wind energy policy in it.
I understand all of that, Mr. Robinson, and no doubt there'll be advantages or disadvantages. But if you can, could you consider this question again? If we are consented, would we assist on carbon reduction measures as required by full council to be addressed in double quick time?
Yes, it would contribute towards a low carbon economy in SPP, and I don't think we've disputed that in our recommendation.
And do you think claiming prematurity is consistent with the emergency declared by Dumfries and Galloway Full Council for urgent action?
My comment was taken in the context that there is still a process to go through in terms of how all of these action plans will be implemented.
So can I try, Mr. Robinson, to draw matters together? We have agreed that there is some capacity, to some extent, according to the various qualified landscape architects, for turbines of this type in the Lowthers.
No, because the document you've referred to is out of date. The current document, which is the capacity study, does not give any scope in the Lowther unit where the proposal is situated.
Well, is there a material...
But I accept that the comment that the document you referred to did.
Thank you. So can I just repeat the question? Insofar as the professional judgment of suitably qualified landscape architects is concerned, there was accepted to be some capacity in the Lowthers for wind turbines of approximately this height.
It would appear so, but as I say, but that did have a caveat with a significant constraint.
Yeah. I only asked you about some capacity. Are we in agreement about that? Obviously, there'll be detailed considerations. We've agreed that in the North West Lowthers, your council has objected on a whole raft, for a whole raft of reasons, including the effects on the SSSI and the SPA.
In respect to the Spango scheme, yes.
And your professional judgment of your department was to refuse a scheme out with the SPA, but within that North West Lowther area as well, for a raft of reasons, including landscape and visual.
Yes.
And on the basis of Mr. Bell's evidence, much of the rest, or perhaps the rest of the Lowthers, it will be embargoed as a result of the Estill-Muir issue.
At this moment in time, that would appear to be the case.
Would you accept, Mr. Robinson, that looked at on that basis, there may be some significant advantages in consenting our proposal in the circumstances in which we find ourselves at this moment in time?
No, because the MOD position could change at any moment. I don't think the MOD position gives any further weight to this proposal.
Well, 2 points, Mr. Robinson. Do you have any evidential basis for suggesting the MOD position could change?
No, but as I said in the past, it's been a long-standing constraint in this area, and then when budget has become available, we've had wind farm proposals come in the area. That it is just stating a fact that that could potentially change.
So, Mr. Robinson, drawing the matters together, as we sit here now, and without speculating as to the future, as we sit here now, is it not obvious that there would be significant advantages in consenting our scheme now to meet the climate change emergency and government policy in that regard?
In a general sense, this scheme could contribute towards the climate change emergency, yes.
Thank you. No further questions.
Thank you, Mr. Steele. Right. I want to pick up on this Estill-Muir point. So I just confirm with you, Mr. Robinson, policy LDP in LDP2 in 2 which you were taken to by Mr. Steele recently, I think it says further down, impact on aviation defence interests are one consideration. And does that include looking at the Estill-Muir safeguarding area?
It does, yes.
Right, could I take you to core document 7.38? That's the Hairsteins Extension Wind Farm report by my colleague, Mr. Little. And if you could look at Chapter 7, specifically paragraph 7.3 and 7.4.
Sorry, sir. What was it was document CD 7.38?
That's correct. Paragraph 7.3, 7.4.
Sorry, I didn't catch the paragraph number.
7.3 and 7.4. What I want to understand is, are you aware of this interim guidance that was produced by the Scottish Government in 2014 and what effect that has on the 50-kilometre exclusion zone?
I wasn't aware of it, no.
And in your reading of those paragraphs, it seems to me, reading that there's a requirement on wind farm operators to inform the MOD, but they've withdrawn their objection to certain schemes based on an interim guidance. Is that your reading of it?
That would appear to be the case, yes.
So is that a paragraph 7.3?
7.3 and 7.4.
Well, not for me to give evidence, but this,
I've asked the witness, and the witness is unsure. So for me, obviously we've adopted to take public inquiry proceedings for this particular inquiry under the 1989 Act, and I appreciate why we've done that. In normal circumstances, had we adopted other procedures, I would have said we should have further written submissions on this particular point. However, could this point to do with the Estill-Muir situation, particularly in light of what is reported in this inquiry report for another wind farm in the area, would it be acceptable for parties to look at this in closing?
I'm very happy to do that, sir. I just wonder if I could draw attention, though. It relates to applications prior to December 2013.
And that's my concern. I don't know what's happened post-2013, and we don't have evidence before this inquiry saying what the current situation is. So I would rather that was, if possible, addressed in closing.
Indeed, sir, although if you want more evidence on it, I think, Mr. Bell, I thought we'd taken enough evidence on this point yesterday, but we could possibly re-lead Mr. Bell on it, or if you prefer it in closing submissions. But it's a matter for you.
Yeah, Mr. Bell has explained the situation, but without the context of any evidence from the MOD or the Scottish Government in terms of its interim guidance and whether or not that still stands, what it means, hasn't been submitted as a document to the inquiry. So I would like, as you expressed earlier, ministers need to know what's happening in this area. It is a key point that you've put to witnesses. So I would like further information on it, and I'm asking, is it acceptable to do that through closing submissions?
I'm thinking aloud, sir. Yes to further information to you, obviously, but I wonder whether it should only be dealt with in closing submissions, or whether we might exchange something in writing to you within 7 or 14 days or something of that nature.
Well, Mr. Steele, if we take you back to the pre-examination meeting, you request an inquiry for all procedures.
Yes, indeed, absolutely.
So if you're happy with further written submissions on this particular topic, and the other parties are, then I can accept that. Mr. Finlay.
Well, this topic is growing arms and legs in the last 2 days of the inquiry. I'm certainly not happy dealing with it in closing submissions, because I won't see what the applicants have to say about it. It be entirely appropriate for there to be further written material on it from both sides, both as to the current policy position and the current practice position, and the experience of Dumfries and Galloway within its area. So I would support an exchange of further written material on it, and so that now we've had proper notice of the issue, we can provide you with proper evidence.
Yes, and I wonder, I think that is sensible, sir, because I take the point absolutely that Lowther would not know the detail of our position. But I wonder whether it's rather than written submissions, it's a matter of lodging another document for the inquiry in 14 days or something of that order.
So if there's to be further material evidence, and indeed I was going to request this in any event, it appears to us that this has been raised without notice in the last 2 days of the inquiry, maybe the last 3 days with the way we're going at the moment. We may well wish to put in further evidence on it so that the ministers have an accurate picture. But we would wish to put evidence in, so it's not simply a case of lodging a document. If you need accurate information, and I can understand why the issue hadn't been raised yesterday, then Dumfries and Galloway would like to assist with that, but we would need some time to do so to ensure that you have accurate and complete information.
Can I just clarify, when we're talking about additional information, additional evidence, is the suggestion that there should be more oral evidence on the matter or not?
And I'm perfectly happy to deal with it by written exchanges provided in the Low and Frienders for the reason you've just indicated. No need to reopen the inquiry session.
So that seems sensible. Obviously, I'd like to take some instructions about that and discuss that with the team. Perhaps we can revert to you after the next break, whenever that is. I don't think I can take a decision about that myself, but that does seem a sensible solution, and I can well understand why you have to get information about it, sir.
Okay, we'll return to that after lunch. Thank you. Now, Mr. Robinson, the decision to object by the committee, was that unanimous?
No, I think it was probably a 2/3 split, roughly. I don't have the figures to hand, but it was yeah, I would say roughly about a 2/3 split.
Okay, thank you. Now, for a point of clarification, the Dumfries and Galloway wind farm landscape capacity study, the draft one, the anticipation is that that will become supplementary guidance and therefore part of the development plan. Could just confirm it is both parts, the main report and the appendix, which have been put out for consultation, will be considered and adopted, well, approved by ministers during that 28-day period. Is that correct?
That's the intention. They were both published at the same time, yes.
Now, if we look at LDP2, policy NE2, regional scenic areas, I'll let you get that. Now, you'll notice the policy above NE1. Right, you have that? Yeah, policy NE1, national scenic areas. Comparing the two policies, NE1 and NE2, there doesn't appear to be an allowance within policy NE2 to balance or take account of the benefits that might outweigh any impacts like policy NE1. Is that correct? And can benefits not outweigh impacts to an RSA?
That would be that would appear to be the position that's written in the policy. I can't go into the detail of why that has been worded in that way, but your assumptions are correct. Yes.
Sorry, when you say my assumptions are correct, does that mean you agree that any benefits could outweigh the impacts to an RSA?
I would accept that. Yes.
Now, you recall Mr. Steele asked Dr. Wimble about the LDP spatial framework, and indeed you were asked about it today. And there's no dispute that the area is in a grouped area and shown in the LDP2 as an area without significant protection. Is that correct?
That's correct.
Is there any conflict, therefore, between what that spatial framework says and what is contained within the capacity study, both being parts of the development plan?
The capacity study, I'm just trying to load it up. Yeah, the capacity study doesn't include any sort of further spatial framework maps, if that's what the question is. It effectively just provides written guidance and on cumulative issues. So sorry, the question was...
Well, I'm trying to understand. Yeah. I think that your position is that the capacity study is not favourable to the application site, and yet the LDP2 spatial framework appears to show that it's an area without significant protection. I want to understand, is there a conflict between two parts of the development plan in that case?
I don't appear that I don't know. The spatial framework maps is pretty much been it's been drafted in accordance with SPP, and it can only let's just turn to the spatial frame. I'm just looking at SPP. It's listed in So effectively, the only things that we can map on the spatial framework maps within areas of significant protection are those listed in Group 2, such as World Heritage Sites, triple SIs, and so on and so forth. But in terms of the capacity study, it's looking at in more detail in terms of emerging patterns of wind farm development, also constraints in terms of the specific characters of those landscape. And in terms of this particular landscape character, one of the strategies is, I think as Dr. Wimble pointed out last week, there's very much a strategy of keeping free large-scale wind turbines from the more rugged hill ranges, the southern uplands. And then if you go to section 3.8, I think it's 3.8, it's got so part of a recommended landscape strategy, so protection of the most scenic of Dumfries and Galloway's landscapes by directing large, medium and small, medium wind turbine development away. That's the first criteria on page 45 of obviously part of the sites in regional scenic area. Also, the top bullet point on the page, top 46, strategy conserve the openness and unmodified nature of upland landscapes, such as the more dramatic and undeveloped southern uplands, and that includes the Lowther unit.
We just look at the bottom of policy in LDP 2. So it points to the spatial framework, map 8, which it says provides strategic guidance. And then it caveats, it says, however, it must be read in conjunction with the supplementary guidance in its appendix, the capacity study. And then it says the capacity study is a supportive study, consideration of which does not replace the need to assess the landscape and visual impacts of individual proposals. Now, I don't think that's in dispute, but the fact that it's called a supportive study, but it's also part of the development plan, does that give it any less weight, the fact it's being called a supportive study?
I think that's clarified what it is, but it doesn't give it any less weight because it still forms part of the development plan. So it has to be, you've got the spatial framework map, that's the starting point, and then we go into looking at the more detailed considerations, which is where supplementary guidance and the capacity study then comes into play.
Thank you, Mr. Robinson. That's all the questions that I have. Mr. Finlay.
Yes, sir. Can I just, Mr. Robinson, ask you to pick up on one of the last 2 points the reporter made. In respect to the SPP spatial framework and the WIN capacity study, did the LDP reporter consider there was any conflict or tension between the two?
No, there was no mention of that in the section use of the capacity study in paragraphs 52 to 60.
And then can we go back to policies NE1 and NE2, which are on, I think, page 51 of the current plan. I haven't had a chance to see whether these are recommended for, whether there are any recommended changes to these. Do you know if there are?
No, there wasn't.
Policy NE1 is worded in a negative sense, so that it, policy NE1 is saying that it should only be permitted where it will not adversely affect the integrity. So it's a clear development control policy. Policy NE2, first sentence simply requires respect to the special qualities and then limits the council's support in various circumstances. In terms of the regional scenic areas, the development control test that one can take from that is whether the siting and design respect special qualities of the area.
That's correct, yes.
Go back to the start of Malone Friend's cross-examination. He took you to NLEI 21, which is the June 2011 document. Now, I don't need, well, I want to go to it for one purpose in a moment, but since 2011, has the Council had further input from respective landscape architects, which has resulted in the current version of the WIN capacity study? And by current, I mean either 2017 or draft 2018, because we know there's no significant difference between the two.
I believe it's been produced by the same landscape architect.
So the same landscape architect. Great. If we go to NLEI 21, which is the full report, and go to page 141 in that, should be in Type 19 Southern Uplands, which includes the page 141. And if I could just ask you to read the first sentence under guidance on development, please.
There is no scope for the large development typology to be cited within this character type without incurring significant impacts on a number of key characteristics.
Do you consider that is a positive feature for the applicants or a negative feature?
I would say that's a negative feature.
Okay. What may be more helpful is to go to the up-to-date wind capacity study, and which I have a document number. I do. I think that is. I think it's part of CD 613. My apologies, no, it's CD 614. At least I hope it is. And if you can go to page for purposes of navigation, firstly page 339, which deals with rugged southern uplands areas, which is the area within which this site falls. And then turn over to page 340, which gives guidance on development. Is there the same guidance that you've just read out is reiterated?
Yes, in the first paragraph.
So we're looking at which document, albeit there's no difference between them, when the reporter is advising ministers, should the ministers have placed any weight on a 2011 document dealing with wind farm capacity within Dumfries and Galloway at all?
No.
Likewise, any LEI 22, which dealt with cumulative zones, which I think you said was based on work from 2011, should any weight be placed on that document?
No.
Go to the Spango decision, and we don't need to turn it up in detail. It was a resubmission, as I understand it.
That was correct, yes.
And presumably the wind farm applicant, who, unless he was desiring of tearing up money and throwing it away, felt that they had some case for developing within an SPA and a triple SI.
I can only assume that was the case, yes.
But in terms of the landscape and visual matters, I think Malone Friend put to you that any scheme would suffer from the same complaints that Spango Wind Farm would suffer for within that northwest Lowther area. The landscape and visual matters raised in the report, which you can see, but I can summarise, concerned lack of appropriate siting away from the Croik water. Would there be ample scope within that unit to achieve that if that had been desired?
Yes, there's a significant area to the north of that, yes.
Likewise, there was a complaint about absence of adequate setback from Nithsdale. Again, could that be achieved in that area?
Yes, that is correct.
And likewise, there was complaint about impact in the Southern Uplands Way. Again, if there had been set back further into that area, could that have been achieved?
Yes, it's likely that it could have been.
And there are impacts on all those three matters, impacts form part of the Dumfries and Galloway's concerns in this case. Absence of setback from Croit Water, absence of adequate setback from Nithsdale, and impact in the Southern Uplands Way.
Yes, that's correct.
Thank you. Glenn Marklock, just a point of information. A known friend made the point that the Section 75 has been outstanding for some time, but is there any particular reason why it hasn't been signed, and have you got any idea when it might be?
It's very much in a finalised stage. My understanding is that there is it's just reaching agreement as to whether a previous obligation dating to 2013 has been discharged, but upon finalising that, then that should be the matter concluded.
Eskdale Muir, what's your experience been of wind farm applications coming forward within the Dumfries and Galloway section of that so-called exclusion zone in the last year or two?
We've still been getting applications in that area. Little Hartfell, for example, is just west of Langham. That was submitted in the last year, much closer than this particular site. So there doesn't appear to have been a drop-off of any applications, and there's recently been a four-side application, which I think Mr. Bell referred to yesterday.
And just for absolute clarity, that's within the region itself, within the exclusion zone?
Yes.
Are you aware whether the MOD has objected to those applications?
I'm not aware of the situation with Forside, but they didn't object to the Little Hartfell application, which was recently recommended for approval.
Dumfries and Galloway's climate change emergency, is there any suggestion there should be a change to the protection to be afforded to the environment as a result of its decision to declare an emergency?
Not that I can see in the points, no.
You were asked about scale of contribution. This is a commercial scale wind farm. In terms of and clearly one that's over 50 megawatts, otherwise we wouldn't be in this form of procedure. I think Below and Friend was suggesting to you that the scale of support would depend arithmetically in comparison with the number of megawatts that was produced. So a 168 megawatt wind farm would not have quite as much support as a 169 megawatt turbine wind farm, megawatt wind farm. Do you consider that that's a sensible way to look at matters?
No, I think it has to be assessed in the round with all the other considerations.
Thank you very much, Mr. Robinson. I have no further questions.
Thank you, Mr. Robertson. Now, Mr. Godfrey, I think we'll take your evidence just now. Thank you. So just a minute for you to get comfortable in the witness table. process now. Is it your intention to read out sections of your recognition?
Yes, I want to read some sections, but not all.
Okay. If you'd like to proceed, thank you.
I'll start at paragraph 3.7 relating to the intermittent nature of renewables. In my inquiry report, I illustrate this with two sets of data showing wind power output within the UK for 2 summer days with contrasting weather conditions. One with little wind, where wind power only generated 0.05 gigawatts, which met approximately 0.2% of UK energy demand, and one where the wind blew strongly. In the latter case, wind power provided the grid with 10.6 gigawatt of electricity, which was 35% of the UK grid supply. So that there's quite a significant difference there between low output from wind renewables and high output when wind is blowing strongly. One of the means of measuring the efficiency of electrical generation plant is the concept of the load factor. This is a calculation which compares actual output with the design output of generating plant. Because of the variability of wind, the average load factor for onshore wind is around 28%. In other words, over a period of time, wind turbines are only able to generate between a quarter and a third of their design capacity. Moving on to security of electrical energy supply. 3.9. We feel that an increasing reliance on wind power and the phasing out of conventional thermal and nuclear power stations will create a vulnerability in the supply of energy in both the Scottish and the UK context. In order to satisfy conventional energy demand, conventional gas-fired stations have to be brought on stream to supplement nuclear power or energy imported from Scotland. I was just looking at things in the Scottish context there. Oh, so did I say energy imported from Scotland? Energy imported from England, sorry. 310. In paragraph 313 of our inquiry report, I'll skip that one. 311. The huge variation in wind power output highlights the need for substantial investment in more reliable and predictable low-carbon methods of generation, such as nuclear power or other forms of renewables, including barrages incorporating tidal power stations. These could be supplemented by energy storage mechanisms. However, given that it is Scottish Government policy not to replace the ageing nuclear power stations, then in the future there is a substantial risk of an energy deficit. Since electrical generation from other forms of renewables also exhibit considerable swings in output relating to weather conditions or the phase of the moon, it is doubtful that many renewable types of generation could be relied on to provide a consistent supply of electricity. Our inquiry report described the vulnerability of the electrical supply network and quoted a paper published by the National Grid entitled The Security of Energy Supply in Scotland. That was published in 2015. And that included a paragraph describing the vulnerability of Scotland owing to its increased reliance on wind-generated energy. That paper was quoted in our inquiry report. Paragraph 312. It is our contention that the Scottish Government's policy of placing disproportionate reliance on wind power is consistent with the Scottish Government's policy articulated in the 2017 Scottish Energy Strategy, which states within the section entitled System Security and Flexibility that, quote, Scotland needs a balanced and secure electricity supply. That means a system and a range of technologies which provide sufficient generation and interconnection to meet demand. It means an electricity network which is resilient and sufficiently secure against any fluctuations and interruptions of supply. It continues, quote again, for example, efficient and flexible gas-fired generation is a natural complement to a high renewables future, especially when fitted with carbon capture technology. Gas-fired generation can be scheduled and controlled, meaning that it can be instructed to power up or down, depending on rising or falling demand. It provides inertia, helping to maintain a stable frequency across the network and increases its resilience. The Scottish Government policy thus explicitly recognises the limitations of wind power in ensuring a reliable and consistent means of providing electricity over a range of weather conditions. Basically, what it's saying is that you can't put all your energy eggs into one basket. And this is recognised by the Scottish Government. And this is included in a core policy document issued by the Scottish Government. Moving on to constraint payments. I'm getting near the end now, Mr. Edwards, is what I want to read out. Paragraph 313. In my inquiry report, I describe the nature of and the reasons for payments being made to generators to increase generation or to reduce output in order to balance the supply of electricity with demand. I showed that there had been a huge increase in constraint payments made to wind generators to shut down particular wind farms because of overcapacity or transmission bottlenecks. I show within my inquiry report that during 2018, payments totalling £125 million were made to wind farm operators in the UK to shut down their facilities. The majority of these payments, that's 115 million, were made in respect of facilities operating in Scotland. Data showed that during September 2018, the operators of the Clyde Valley and Clyde Valley extension wind farms received constraint payments totalling £3.8 million. This figure represented almost 13.5% of all UK wind farm constraint payments to onshore and offshore wind farms made during the month. It is estimated that 12% of all UK wind farm constraint payments were made to the Clyde Valley operators, totalling approximately £15 million. We note that the applicant has received a commitment for a connection to the national grid at the Elvenfoot substation. This substation is located on the main interconnector between England and Scotland. The Clyde Valley wind farms distribute the power they produce via this interconnector. It is our assertion that If the North Lowther scheme was to be approved, this would put further pressure on the capacity of the interconnector and would be likely to result in the North Lowther operator receiving constraint payments of considerable magnitude paid by electricity consumers. Should the North Lowther scheme be approved and become operational, then because of the limited export grid capacity, it would be likely to be constrained off in periods of peak generation or force other wind installations to be constrained off. Such a situation would result in no net saving of emissions of CO2 and thus no contribution towards climate change objectives. This situation would be exacerbated should Harryburn, well, I'll just leave that bit. That's okay. I'll finish there, if I may, Mr. Edwards. I'll leave the policy elements because they've been dealt with already by, or the main policy elements relating to planning have been dealt with by the council's witness.
Okay, thank you. Deferring to the council's witness in terms of their policy position. Okay. Is there any clarifications from this side of the table to Mr. Godfrey? No, in that case, Mr. Steele.
Thanks, sir. Mr. Godfrey, at one point of detail, at 312 of your precognition.
3 what, sorry?
312.
312.
Second line.
Yes.
You read out consistent. Unless you've had a change of heart, I assume that was an error.
Did I say consistent? I'm afraid it was
I assumed.
Right. An error on my part. I just misread.
So you're still maintaining your position that it's inconsistent, I assume?
Yes, indeed.
So in short, Mr. Godfrey, you are critical of the government's policy in relation to wind power.
No, I'm saying that the government's energy policy has got to be taken in the round.
Well, that may be, but we both know, or perhaps we should just look for completeness at the evidence of Mr. Bell, if we need to. You've heard his evidence in relation to government policy and the support for onshore wind farms, have you not?
I have indeed, yes.
And do you accept what he said at the various pages of his inquiry report? Well, I can get it for you if needs be, but you've no doubt read it and considered it. Do you agree or disagree with that?
It's not immediately fresh in my mind, and so I don't want to comment until I've just refreshed my mind.
Can you
I think I do have a copy of it over there, but
we can give you one more quickly, NLEI 8. I'll not give you mine because it contains many scribbles.
Which particular section?
Starts at page 9, dealing with the renewable energy policy framework and an update on it, through to page 17.
Sorry, there's a lot there for me to take in and comment upon off the cuff without sort of giving it a little more consideration.
Well, Mr. Godfrey, I assume that you've read all of that before in preparation for the inquiry.
Yes, indeed.
Was there anything at that time that struck you that you significantly disagreed with? What I'm really trying to establish is whether you are critical of government policy as set out there by Mr. Bell, or whether you accept it.
I accept that there is a strong element of support for wind farms within government policy.
And do you also accept that the targets that you set out are not to be regarded as caps beyond which one doesn't go? They are targets that should not be missed. Do you accept that?
I accept that there is no cap on the 2020 target.
Thank you. And so far as constraints payments are concerned, you've given evidence about that, but do you now realise that that was due to technical faults, or largely due to technical faults with the interconnector, as Mr Bell outlined yesterday or the day before, recently in any event?
It's not solely due to technical faults. It's a question of how the electricity is distributed in relation to meeting demand.
I accept that. I think I hope I used the word largely. That the spike in payments, constraint payments, was largely due to the technical faults with the interconnector.
Not only with the interconnector, there was the second, the Western interconnector that was referred to in evidence earlier. The grid, we're trying a new technical solution, because what happens is electricity doesn't travel long distances very well. You get a drop in loss of power, and so they tried with this new Western interconnector between Hunterston and Deeside. They've tried a new technical solution. It's a direct current powered interconnector, and they're having all sorts of trouble with it, so that there's a combination of technical problems.
Okay, well, you've rather lost me, Mr Godfrey, but that doesn't matter. Can we agree that there were a series of technical problems with an interconnector, or interconnectors plural, which caused the spike in constraint payments? Is that not a fair summary?
It did make a large contribution towards those, towards the spike in constraint payments.
And you are not here to challenge government policy. You accept government policy in relation to its support for renewables. Is that so?
Yes, indeed. I mean, we as a community have no objection to renewables per se. It's just that we feel that the North Lowther site is an inappropriate site.
Well, to put it another way, you don't want it in your own backyard. Is that about it?
It's not a question of only of NIMBYism. I mean, one of my stepdaughters came over from Australia, and she was absolutely shocked by the impact of turbines or wind farms generally that have appeared and are due to appear in this area.
And insofar as other policy matters are concerned, you're content to rely on the evidence of Dumfries and Galloway Council?
Yes, that is true. I feel that the Council's expert witness is more in touch with, obviously, the details of planning policy than indeed I am.
Right, thank you. No further questions. Thank you.
Thank you, Mr Godfrey. You've actually asked the questions that I had through cross-examination. So unless there's any questions through re-examination, Ms Richford? No. Thank you, Mr Godfrey. Now, that's the end of the policy inquiry session. We're going to move on now to the S&H internal procedures inquiry policy. Now, my understanding is the order of witnesses will be Mr Welch, followed by Mr Bell.
Indeed, sir.
And so, my question to parties is, should we break now for lunch, or would you like to get a witness through?
Well, sir, with a view to hoping to finish the evidence today, I think we would probably prefer to get on with Mr Welsh just now. That might have the advantage that he could explain the plan as well, and it may be that we then break for lunch if needs be. If my learned friend needs some time to consider the plan, it's pretty straightforward, but that might assist if he were to explain it in evidence in chief.
Well, I'm not sure I want him to explain it if it hasn't been accepted. Is there any movement, Mr. Finlay, in terms of accepting that plan?
So can I'm from what I recall of it, I'm happy to have it in, but if we, I'm not necessarily accepting it's accurate at this stage, but I see no reason not to have it in.
Okay, on that basis, Mr. Welsh, if you'd like to come to the witness table. Thank you, Mr. Godfrey.
So it may just take a few minutes to switch witnesses over.
I am. Thank you, sir.
Thanks, sir. Mr. Welsh, good afternoon and welcome back. Could we go, please, to your main original inquiry report and the section dealing with SNH in that, and can you just tell us which page and paragraph you wish to take us to?
Yes, I refer to the Freedom of Information request from paragraph 914 on page 57, which follows my review of the SNH consultation response.
Now, you've got several pages dealing with the SNH matter and the Freedom of Information request. It may not be necessary to read all of that, Mr. Welsh, but are there particular paragraphs that you would wish to draw our attention to?
Thank you. If I just quickly work my way through it.
I think then I'll have one or two additional questions.
Open feels it necessary to comment on some aspects of the officer advice contained in the memos that sit behind the ultimate letters of objection, as some of the language used in presentation of advice provides an insight as to how the objection has been framed. As some of the language used in presentation of advice provides an insight as to how the objection has been framed, which is of concern to Open from a professional standpoint. SNH's consideration of the project begins with an email to the Local Energy and Consents Department dated 18th of December 2015, commenting on a draft meeting note prepared by the LEC. Paul Taylor, the SNH casework advisor, was Renewable Energy Casework Advisor West at the time. The email notes that at that stage, SNH had not given any advice related to landscape, but had discussed the potential for a landscape-specific meeting with the applicant during spring 2016. I will jump through 917 to 919. A second file note follows, also produced by the SNH casework advisor, of the pre-application landscape-specific meeting held with the applicant on 24th of March 2016. The note sets out a range of issues that SNH advised the applicant may need to be considered in the LVIA, and further highlights SNH's interpretation of the Dumfries and Galloway Council capacity study at that time. It is evident from the note that SNH had concern about the area as one that is currently wind farm free. And I quote there, which I won't read out. But it does include reference to the association of wind farms with more forested areas of the southern uplands. 921, it's notable that over half the North Lowther site is located in a more afforested area of the southern uplands, so that it reflects the existing pattern that SNH refers to. It is unclear what strategy lies behind SNH's, inverted commas, regional strategic pattern of development, inverted commas, that was emerging at this stage. A further landscape meeting was held on the 17th of October 2016 in Edinburgh, at which Fraser McNaughton, SNH landscape architect, was present. SNH advised that we have previously commented on the value of the landscape. Its character does differ and is valued as expressed previously, e.g. in terms of cultural, recreational, incised valleys, highest settlements in Scotland, etc. So we are in disagreement about the ability to accommodate in this landscape and wouldn't want to be misrepresented in this respect. This is a challenging site in terms of the impact on these hills and the strategic cumulative picture. No clarification is provided as to what is strategic about the cumulative picture. With particular reference to the former mining villages of Wanlock Head and Lead Hills, Fraser McNaughton also noted that there is an overlap in terms of how cultural heritage relates to landscape character, local identity and sense of place. The landscape is defined in part by cultural heritage and identity. The juxtaposition of the cultural and natural heritage makes this place unique. Open considers that almost all landscapes in Scotland are defined by cultural heritage and identity, which is also understood to be the purpose behind SNH's The Landscapes of Scotland map. All 79 units are distinct or unique, and cultural heritage has played a significant role in shaping them. Paragraph 924, I note that the casework advisor noted that the possibility that SNH would object, but that there was more internal consideration required. 925, it was helpful for the applicant to understand SNH's position at an early stage, and some confidence was derived from the knowledge that more internal SNH consideration was required in terms of analysis and internal processes to provide justification behind any subsequent decision to object.
So I'm concerned that if we're just reading out the report as to, I only raise that, it's obviously for my own friend Harry wishes to introduce his case, but Mr. Half-Hyde has to be dealt with today if possible. I know my own friend is keen to finish everyone today. But certainly for my part, there's no need for Mr. Welsh to read out excerpts from documents. We've all had the opportunity to read it. But I simply hope that's helpful in speeding matters along.
Well, I'm certainly happy to take things as read. Mr. Steele?
Sir, I indicated to the witness that there was no need to read it all out, and I think we're trying to be a bit selective, but at the same time give a flavour, not just for our benefit, but for the members of the public and those listening online, so to speak, just exactly the conduct of SNH that there has been. So there's a bit more to it than that, but obviously we don't want to waste time.
No, well, Mr. Welch has some particular paragraphs that you want to read or indicate. Obviously, those you've indicated it's your inquiry report that you're reading from, document NLEI3, and so anyone watching online can open that document. There'll be a link to it, and they can go through these paragraphs as they wish. But I'll let you continue selecting parts you'd like to read out.
Thank you, sir. I'll refer you to paragraph 927, where prior to the SNH's draft landscape advice, the officer sent an undated file note to colleagues setting down a layperson's view on the landscape and visual effects, and in a surprisingly informal manner preceded the advice with the caveat, having been on all these recent site visits and picked up on the various chat, here are a few thoughts on what might some main issues, obviously noting that I'm offering a layperson's perspective in a fairly quick, non-LVIA jumbled way. The language then continued in a fairly informal way through subsequent responses detailed in 928, 929, before going on to discuss the key issues.
Perhaps you might read at 9:30, however, and give us your comments on that, Mr. Will.
9:30, the officer reveals that we talked about how to define the Lowther Hills and the tighter geographical area being affected. Nick sent an email the other day highlighting that Wikipedia offers a description of the Lowther Hills, and this might be a good starting point. And the webpage talks about a roughly rhomboidal shape which runs along the Croik Water to Crawfordjohn in the north, bounded by Nithsdale and the M74 to the west and east, and then the Forest of A to the south. I have assumed there that Nick is Nick Halfide, Director of Operations for SNH.
Well, we'll hear, no doubt, confirmation of that later, but what do you think of a starting point, Mr. Welsh?
I don't consider Wikipedia is necessarily the be-all and end-all in terms of accuracy, but actually the area identified on that first map does include what I would regard to be all of the Lowther Hills in terms of the boundary, albeit it may extend a little bit further west across the B740, sorry, in the north, across the B740. 932 records that the caseworker set out his initial views on the likely effects of the proposed development, noting that from the Green Lowther, Lowther Hill and East Lowther range, a walker would overlook the schemes and get an eyeful. In my view, this is hardly an objective and impartial framing of a professional assessment. And I go on to say in 933 that I sense a search for a basis against which an objection could be arrived at, and I've quoted from that there. Rather than assessing these effects of the developments in a methodical way, it suggests a counter-approach whereby the hole is fitted to the peg. And the officer draws further from the Director of Operations advice. Nick suggested that if it could be argued that the core of such an area was affected, then the case of regional distinctiveness could potentially be made. 936, this suggests to me contrivance to find a solution which fits a preconceived idea around impact. It does not suggest a thorough and methodical review of the likely effects upon which a balanced judgment can be arrived at, but indicates that having formed an early opinion of dislike for the project, an appropriate device needs to be found to support that gut reaction. The theme continues through other sections of that response, including reference to Harryburn and the villages of Lead Hills and One-Lock Head, and the suggestion that if they were both recognised for their distinctive contribution, then it becomes more difficult for proponents to downplay the impacts on setting of the pairing. Mennick Pass, surprisingly bad impacts were identified. Now, I acknowledge that that's in respect of the original scheme, pre-FEI. Then I go on to talk in 939 about the regional distinctiveness and context map, which I provided my evidence on last week. 940, I don't regard there to be any justification for the area indicated on the map as being described as the core of the Lowther's unit. It avoids the most elevated and impressive parts of the Lowther's unit landform, other than Green Lowther, which lie to the south of the Dalveen Pass. And fundamentally, as I said last week, it excludes the Dalveen Pass itself, which I regard to be one of the most iconic parts of Parcel 74. I 941, I refer to an email from Nick Halfide to the casework officer suggesting changes to the draft landscape advice, which to me reads as an attempt to bolster the objection and remove any sense of doubt from the draft advice. And I set out in 942 my concern that SNH has sought to articulate an argument against the project rather than undertaking a systematic, balanced and objective assessment of the evidence presented in the ES. And I go on to cite some further examples, but I think that's probably a fair overview of it.
Now, can I also ask you now to turn to look at the plan, which is NLEI 30, Mr. Welsh. And you have undertaken an overlay, as I understand it, correct me if I'm wrong, of the core area as identified by SNH and the reality of the situation. Is that so? Perhaps you just explain this to us.
Yes, it is quite a complicated map because we've taken the map I just referred to in my report showing the core area of regional distinctiveness, and we've overlaid three things. We've overlaid, firstly...
Just before you do that, the two almost parallel purple lines and the NLEI site and the original RSA, as suggested by SNH, are shown there. Is that so?
That is correct.
The NLEI site is yellow and almost a circle. The two purple lines parallel represent the extent of the core area, and the green was said by SNH, the green dashed line was said to be the RSA. Is that correct?
That is correct.
Could you just explain, please, what is the truth of the matter?
We have overlaid in red dots the NLEI turbine positions. Helpfully, the SNH base has grid squares on it, so we've been able to do this with a certain degree of accuracy. We've also overlaid in thinner purple the boundary of the Thornhill Uplands Regional Scenic Area, and we've also put on there the boundary of the SPA to the northwest of NLEI. Following discussion around it last week, we thought that would be helpful.
Firstly, can I just ask you to please to comment on the consistency with the SNH suggested boundary from the RSA with the one that you say that there is. The SNH boundary was dotted green, and yours is in a purple colour. Are they the same?
Sorry, we heard this last week. I have it in my note. I don't think this is going to take us any further forward. I understand your position in terms of...
Right, sir, I'm not sure that we ourselves understood the difference, the extent of the difference between the RSA last week.
Okay.
We had the number of turbines within the RSA and the number of turbines outside. I think the position was fairly clearly examined last week.
Well, my understanding of the question was actually where SNH had drawn the boundary and where the actual boundary is. And I have an answer to that from last week.
If you do, sir, that's absolutely fine, but I'm bound to say that I certainly, and I don't think we understood the extent of the error last week until we've overlaid it. That's why I was keen to bring that out. But if you're content, I'm relaxed about moving on. But I think there is a much more significant difference, and certainly we understood that.
If you're going to draw out another issue, that's fine. You can continue.
Thank you. I think we are, Mr. Welsh. Could you just confirm, please, whether the extent of the difference between the RSA boundary indicated by SNH and the one that you say is the reality?
I think, sir, the difference from our discussion last week is that we didn't talk about the southern boundary of the RSA, and you can see from the overlay that the RSA drawn on the SNH map represents a considerably smaller area than the actual limits of the RSA, which extends further south to Old Girth, as the purple line shows there.
For the south and west, I think, is that
and west, that's correct.
Is there any comparison to be drawn between the two, or are they just fundamentally different?
They are fundamentally different, with exception of the northeastern boundary, which runs along the county boundary between D&G and South Lanarkshire.
And what is your professional judgment about the effects of these errors, Mr. Welsh?
In my view, it erroneously represents the location of the NLEI site relative to the core area of distinctiveness. It represents the location of NLEI incorrectly to the boundary of the RSA, and it also suggests that the RSA relates to a much smaller parcel of landscape than it actually does.
And is there any importance in the fact that it was suggested that the RSA was much smaller than the reality of the situation? What's the effect of that?
I think for somebody using the map who did not know, who is none the wiser, it could suggest that the project was affecting a relatively small designated area.
And might that affect judgments as to the effect on the area than an area, an RSA that was actually bigger?
It might be interpreted that way by somebody.
You've looked at this. Can you understand how this could have come about? Is there any logical explanation for this error or these series of errors?
I don't understand how somebody could have drawn the RSA boundary so wrongly. Clearly, the heavy purple lines representing the core are entirely subjective, and I don't agree with those. But I think, given the importance of this figure to the S&H process, more care should have been taken to accurately position the development and the designations that pertain to it.
What consequences, if any, do you see follow from a professional point of view in relation to the errors in this map?
It's not a plan that should be relied upon, as it is, in my opinion, clearly misleading.
Now, do you have any other concerns or thoughts to express in relation to the S&H process procedures, Mr. Welsh?
Another concern that came to me over the weekend was in reading the chronology that was supplied on Friday, I believe, or maybe Monday. It very clearly documents the fact that the balancing duties were undertaken after the objection to the application, the original objection to the application had been submitted. And yet, when you look at the application of balancing duties form, the proforma that's been filled in, it suggests very clearly at the end that it should feed into the decision rather than come after it, and that is another aspect which gives me cause for some concern.
And was that not clear to you until you got the chronology forwarded to us over the weekend? Monday, I can't remember.
It became clearer to me upon seeing that chronology.
Now, Mr. Welsh, you've appeared at many wind farm inquiries, some involving S&H and some not. Have you ever come across this sort of situation before?
I'm sorry to say that I think that there are aspects of this process that I am really quite surprised by as a chartered landscape architect, and I have a great deal of respect for the work S&H does, but I am not, the process that I've seen unravel here gives me fairly limited confidence that this has been carried out with a high level of objectivity.
Fine. Thank you, Mr. Welsh. No further questions at this stage.
Mr. Finlay.
Mr. Welsh, do you have the chronology DS17 before you? You've criticised two documents in particular, and you accept that they're not written by landscape professionals. That's Mr. Taylor's note, which is you criticised at some length. That's I think pages 15 to 19 of the FOI bundle, dated 25th July, and then the email from Nick Halfhide that you drew attention to.
I accept that they are neither landscape architects.
Now, if we look at the involvement of landscape architects in this drawing, we can, for this stage, glance over the first page because that was involved with pre-scoping advice. But we see that the landscape architects, there were two main ones involved, Fraser McNaughton and Fiona O'Mahony. And you'll see that prior to reaching, Fraser McNaughton raised issues in terms of objection in 2016, and having carried out a site visit, but I'm not too interested in that. It's really Fiona O'Mahony who wrote the report. She spent, according to this, a week preparing for site visits and then 3 days of site visits. Would that be sufficient for a qualified landscape architect to carry out a thorough appreciation of the site?
Yes, I'm not critical of that factor.
And she then produced a draft report and then a final report, again, which you have not criticised the wording of. That's correct, isn't it?
That is correct.
And she also produced a detailed viewpoint assessment on the considering the changes, the removal of the Mennock Pass turbines, if I can call them that. And again, you haven't criticised that, have you?
I haven't criticised that. I've criticised the process that led to the respective objections.
Well, sorry to interrupt you. Are these all submitted as core documents? I know you're going through this quickly.
Yes, they are. The letter, the draft is. Let me just find that for you, sir.
It's the two reports you've mentioned from Fiona O'Mahony.
Yes.
And the detailed viewpoint assessment I'm interested in.
The Fiona's draft advice is at 36 to 43 in the bundle, and then she then produced the final letter that Mr. Halfhide or someone else signed off, which was the letter of objection. And then there is her redrafting of the landscape advice is at page 52 to 55 of the bundle, and then review of the FEI material is at pages 61 to 71 of the bundle. Now, you weren't at any of the meetings concerned, whereas Mr. Van Grieken was at some of them.
I was not at any of them.
Could we take up your report? And go firstly to 922. You make a comment at the end of 922, no clarification is provided as to what is strategic about the cumulative picture. Now, that was a... do you know whether Mr. Van Grieken or anyone else on the applicant's behalf asked for that clarification at the time?
I don't know that.
And if they had wanted to, if they did ask, do you know whether anyone refused to answer?
It's hypothetical. I don't know. I can't answer that.
So what's the purpose of this criticism here? If you weren't at the meeting and you're just simply criticising a note, was that a relevant issue at the time?
I think it's a relevant issue because the strategic cumulative picture is something that forms a thread through various of the responses in the FOI documentation, linking back also to or cross-referencing South Lanarkshire's views on it too.
Absolutely. I'm not suggesting it's...
But nobody spells out in any of that correspondence what is meant by the strategic cumulative picture.
But if there had been concern about that, or that hadn't been covered in the meeting at which Mr. Van Grieken was present, and we can see he's present because if you look at page 10 of 8.27, that's the 17th of October. It's only, that just shows you that Mr. Van Grieken was there. This is just a file note of that meeting. It's not a full verbatim note. If he'd been concerned as to what that was, he could have asked.
I wasn't at the meeting. I don't know what was discussed. I'm reading all of the paperwork that's been produced relating to the case.
Have you asked Mr. Van Grieken about it?
We have both discussed this reference to a strategic picture, and we can't find it set down in policy, any indication of what is strategic about the cumulative picture here.
Well, I'm not going to go back into the debate on our evidence, Mr. Welsh, but have you asked Mr Van Grieken whether he asked for clarification at the time, and if not, why not?
I have not asked him, but I am clear that he is bemused, as I am, as to what is strategic about the cumulative pattern of development.
He may be, and you no doubt still bemused, but Dr Wimble explained that last week, and I'm not going to go over that. But if you didn't ask Mr Van Grieken whether he asked, and if so, whether he was given an answer, how can you sustain that as a criticism now, if you're purporting to be fair?
I'm very happy to amend that wording to say no clarification is provided in this note.
Well, you put it in there to be critical, Mr Welsh, and that was unfair, wasn't it? Would you accept that?
I don't think it is unfair. Here is a note which is setting out what in SNH's view is problematic about the development. And it's a fairly sweeping statement to say it's counter to the strategic cumulative picture.
Well, it is, but it's their note. It's their note of a meeting that took place. Why is it fair to criticise that note if it doesn't reflect, if the criticism doesn't reflect a real issue at the time? You're not suggesting that your side were misled by the note, or when they got a copy of the note, did they ever get a copy of the note?
I think my statement is fairly simplistic. I've said no clarification is provided.
Then let's move on to 927. You note that this is Mr Taylor's note. You note he's not a chartered landscape. Is there any particular reason why, for instance, a non-qualified person cannot express himself in informal language? Just because he expresses himself in informal language doesn't mean he's ceasing to be objective, does it? The question, just to remind you, is just because he expresses himself in informal language is no indication he's not being objective.
I don't doubt that he was endeavouring to be objective, but I think it is very informal language being used in relation to a pretty serious development.
Yes, but he's not the landscape architect.
The witness have not finished the answer.
I think it's pretty informal language to see used in relation to a very significant development in Dumfries and Galloway, and I would have expected, if the officer was unclear or had doubts about landscape and visual, to consult one of the three landscape architects that's referred to in the FOI material.
Well, firstly, for instance, if you turn to 938, one of the informalities of language was that the Mennick Pass had surprisingly bad impacts. That's not only objective, but accurate. Would you not agree?
But bad is a subjective word.
Yes, but it did have bad impacts. We know Mr Van Grieken advised that it be taken out before the application was even put in, and that subsequently they were removed because of their bad impacts.
Well, there were significant effects.
Yeah, significant adverse effects, Mr Welsh. Can you not agree, can you not be sufficiently fair to agree that surprisingly bad impacts is an informal way of expressing exactly the situation at the Mennick Pass?
I'm comfortable that somebody with informal training could interpret it that way, but that's not the only language. You've picked probably the most moderated language, but it goes on to talk about getting an eyeful and.
Mr Welsh, would you answer the question rather than being argumentative?
Sir,
I think the witness, respect,
please,
Mr
please.
Steele.
The witness had answered it and was going on to make a qualification, as he's perfectly entitled to do, as you said to me on more than one occasion.
I'll come on to Eiffel in a second. The question was, Mr Welsh, do you not accept that it's unfair to criticise a non-professional witness for language such as surprisingly bad impacts when that is not only objective, but your side is accepted in reality?
I accept that somebody without formal training might use language of that nature, but it's a subjective interpretation of what that person considers those effects would be. I don't think I would have read those words in a response from Fraser McNaughton.
Of course you wouldn't, Mr. Welsh. Now, answer the question. Is it fair to criticise a non-professional person for using that language? When it has proved to be correct and accepted by the applicant's side.
I regard the officer to be a professional person. I think if you're equating it to a member of the public, I'm surprised to see that type of language used in SNH evaluation. But there are significant adverse effects, so I accept that's what he was saying in his own terms.
Mr. Welsh, that's a very helpful answer, because it's not an SNH evaluation. The officer makes it clear it's not an SNH evaluation. You've reiterated what he put at the outset of it. It's a jumble of thoughts picked up from a site visit intended to assist those who are carrying out the valuation, which are the landscape architects, in helping them provide their advice. It's not an evaluation itself. Clearly isn't, is it?
It played a part in the evaluation of the project undertaken by SNH.
Welsh, it's clearly not an evaluation. Can you not answer a simple question?
I think parts of it are an evaluation. The preceding paragraph discussing...
Sorry, I didn't mean to cut you off.
Discussing the connect between the villages. There is a great deal of evaluation in this particular email report.
Yeah. As he's explained, he's picked up comments made by the landscape architects on site. He doesn't purport to be making his own evaluation, does he?
He's not making a landscape architectural evaluation, but he is making an evaluation using his considerable experience as an SNH officer.
Come to that in due course. Can we move to your word eyeful? Do you consider that if he'd used the words particularly eye-catching, that would have made any significant difference to the meaning?
I picked that out because it, along with other language in this note, suggests to me a disposition against the project.
Mr. Welsh, I'll ask the question again. I'm only going to ask it once. If you don't want to answer the question, we can note that. Do you consider it would have made any significant difference to it, meaning if he'd used the words particularly eye-catching?
That's more objective.
So would it have made a difference to the impression conveyed that he said it was particularly eye-catching or you get an eyeful?
If he had said particularly eye-catching, I don't think I would have extracted it here to indicate my concern.
And getting an eyeful of something, just Googling this the other day, not on Wikipedia, your side would be glad to hear, but the Cambridge Dictionary, can be an eyeful can refer to a very noticeable or attractive sight. So getting an eyeful of something doesn't necessarily mean it's pejorative. Just means you get a very noticeable or a picture that is very noticeable of a sight, attractive or otherwise. Quite often used of an attractive person.
I accept that.
So that when somebody says you get an eyeful in not being a landscape architect or consultant, they're conveying a meaning that which is no different from saying that it might be particularly eye-catching.
Well, I think it does, and I think it taken with all of the contents of this particular report, it would be unusual to interpret that extract that the officer thought that this was an attractive effect.
Of course, he didn't think it was an attractive effect, but that's the use of the term "get an eyeful" is no doubt slang, but it is, I'd suggest, no more than saying something is particularly eye-catching. And eye-catching is a word that's used consistently within the descriptive terminology of the environmental impact assessment.
I haven't come across many landscape and visual impact assessments that describe effects in those terms.
As eye-catching?
As eye-catching, certainly. As getting an eyeful or get an eyeful.
Not suggested that, Mr. Welsh. And again, you didn't listen to the question. It suggests to you that there is no significant difference between the description of get an eyeful and eye-catching, and you're picking apart a informal note seeking to criticise when that is unfair. You've highlighted 3 passages in terms of the language used, I think. Surprisingly bad impacts being one, get an eyeful is another, and some stuff, which is in your paragraph 928. They're informal, but there's nothing suggesting lack of objectivity.
I'm afraid I disagree.
Now, in 933, you say the SNH officer was searching hard for a basis against which an objection could be arrived at. And you're talking about regional distinctiveness. This is in the note in 2017. The possibility of a regional distinctiveness objection had been raised in 2016, had it not? If you look at pages 10 to 12 of the FOI bundle, you'll see that that's recorded there. It's page 11.
Sorry, I was looking at 17th of October 2016 at the meeting with the ECU.
So there was no need to search for the basis of a regional distinctiveness objection in July 2017 when the landscape architect had himself put it forward in 2016. That's correct, isn't it? It's an unwarranted comment.
I think it is warranted because when you read this through and you read all the information through, to my reading, there was an attempt to find a basis against which to attach an objection, including whether the iconic device might be used or the distinctiveness device might be used. And this was tying back to the SNH CD 825. There are only 2 devices that can be used in relation to landscapes that are not subject to national tier objections for SNH to object against. And so if SNH can demonstrate that either an iconic piece of landscape is affected or a distinctive piece of landscape is affected, it gives it a valid basis for objection.
Are you using the word device there in general terms in a pejorative sense?
A means, I would accept a means. It's a facility, a tool to enable an objection to be framed.
Are you using it in a pejorative sense? Is there a negative connotation? Do you attach a negative connotation to the word device, Mr. Welsh?
No, I don't.
Thank you. Could you turn to CD 825? And if you do you accept that the policy, let's see if I can take it quickly, do you accept the policy background set out in paragraphs 1 to 10 of this, that SNH may not are not only obliged to consider objections when there are protected areas that are affected, but also where non-protected areas, including non-protected areas of landscape, may be affected?
I'm not challenging anything written there in paragraphs 1 to 10, if that answers your question.
So, but you yourself, as I understood your questions last week, have not come across a case of a regionally distinctiveness objection in terms of the wind farms you've promoted?
I have not come. I don't promote any wind farms. I will just make that point clear. I assess the effects of development. I have not come across a scheme before where I have seen this facility of distinctiveness being used along with the map to object to a project.
And you're aware that, because I referred to last week, that certainly in the last 5 years when Mr. Halfhide has been in post, I think there have been 5 objections, maybe 2 of them twice. Upper Sonican, West Garty, Harryburn, this site and one other whose name escapes me at the moment, but I think that's not been taken forward. In all those other objections which were referred to reporters, the regional distinctiveness was considered in the context of the map to which you've just referred. Do you accept that?
Yes.
Okay. And if we turn to, keeping with this document, I'm grateful for your acceptance of paragraphs 1 to 9. If we go to the Appendix A and page 4 of that appendix, would you agree that there are 2 questions? If someone suggested you could be in the territory of an objection, there would be 2 questions that a landscape architect may be able to assist with. One is, does the landscape make a significant contribution to the distinctiveness and identity of Scotland's landscape? And the second question being whether, if you look at the last paragraph in the right-hand column, the proposal fell within one of those criteria or examples.
I accept that.
Thank you. When you were addressing the first question, surely, firstly, there's no other source of which I'm aware that might assist you apart from SNH's map of Scotland's regional landscapes as providing context. Are you aware of any other source?
The regional programme of landscape character assessments might be of some assistance in that respect.
So that's the SNH LCA finer grain assessments?
Yes, it's online service.
And if you were seeking to identify whether the landscape in question makes a significant contribution, you would clearly be trying to identify what contribution that landscape made.
Yes, but to me, this final box is a catch-all that can be related to any one of the 79 areas, because they've all been identified and differentiated on the basis of being regionally distinctive.
Absolutely. It could provide the context for a consideration of an objection in any of those 79 areas, but the important point is that this makes it clear it's not just because you're in such an area. You have to answer the 2 questions that we've agreed about. document makes that clear, doesn't it?
I accept you have to make an assessment to determine whether the landscape makes a significant contribution.
And so if you have a description of an area of distinctiveness, surely it may not be a tool that you would use, but seeking to identify, and it may not do it in every case, where within that area the distinctiveness is most clearly expressed, could be a useful exercise. May not be, maybe.
It could be, in the same sense that you might, in relation to a wild land area, determine where the wildness qualities were best expressed.
Absolutely.
And that is what SNH did in this instance, and they produced a map that, in my opinion, is erroneous.
Thank you, Mr. Welsh. That's cut out a lot of questions, but you will do you consider, well, we've been through whether you consider Dr. Wimble's map erroneous, and we've had that cross-examination, so I won't go there. Thank you. That's a very helpful answer. Don't need to take that further. Come back to your evidence. Yes, just one last point, I think. Paragraph 941. Do your inquiry reports go through various drafts before a final draft is produced?
They do.
And do you have input from, amongst others, no doubt, lawyers, certainly within other landscape consultants, seeking to ensure that the thoughts you've expressed are as clearly expressed as you would hope they would be?
Yes.
Is there any reason to suggest that Mr. Harfide's email was doing anything other than that?
It was seeking to make SNH's objection on the defined grounds more robust.
Well, see what he said, because you've quoted it here. He's suggesting emphasis be given to the landscape, removing expressions that make our advice seem tentative. Now, if advice seems tentative, but isn't tentative, there's nothing wrong with removing such an expression, is there?
What I read from that is that the officer said something is likely to, and what we're seeking through this email is to be more definitive and say it will.
And if the officer wasn't happy with that, then being a proper professional, they wouldn't have changed their view, would they?
I don't know what they would have done.
Well,
they might have had a discussion, they might have changed it, they might not have changed it.
If it didn't reflect the officer's view, just as if your report didn't reflect your view, even though that your legal advisor suggested you put something in it, you wouldn't put it in, because that would go against your professional code, would it not?
That is correct.
Thank you. I have no further questions.
I have no questions for you, Mr. Welch, so I'll pass you over to Mr. Steele.
Mr. Welsh, thank you. You've now been cross-examined for quite some time by Mr. Finlay about these matters, who's taken you to precise details in various paragraphs. But, Mr. Welsh, is it a question of looking at the comments one by one, get an eyeful, some stuff, and so on, or is it a pattern of conduct that you're criticising here?
I tried to bring that out in my answers. I'm critical of the pattern of conduct that I read through all of this correspondence evidence.
And what do you say that pattern of conduct was doing or endeavouring to do?
What I've said in my report is that I read this as a construction of a case against the project, and as I've said, to try and fit instead of fitting the peg to the hole the other way round, right from the outset there was concern expressed about the distinctiveness of this landscape, and that was then used along with the map and core area map to build an impression that this was somehow a uniquely distinctive piece of landscape, and against that basis the objection arose. I don't read through all this paperwork a methodical and objective assessment of the effects of the project.
And did you hear in cross-examination any explanation about the errors in the plan or the use to which it was put?
No.
If I just take you to one matter at 941, if I just ask you to put the matter in context, what do you think was likely to happen when the Director of Operation sends an email in the terms that he did in relation to reports and evidence? What do you think might be likely to happen?
I would have expected the officer to make the changes that were set out there, unless clearly they had an overarching concern about what they were being asked to do.
And what do you make of a circumstance where the Director of Operations thinks it appropriate to issue such an email or directive, depending on one's attitude to it?
I don't think it's for me to say whether it's appropriate or not, but what I read from that is yet a further endeavour to strengthen the objection on the basis of the regional distinctiveness point.
And has anything that you've heard or any of the questions put to you in cross-examination, Mr. Welsh, caused you to in any way alter the criticism that you have made of the SNH process looked at as a whole?
No.
Thank you. No further questions.
Thank you, Mr. Welch. Mr. Steele, Mr. Bell's coming next, is that correct?
He is indeed, sir.
And do you know how long you might need with him?
Not terribly long, sir. 10 minutes, 15 minutes, something of that order. But I would have thought... Oh,
and Mr. Finlay, do you know how long you might need to cross Mr. Bell?
About half an hour, maybe less.
And are you then proposing to have Mr. Halfhide first or Dr. Wimble?
Mr. Halfhide, I'm not sure as yet there's anything for Dr. Wimble to deal with, but Mr. Halfhide first, and he may be about 15 minutes in chief.
And Mr. Steele, roughly how much for cross-examination, Mr. Halfhide?
Difficult to say, sir. Depends how I get on, but approximately half an hour. It might be a bit longer. Depends on answers and so on. But in terms of order, Mr. Bell cannot be here tomorrow either, sir. But I'm still hopeful that we might finish all the evidence today, if that's the question. I'm not so sure about the condition session.
Well, from my point of view, there's very little between parties on the conditions because of the series of agreement that we've had. So I wouldn't envisage that session taking more than 15, 20 minutes.
Well, that's entirely different, sir. Some reporters like to go through every condition one by one to check the wording, but if that's the case, that's an entirely different matter.
Well, there will be an opportunity. We will go through each briefly unless there is debate on each condition. But my intention is it will not be a long hearing session. What I'm trying to figure out is where to fit Mr. Mundell, is whether or not we break now for lunch. Mr. Mundell is due to be here at 2, if we fit him in immediately after lunch or not. Any comments from parties?
Sir, I think I would prefer, if we could, to get on with this particular topic. I don't think, I may be wrong, but I don't think Mr. Mundell's in the room, and I'm not sure what time he's coming, but I would prefer to finish this topic, if at all possible, before we move across.
Okay, we'll work on that basis. Now, how long would parties like for lunch? 45 minutes? Would that be...
It depends when we get there. That should be all right, sir. It just depends on on the hotel. But yeah, that, from our point of view, that should be fine.
Well, it's fine for you. I'll say 45 minutes, so we'll resume at, let's say, 2:15. Okay, thank you. Mr. McDowell has joined us, so I've just informed him that we're going to take the next 2, possibly 3 witnesses on the SNH internal procedures session before we come to himself, which I'm anticipating will be around 4, 4:30. So, Mr. Steele, I'll pass over to yourself and your witness, Mr. Bell.
Thanks, sir. Next witness is Mr. Bell. His main report deals with these issues, most of which we will take as read. Mr. Bell, if we can take pages 44, 45, 46, 47 as read, but could you commence with the balancing duties section at page 48?
SNH balancing duties. It was also set out.
Just wait a second.
It was set out in the applicant's inquiry statement that the applicant is concerned that the application of SNH's balancing duty appears to have been undertaken after the decision to object and represents a post-event justification. Furthermore, the balancing duty assessment would not seem to have been reconsidered after the applicant submitted FEI and amended the scheme. The balancing duty form is dated 23rd October 2017. Observations on this include the following. The first set of questions includes this one. Does the proposal aim to help Scotland adapt or mitigate the effects of climate change on the natural heritage? The SNH response is that the proposal will help to mitigate the effects of climate change by introducing more renewable energy capacity. It's then stated that the proposed project offers a contribution to the Scottish Government's 2020 target. The SNH response could fit a modest 5 or a 10 megawatt development. To simply say the project offers a contribution, whilst correct, considerably underplays the scale of the benefit that would be derived from 147 megawatt of capacity, which can be considered a strategic scale development that would make, in my view, a substantial and valuable contribution to unmet targets. Furthermore, targets go beyond 2020, but SNH is silent on this. Moreover, given the form was completed in October 2017, the SNH assessment did not take into account the onshore wind policy statement or the Scottish energy strategy, both of which were published in December of that year. As noted in Chapter 2 of my inquiry report, today we face a global heating crisis and a climate emergency that's been declared by the Scottish Government. The position now is very different, indicating this answer from SNH is very much out of date. The SNH answer to the first question also states this. However, there is no evidence that this particular development is needed to achieve government targets in relation to energy and climate change policies, and clearly if these targets can be achieved with a lower impact on natural beauty and amenity, that is a good thing that should be encouraged through planning decisions. A number of points arise from this stance that SNH has taken. Firstly, the National Interest Form does not ask if a particular development is needed. Notwithstanding that, it is not even a matter that is sought by national planning or energy policy. Government policy recognises the vital role that onshore wind plays in meeting targets and expects multiple sites to come forward as part of national deployment, especially in Group 3 areas such as this location. Secondly, seeking to achieve targets with sites that have a lower impact implies a best performance and sequential approach which is embargoed by national planning policy and guidance. Moreover, the reference to natural beauty is entirely misplaced, as the spatial framework approach takes account of that consideration. Thirdly, the SNH's position that such a flawed approach should be encouraged through planning decisions is, in my view, entirely inappropriate and at odds with national planning and energy policy. The third question relates to socio and economic development. The SNH answer only refers to the environmental statement non-technical summary in Chapter 13 in terms of regional construction spend and regional employment creation. Brief mention is made of operational employment. No mention is made of consequent opportunities for a diversified economy. SNH had before it substantial detailed information in the planning statement and wider application documentation on the difficult socio-economic issues that this part of Scotland faces, and potentially the transformational economic opportunities that the project presents. This is all set out in the detailed evidence of Mr Blackett. To say that SNH has underplayed this matter, in my view, is a significant understatement. Turning to conclusions on the SNH position, if the significance of the adverse impact has been overstated, while the weight of economic and environmental benefits has been understated, then the balance called for by the exercise of the statutory duty could have been different. Moreover, as explained in my update of renewable energy policy, since SNH expressed its objection to the proposed development, matters have significantly moved on in terms of Scotland's response to the global heating and climate crisis by way of significant new energy policy documents and associated targets. I note Dr Rutley emphasises that SNH rarely objects. However, in my view, a history of no objection should carry no weight. A flawed approach and decision remains flawed, irrespective of other decisions by SNH, and the point is without substance, where the process underlying those other decisions has not been compared to that applied for in this application. Whether a landscape is in fact unique in the sense that it is recognised as nationally important or simply regionally distinctive is very important when considered, as it should be in this case, outside SNH's narrow approach based on their own landscape map, in which all parts of Scotland are deemed distinctive. Having regard to a map that identifies what is distinctive in each and every part of Scotland is not an appropriate test of what is nationally important, especially when a decision is to be taken with reference to such considerations in Table 1 of SPP. Mr Welsh makes it clear in his inquiry report that, in his opinion, SNH's approach lacks the proper level of evaluation that should be expected in the event that national importance is being attributed to a landscape. It will be important for SNH to explain if it has considered the weight of evidence submitted by the applicant for the inquiry sessions and the updated energy policy position in deciding to come to the inquiry to maintain its objection to the application. The conclusion reached on the balance of evidence is that the position adopted by SNH has lacked impartiality and has not been objective, and this goes to the weight, if any, that can be attached to the SNH position. It is also important to recognise that the wording may merit an objection contained in Annex A of the SNH guidance. It is therefore a matter of judgment and balance where the decision could go either way. In my view, the SNH balancing duty, in the way it has been applied in this case, has been shown to be unbalanced in favour of landscape and visual impacts. As I set out in my overall conclusions on the policy evidence, the decision on the North Lowther application will not, of course, be taken by reference to the predicted landscape and visual impacts alone.
Now, Mr Bell, one further matter. 3 or 4 cases were mentioned earlier, in respect of which SNH objected: Upper Sonican, West Garty, Harryburn, obviously, and one other as yet unnamed. Have you any knowledge, or did you have any involvement in relation to any of these schemes?
Yes, the Upper Sonican scheme, that's CD 7.34, I was involved in that, advising the applicant, and also West Garty, that's been referred to, CD 7.31. Again, I was involved in advising the applicant.
In that case, these cases, were you aware of any argument about core areas?
No, that wasn't a concept that was advanced in those cases.
Have you ever known of another case in which SNH have advanced an argument about a core area?
I think the only reference to core areas that I can recall over the last several years has been in relation to wildland draft designations. When they came out, there were core areas of wildland. But beyond that, it's typically been references to integrity or otherwise of landscape designations that has looked at areas, but not core areas as a concept.
And do I take it that core areas in relation to wild land are a rather different issue. So can I ask, have you ever known of a core area issue in relation to non-wild land applications?
No.
And what do you, Mr. Bell, as probably one of the most experienced witnesses in relation to wind farm developments in Scotland, consider of a position that we discover about the core area as a result of a freedom of information request? What do you make of that?
I think in the other cases, the issue in certainly West Garty and Sonican was, I would put it, fairly clear-cut in that the landscape resource, if I can call it that, was fairly well defined in those decisions. It's not been, in my view, in this case, and certainly in my discussions with the applicant's landscape architects. And from what I have seen of the evolution of the core area, it doesn't leave me with confidence that that has been a robust exercise that can be relied on in that regard.
And in relation to the specific point of discovering about it by means of a freedom of information request, what do you make of that?
Well, it just seems surprising in terms of lack of transparency.
From a government agency?
Yes, SNH is that.
I won't even ask you what you make of the accuracy of the document because we've covered that. Thank you, Mr. Bell.
Thank you, Mr. Bell. Thank you, Mr. Steele. Now, Mr. Finlay, do you have any questions in Cross?
Yes, I do, just a few. Mr. Bell, were you at any of the relevant meetings that have been referred to in the chronology?
No.
Have you produced all the documents relating to that the applicants have relating to communications from SNH?
Sorry, could you repeat the question, please?
Are you aware of any documentation the applicants have that relate to communications with SNH that you have not seen produced to this inquiry?
No.
Were you aware of documents DS 12 to 14 when you drafted your evidence?
Just need to clarify the title of the documents, DS 12.
DS 12 is an email from Francis Ososka dealing with, amongst other things, how balancing duties were applied. DS 13 is an email from Paul Taylor about a future meeting, and DS 14 is an email from Nick Halfhide to Bakura Estates relating to engagement with planning applications and applications to the balancing duty. Were you aware of those when you drafted your evidence?
I've certainly seen those, and it may have been they came after I drafted my evidence.
Were you aware of them before SNH produced them?
I don't think so.
Do you not consider they're relevant to SNH's application of the balancing duties?
Yes, they are of relevance to that.
Yet you haven't referred to them either, and now I understand why, either in your written evidence or your oral evidence.
Well, I didn't see that they changed the fundamental points that I've set out in terms of factors in the balance.
Mr. Steele referred to lack of transparency. Do you not consider that if you were to be, your criticism would have been more rounded, or your appreciation, your critical approach might have been more rounded had you been made aware of those by someone who was, at least for a while, behind the applicant, and then I think, as you've explained recently, Bakura Estates are simply the landowner?
That's fair. I think it may have been more rounded. I still think, though, that the fundamental points, and indeed they're very similar to some of the shortcomings that was identified in Sonican and indeed West Garty in terms of the planning balance considerations. These, for me, are the fundamental points.
The approach of SNH in terms of planning balance revealed by FOI in this case is, if not identical, very similar to that at West Garty and Upper Sonican, is it not?
It is similar, yes.
And I don't recall you criticising its approach on planning balance at either of those cases.
It wasn't as I think the shortcomings weren't as great as they are here in terms of Sonican and West Garty.
Well, do you think that Mr. Taylor's note, which is at pagination, I don't need you to go to the detail of it. It's at begins at page 15 of CD 8.27, could properly be described as an evaluation. Is that your understanding of it?
No, I haven't looked at it that way. I think
Thank you.
I've looked at that in the round in terms of the overall assessment or evaluation, taking the papers overall.
Didn't mean to interrupt you. Just to be clear, you didn't consider Mr. Taylor's note of itself as an evaluation?
No, I didn't.
Thank you. You've made various assertions, and I'm going to take them all together in your report. You've 4.2.1, use the words negative predisposition. 4.2.8, steering the argument to a particular position. 4.4.18, actively sought to present a worst case. And 4.6.6 has lacked impartiality and has not been objective. Now, those criticisms are potentially very serious. Are you suggesting, firstly, that, and I'm not saying I accept them, that they have infected the evidence of Dr. Wimble?
I'm not saying that.
Thank you. Are you saying that the landscape professionals, Fraser McNaughton and Fiona O'Mahony, breached their professional duties?
I don't say that.
Thank you. Are you saying that those two have sought actively to mislead anybody?
I don't use those words.
I know you don't use the words, but are you seeking to portray that they've positively sought to present a case different to that which they hold an opinion of?
No, I don't say that.
Are you suggesting that about Mr. Halfhide or Mr. Taylor? Paul
No.
Taylor. Thank you. Or the panel members who considered and advised Mr. Halfhide?
No, what I'm saying is that taken together collectively, my reading of the papers leads me to hold that opinion.
I'm grateful, Mr. Bell. But with respect, your opinion of the papers is of an interested observer. I'm not being pejorative in that sense. And your reading of the papers is, and you set out the basis of it, is your reading. I'm not suggesting it's an opinion you don't hold. But whether it's correct or not will be a matter for the reporter to advise ministers about.
I think that's right. What I do is set the scene, if you like, with the review of papers at 4.2. But the substance of what I'm advancing is in terms of the guidance papers that SNH has at 4.4, and then the balancing duties, and that taken together. So it just sets the scene for that.
And setting the scene would also have to have regard to the additional material that has been revealed, or work undertaken by SNH that is revealed by the chronology. the extensive site visits undertaken, the extensive work by Fiona Omani, and the report writing that she did, and the length of time she spent putting into the report writing, which, as we heard from Mr. Welsh, he didn't criticise.
I agree, that all has to be taken into account.
And there's nothing of that in your report or in your oral evidence this afternoon, is there?
No, it's not.
Two small points on timing in your evidence. At 4.2.9, just to put this in context, this is having referred to Mr. Taylor's note, which or referred to, which I think is at page 10. No, apologies. It's page 15. At 4.2.9, you say it would seem therefore, and that's drawing a conclusion from Mr. Taylor's note. Have I understood the therefore correctly? That's what that paragraph is doing. It's the therefore is a reference back to Mr. Taylor's note.
I would need to have based it on something in the bundle of papers.
Yes. I'm saying that because you refer to the email exchanges, and at 4.2.3 you say this contained a detailed note from an SNH official, and then the remaining paragraphs up until 4.2.8 contain quotations or commentary on that note.
It may have been a collective a conclusion overall that I'm drawing there. It was right at the end.
Well, see, 4.2.9, you say it would seem
I think
therefore...
Mr. Bell had finished that
apologies.
answer. I'm sorry.
I thought he had. But at 4.2.9, it would seem therefore that at the outset there was a drive to achieve outright objection. But the only material you've referred to in any detail is that note from 2017.
Well, I take it there will be a reading of all the papers, and I think, as I've said, it's taking it in the round in terms of the chronology and the stance taken at different points in that leads to that conclusion.
But with respect, Mr. Bell, that's not the way your report reads. Your report reads very clearly from 4.2.3 onwards. The only detailed points you make relate to the note, which is dated in 2017. And you say that at the outset there was a drive to achieve outright objection. If you turn to 4.4.12, 4.4.12, you'll see there's a reference to framework areas, and you say this isn't...
Sorry, Mr. Finlay, just what paragraph is that? I'm just confused.
4.4.12.
Right.
You'll see there's a reference to the spatial framework, and there's again a reference to timing of SNH's case. You say this is in stark contrast to the starting position of SNH, as it's evident from the review emails amongst SNH staff referred to above. And again, if we look at those emails, the only emails we refer to date from 2017 in detail. Whereas we know that the possible objection, or the threat of a possible objection, was raised publicly in 2016. All I'm putting to Mr. Bell is that your reference to outset in 4.2.9 and starting position in 4.4.12 are simply inaccurate.
Well, what I can say is that the conclusion I draw on the posture taken, if I can call it that way, by SNH, is the conclusion I arrive at from reading the papers in the round. I cannot say whether it's that particular exchange, and I haven't expressed it that way in my inquiry report, but it's in the round reading of the papers that leads me to that conclusion.
So are you suggesting that Fraser McNaughton, who was the original landscape architect who was providing the advice that there could be or might be an objection on regional distinctiveness, that he was undertaking a drive to achieve outright objection when he did so?
No, I'm not saying that. I think when these positions are looked at together with the position that there was no clarity on what the distinctive resource was, and there was quite clearly from the papers different views being expressed and being sought. So whilst there could have been an objection made, the basis for that objection was quite unclear at various stages.
Well, there's a matter for submission, Mr. Bell, but I'd suggest that the potential for an objection was made very clear, and the potential bases for it were made very clear in 2016, and that had you or your clients or anyone who attended those meetings wanted further information, they could have asked, but they didn't.
Well, I can't answer that. That may not be correct in terms of whether further information was sought or not.
That's why I asked you whether there was any correspondence of which you were aware that I am not, of your clients, and this would be included within such, asking for further information at that period.
That would be something I would need to check to answer that.
I thought you'd answer my first question by saying there wasn't such.
And if it is of such importance, then it's a matter that I feel I should check.
Mr. Bell, I'm asking you whether you are aware of it. If you're not aware of it, then your evidence can't take that further forward. And if we go to the note of pages 10 and 11 of bundle CD 827, you go to page 11. You can perhaps help. Fran Paciti from LEC was on the telephone. What role was she playing in the meeting, do you know?
Yeah, your unnumbered version, which I've marked up.
So it's...
the draft note of the landscape meeting, 17th October.
Yes, that's it, Mr. Bell.
Got that.
So what was Fran Paciti's role?
She would be there in the capacity of the consent unit.
Yeah, and one sees at the top of page 11 that she noted that, and this is in there's a dash in Ian's sim. If you go down 5 lines, she noted that in her view this was a challenging site and it had unique aspects to it, with lead hills and one log head having strong cultural connections. And also that it would be useful to see info in the EIA comparing different layout options versus economic yields. So that it was a challenging site was obvious to not only S&H but Ms. Paciti at that stage.
I have to say, probably once a week, a planning officer or another party tells me a site is challenging. And it's not unusual, whether one's in proximity to wild land or residential properties or national park or in a coastal location, to get such a term used.
We go down the page, there's a indent 5 from the bottom that Fraser noted the possibility that S&H would object to this proposal. Fraser acknowledged there was more internal S&H consideration required. And then it may be based on a number of matters, and then the third issue, it may be based on criteria of iconic place and or regional distinctiveness. Just reading on, Ian Sim was a bit surprised that they were potentially going to object. He's and 2020 renewables. Fran said that even in the absence of objection, it may be the case we go to PLI. And then there's a question of length of time that it would take if such happened. Fran also noted that better for the decision maker to understand the substance of these concerns, and this would be a key issue. And then over the page we have Mr. Van Grieken asking about detail as to whether he had underestimated effects and whether SNH might have a different view. Now that's about detailed considerations, isn't it? You can read the rest of that paragraph if you want.
Yes, it needs to be read in the context of that wider discussion there.
But there's nothing in there saying, please explain why the area is regionally distinctive. That's not a matter of fine detail, which is what I think Fraser McNaughton was keen to make the point of, that SNH couldn't spend time about that. There's no request there for the broader aspect, is there?
That may well have been dealing with the suggestion that there could be an objection where the underestimation of effects and the rest of the matters discussed there had gone to informing the SNH preliminary opinion.
You can put that away, thank you. No, I have no further questions, thank you.
Thank you, Mr. Finlay. Mr. Bell, I have no questions on this particular topic. Mr. Steele.
A couple of matters, sir, if I may. Mr. Bell, can you go back, please, to bundle 827? Could I firstly ask you to look at page 10? This is in the context of questions that were asked about whether requests were made about various matters.
Yes, I have that.
Towards the bottom of page 10, the third bottom dash point, could you just read that out firstly, please? The Lead Hills.
The Lead Hills is quite geographically small, is a quite geographically small entity centred on this development. Brackets, note that Ian Sim was keen to know what the Lead Hills was defined as, and Fraser tried to indicate broadly on a map. Also that Fiona has provided some comment on what she sees as the Lead Hills in light of character types and local designations. Close brackets.
First point, do you know what is meant by the Lead Hills?
Well, it's not clear what they are referring to there, but it may be the area to the north, just to the north of the site.
But then again, it may not. Would that be fair?
Yes.
Is it abundantly clear that Mr. Sim, who's present in this room, wanted to know what on earth the Lead Hills was?
Indeed, that's the question there.
Do we find any answer to that anywhere in this note?
Not that I see.
At the bottom of page 10, top of page 11, is there an acknowledgement from Fraser that there is some suitability, as I understand it, in relation to the site? Is that your understanding or not?
Yes, I see that.
Now, if we turn to the page 12, which you've been asked questions about, can I just ask you to take a moment or two to read to yourself that paragraph, that first paragraph, together with the second dash point about regional impacts, just to consider that and tell us what your opinion is as to how helpful or otherwise SNH were being in relation to clear requests made.
From reading that through, first point is that Fraser was not keen to engage on detailed comparison of analyses. It goes on to say that SNH cannot spend time disagreeing or carrying out any fine analysis of key points. They can only engage as time allows. So it would seem that whilst raising the possibility of objection, and Mr Van Grieken is recorded by SNH as being keen to engage in the detail, there is a very strong rejection of that, it would seem, in the minute drawn up.
And what do you make of that state of affairs, Mr Bell, clearly recorded by SNH?
Well, I think when the suggestion of objection, which is relatively rare, is raised, developers, when they're investing considerable time and effort, need to have adequate time to understand the issues and engage in a proportionate way with the key landscape advisor that will have a very influential position that will be expressed in due course. So it's disappointing to see that.
What, just looking at this generally, does it appear to you that SNH told our esteemed clients that they simply didn't have time to engage in these matters? Is that a fair reading?
That's what it said at the end, that Mark Van Grieken was keen to talk through the findings of the assessment.
Right. Thank you. I think that is leading. If we could rephrase the question.
Very well. How does it appear to you SNH treated the request for information to understand what the SNH position was? And what was the reason given?
There was no time available, and the detail would follow in a letter.
And on the earlier point, have you seen any explanation anywhere as to what the Lead Hills is defined as, which seemed to be the issue at that time, on the 17th of October?
No.
That's a bizarre answer, because the note goes on to say that Mr Fraser McNaughton tried to indicate where it was on the plan. So in terms of there being no indication at all, how the question can have been put and the witness answered the way he did is, frankly, I would seek to ask further questions on it, if that's the standard of question and answer that's going to be permitted.
So we're not going to get finished today if this continues. Malone Friend's now making a comment and an answer given that he doesn't like. He's got every opportunity in closing submissions. He's got another witness or two coming, and I'd like, if I may, to move on.
Well, I think I've noted the concern. Obviously, I can read this for myself and come to my own conclusion.
Now, Mr Bell, you're criticised for not taking into account documents DS 12 to 14. Do you have them available to you? Now, just to assist me, because I don't have them in front of me, to whom are these documents, emails, addressed? Who is the correspondence with?
DS12 is to John Glenn of Buccleuch Estates.
And can you look at 13 and 14? Does the same thing apply?
Is to Ian Sims of the applicant, and 14 is to Buccleuch Estates.
So far as 12 and 14 are concerned, they go to Buccleuch Estates, or to and from Buccleuch Estates. Is that correct?
That's right.
Yeah. And do they, to any extent, deal with an issue of, or mistakenly or otherwise, deal with the issue of pump storage?
They may do. I can't see that reference at the moment.
Right. If the documents, or two of them at least, have gone to and from Buccleuch Estates, is it any surprise that you wouldn't be aware of them?
Certainly, I didn't ask for to see correspondence between SNH and Buccleuch Estates.
Now, you were asked a number of questions about paragraph 4.29 of your report at page 45. But could I just take you back to page 44, please, Mr. Bell? And could you read out the heading at 4.2?
Review of SNH background papers.
And does paragraph 4.2.1 make clear what documents you are talking about?
Yes, it's the CD 8.27 review of the papers secured by way of the Freedom of Information request.
And if one looks through the succeeding paragraphs up to paragraph 4.29, do you refer to only one document, or are you referring to more than one document?
It's that one document bundle. Document
bundle, yes, which comprises a number of documents. Is that so?
Yes, that's correct.
When we come to 4.29, it would seem, therefore, are you referring to one single document, as was put to you, or are you drawing together your review of the SNH background papers in plural?
It's the in-the-round review of the papers, and that was my earlier answer.
Now, points were put to you about paragraph 4.21 and others, the use of the word predisposition, steering, worst case, lacked impartiality. Is it possible to nitpick and isolate particular statements by you, Mr. Bell, and are you making only one minor criticism in relation to one matter, or is it something rather different?
It's my review of the various positions that collectively seem to justify the position that the premise was trying to find something, effectively. And that's why I drew the conclusion I have from my in-the-round reading of the papers.
And is that from looking at one document in isolation, or is it looking at the entire bundle of documents and the course of conduct by SNH that leads you to that conclusion?
I don't think it's fair to look at one document. Clearly there are a number in play that are relevant, and it has to be that collective reading.
Fine. Thank you, Mr. Bell. No further questions.
Right. Thank you for your time, Mr. Bell. We'll just take 5 minutes while we swap over the witnesses. Mr. Halfhide. If you take a few minutes to do that and then confirm. Thank you. Mr. Finlay, I've assumed that Dr. Wimble will be giving some evidence now, so I'll get to take over.
Yes, just two quick questions, Dr. Wimble. Firstly, if you have NLEI 30.
I do.
Insofar as Mr. Welsh has put further annotations on an underlying SNH plan, are you happy that his annotations are broadly accurate insofar as you can deduce at this stage?
Yes, he's put a shape on for the regional scenic area and for the SPA, and given the coarseness of the background map, that seems a reasonable representation.
Thank you. Now, given you have been given evidence on behalf of SNH, and you state in your report at 3.6 that you broadly agreed with it and the Council's consultation responses, what is your understanding of the role the Dumfries and Galloway Regional Scenic Area played in respect of SNH's objection?
The RSA would be, well, in fact was, more a matter of concern to the Council than it is to SNH. I believe SNH referred to it in their objection letter, but merely to underline that the nature of the landscape in that area.
And so in support, your case supporting SNH's view as opposed to the Council's view, how important in reaching that view was the Dumfries and Galloway's RSA?
That was not the core of, perhaps I should use a different word, that was not the main substance of SNH's objection by any means.
Thank you very much. I have no further questions.
Mr. Steele, do you have any questions in
Thank you,
cross-examination?
sir. Dr. Wimble, does it come to this? You now realise, and we now realise, that there was a very significant error in relation to the RSA. Is that the first point?
The RSA, as was drawn on this original conceptual map, was not an accurate area, although it indicates the approximate location.
Well, Dr. Wimble, be fair, it doesn't even indicate the approximate location. Just look at it. It's wildly different from the actuality of the situation, is it not?
Well, in the area of most concern, it is more accurate than in the south and the west,
Dr. Wimble,
although not completely accurate.
Can we agree, Dr. Wimble, that it is wildly inaccurate when read as a whole? That must be so, surely.
As a whole, it is not an accurate representation of the area.
You now say that notwithstanding that inaccuracy, it doesn't really matter. Is that the position?
In terms of S&H's objection, the RSA has very little substance.
Fine, thank you.
Dr. Wimble, I only have one question for you. I said last week that some questions I had may have arisen through the landscape and visual impact inquiry session we had, and some may arise during this session. And some I would have posed to you then, and I've saved for now. So if there's crossover, I apologise for that, but my question. So last week, I just wanted to confirm that I have this correct. You said that prior to the accompanied site inspection, you'd spent time on the application site. Now, my understanding was you'd spent approximately an hour on the application site. Is that right?
Yes, in terms of actually being within the red line boundary, then probably an hour, and I would have visited that area in connection with the Harryburn inquiry as well, but that's the same area around Glenaber Hill.
And that was my next question. So the area that you visited, was it just Glenaber Hill that you went up in connection with both? I realized there was a shared viewpoint from Glenaber Hill to Harryburn as well.
Yes, that's right. It was pretty much the same viewpoint.
So you didn't travel anywhere else within the red line boundary other than Glenaber Hill?
No, I mainly looked at the site from the surrounding viewpoints and road and path receptors.
So last week, you'll remember, I took you to 4 points in the compass where we looked at the site, and I asked you the question about what was it about those areas out with the site that made them distinct from the area that you'd identified within document DS1 as being the core, or, well, not the core, sorry. I realize that you described it as the area where distinct features were shown. What I want to understand is, if you haven't visited anywhere else within this red line boundary, and you've only spent 1 hour at the summit or climbing to the summit of Glenaber Hill, how do you know that these areas within the red line boundary have regionally distinct features or not?
Well, mainly by looking at and experience it from the surrounding area, including areas which are out with and within the area with the greatest regional distinctiveness. And it's possible to tell, as I did by looking at the by where we looked at those photographs, which are all locations that I visited, apart from the area at Wing Head. It's possible to see the variation in topography and to experience the somewhat less interesting topography of the surrounding area.
Do you think it would have been preferable for you to have actually gone onto the site and gone up and driven around? I know we did it during the accompanied site visit, and we drove around the wet weather or grouse shooting route on the Southern Upland Way. Do you think it would have been useful for you to have done that exercise in advance of drawing your DS1 plan?
It would have been useful to have had more time visiting the site and the viewpoints. However, looking at the landscape on a regional scale and knowing the area already as I do from not only this inquiry but also from Harryburn and Lead Hills Wind Farm and other wind farms in the area, I felt that my area that I defined was a regional scale of area that was based on my understanding of the regional landscape. And that's why it's drawn in a very approximate fashion. And there are other factors that you can bring into this as well, which is not just the appreciation visually from experiencing the site and the surroundings, but also simply by looking on maps, air photographs, and so on, which is why I showed, and looking at landscape character as determined in the S&H local study, regional studies, for instance, which is why I prepared two maps, one which highlighted the topography, and the second which highlighted the landscape character. And I suppose the final thing I would like to add to that is that I was trying to understand S&H's view of this, and to do this I went to the original source material, which is obviously the shape identified on the map, and secondly the description of the key features of the area, which is something that's applied to all of the 79 regional areas in Scotland. So I threw my circle around features that were included in that description, as well as basing it on my understanding of the regional landscape from having worked in East Ayrshire, South Lanarkshire and Dumfries and Galloway.
Thank you, Dr. Wimble.
Sir, I wonder if it would be possible to clarify whether Dr. Wimble in fact visited Glengabber Hill for the purposes of this inquiry, or whether he'd actually visited it during his up to 1 hour, actually for the purposes of the Harryburn inquiry.
Well, I'm happy for that to be clarified.
I visited it on both occasions and in respect of Lead Hills Wind Farm as well, and I think probably I visited it in respect of another wind farm, but I couldn't name it.
So, sorry, I think we're trying to ascertain your 1 hour spent at that location. Is that cumulatively for those three projects, or did you spend an hour separately for each project?
Oh, no. The 1 hour spent in the area would have been for this project and walking along the path a bit and looking from the viewpoint, walking down towards Cog's Head, just to see that stretch of path and to get an idea of the site from that location.
Thank you, Dr. Wimble. Mr. Finlay.
Dr. Wimble, just if we look at DS2 for the moment, your plan DS2, which I'm sorry you won't have in front of you, Mr. Innes may be able to assist. But I can ask a preliminary question whilst he's getting it. It shows that about half the area that you've identified was part of the is encompassed within, not wholly, but mostly within the South Lanarkshire Special Landscape Area. And was that an area that you were the lead landscape architect in identifying and drawing up?
The South Lanarkshire Special Landscape Area.
Drawing up, but identifying in the most recent South Lanarkshire suite of documents that include special landscape areas.
Yes, and in the South Lanarkshire Landscape Character Assessment and the wind farm capacity study.
And then just looking at your blue line, again, if you can visualise it at the moment, does the, if you like, the northeastern boundary of that broadly follow the distinction between the North Lowther or Northwest Lowther area and the Lowthers area, basically along the Croik Valley?
I'm slightly confused about the document I'm referring to. Did you mean DS1, but the second map?
That's
yes.
Exactly what I meant.
Okay,
yes.
yeah. So could you repeat that question?
Yes, sorry, and my apologies to Mr. Innes as well. Is the northeastern boundary broadly equivalent to the boundary between the two landscape character types identified in the Dumfries and Galloway wind capacity study, which goes up the Croik Valley, in essence?
Yes, that's correct.
And then the sort of southwestern boundary, because it's runs along the main road, which takes in a bit of the Nith Valley, but is on the boundary between the Nith Valley and the Lowther unit. Is that correct?
Yes.
Now, I'm not sure that this arises out of cross-examination at all, but it's entirely up to you.
I don't think it arises from cross. I think it arises from the question that I asked.
Thank you, sir. Yes, it was why, as I understood your question generally, it was, did Dr. Wimble have sufficient information to enable him to confidently draw or identify his area of distinctive characteristics? And one of the answers Dr. Wimble gave was by reference to landscape character types, and I was just seeking to provide some detail on that answer.
That's fine if you want to proceed.
Thank you, sir. You mentioned that you carried out site visit for Lead Hills Wind Farm. On another plan we don't need to turn to, the reporter knows where that is. How much time did you spend on site for Lead Hills, if you can recall? I know it was some time ago.
I think I spent a day or so in the area of, mainly in South Lanarkshire, but including viewpoints on Glenarber Hill and Lowther Hill.
Thank you. And in your, is there anything in terms of the, well, two further questions. So is there anything in terms of what you saw on the site visit, or indeed that you've heard at the inquiry, that has registered with you as new information that you were hitherto unaware of, that might be relevant to this, your identification of approximate area?
Well, given that it's an approximate area, I don't think so, no. I mean, it's always possible to draw an approximate area slightly differently, but I believe this covers what is described in the description for Area 74 and the topography, the most interesting area of topography as well.
And is there anything you, having spent more time on the site in the company of, amongst others, the reporter, and listened to evidence and inquiry, that you would like to change about the area you've identified?
No, I don't believe so.
Thank you very much, Dr. Wimble.
Thank you, Dr. Wimble. Mr. Finlay, if we'll just take a minute to switch over to Mr.
Yes, it should
Halfhide.
be hopefully no more than a minute or two. Mr. Halfhide next. Dr. Wimble first is that it may be appropriate if Malone Friend doesn't need Mr. Van Grieken and Mr. Welsh at this stage. Dr. Wimble has his draft table that you asked him to produce. I don't wish us to run short of time for that to be discussed, but Dr. Wimble would now be free to discuss that with Mr. Welsh and Mr. Van Grieken if that was appropriate.
Well, sir, I hear that, but I think Mr. Welsh and Mr. Van Grieken are very keen indeed to hear some of the explanations that may or may not be about to be forthcoming. I don't think they'd miss it for the world.
The recorded version won't be nearly as good, I'm sure. Are you, Nick Halfhide, and are you Director of Sustainable Growth at Scottish Natural Heritage?
Yes, I am.
And before that, were you Director of Cairngorms National Park for some...
Sorry to interrupt, Mr. Finlay. I don't want to go any further while we've got this interference. I'm just going to swap this mic. Right, sorry for that interruption. If you continue, thank you.
Of course, thank you, sir. Before that, were you successfully Director of Cairngorms National Park, Chief Executive of the Deer Commission, and you've been working for SNH for the last 10 years?
That is correct.
Do you have any professional landscape qualifications or indeed planning qualifications?
No, I do not.
Are you the man that's made the decision in the, I think, 5 or 6, and you can tell us which the one I missed out was, decisions where SNH have made regional distinctiveness objections?
Yes, I am, and the unnamed one is Glendy.
And what's happened to Glendy?
I'm not 100% sure. I think it's still under consideration.
Thank you. And have you, in terms of the cases that come before you, have you accepted every case that's been put forward for a regional distinctiveness objection?
No, there have been a couple of occasions where I have declined to support the objection that has been suggested to me.
Thank you. I want to ask you a little bit about the staff that have been involved in this. Mr. Taylor, is it his role to carry out any landscape evaluation exercise, as Mr. Welsh was suggesting he thought he'd undertaken, but Mr. Bell didn't?
No, we do not look to Paul for landscape expertise. We look to him to pull together the professional advice and to coordinate the case.
Thank you. We heard what, in terms of Fraser McNaughton and Fiona O'Mahony, just can you confirm at the moment Fiona O'Mahony's on maternity leave?
She is indeed, yes.
Okay. In terms of the importance or otherwise, as you understand it, of, you have heard Dr. Wimble's answer, of the Dumfries and Galloway Regional Scenic Area. We know Fiona O'Mahony annotated it on a plan, so she clearly considered it was relevant. But in terms of your decision and your understanding of the mistake that she made in doing so, did it play any significant input into your decision, and would your decision have been different had the plan been accurately drawn as now appears in NLEI 30?
The indicative map was not a significant part in my decision-making. I relied more on the professional advice, written advice from the landscape experts, supplemented by my day in the field, looking at the site from a number of different viewpoints.
Thank you. As far as you're aware and your involvement is concerned, and I try and summarise the case the criticisms against you. Has SNH been involved in constructing a case from the start or from the middle point or at any stage in order to put forward an objection to a scheme that did not merit an objection?
No, I strongly refute that suggestion. As with all cases that we consider, we do so in an objective way. We are supported by professionals who have a reputation to maintain, and they are very clear on the evidence that they bring forward.
Yes, thank you. Perhaps you'd wait there. There'll no doubt be some questions for you.
Mr. Steele.
Thank you, sir. Mr. Halfide, a very good afternoon to you. Am I right in thinking that you have a degree from Oxford, but no qualification in landscape architecture or planning?
That is correct.
Now, let me make clear at the outset, Mr. Halfide, that I'm going to try and look at this matter in a more general, rounded fashion and not be captious or nitpicking about this. There was a Freedom of Information request made to recover certain documents. Is that so?
Indeed.
Is that correct, Mr. Halfide?
Yes, indeed, there was a request, and we did indeed release some internal documents.
And you had a responsibility to comply with that FOI request, or alternatively, to cite good reason why you were not complying. Is that so?
That is the usual procedure, yes.
So I wonder if you can just help me with a few preliminary matters. If we turn to look at the chronology, can I ask, please, firstly, who drew up this chronology? This is the one that was produced, broadly speaking, over the weekend.
I understand that was drawn up by my colleague, Mr. Taylor.
And was there any input from anybody else, do you know?
I don't know the answer to that question.
Did you have any input into this document?
No, I didn't.
Well, if we start at the first page of the document, the date March 2016, we see that was a background note of collated material. Can you tell me where that note is in the bundle of recovered material, or alternatively, where we notified that there was an exemption as to its production?
I don't know the answer to that question.
Sorry, Mr. Steele, could you just give me the date, which one you're referring to again?
It's at the bottom of the page, sir. It's March 2016, bottom of the first page. There isn't an actual date other than the month of March 2016. It's at the bottom of the first page.
So you'll note that the summary says it's not included in the bundle.
I'm grateful for that.
So excuse me, Mr. Steele. The chronology says it's not referred to in the bundle, not included in the bundle, but is referred to in it.
I'm grateful for that considerable assistance. Mr. Halfide, the note says it's not included. Can you explain why that note is not included, given that it was covered by the FOI request?
I can answer in general terms that when we get an FOI request, we will examine all the documents that we still hold, and we will then release those unless they fall into a very small number of exemptions. Beyond that, I do not know the answer.
Can we agree? I should have taken this from you earlier. Can we agree that there are no exemptions suggested by SNH in the response to the FOI request?
I believe that is the case from the covering letter to the FOI release.
Thank you. And can we agree that the note in question, being a background note, has not been included within the information produced?
That is clear from the chronology and the FOI release.
If we look further forward in this chronology to the months of June/July 2017, which is at the bottom of the second page, unnumbered, and the top of the third page, do we see there that there was a detailed handwritten notes in relation to each viewpoint by Fiona, who I understand is your landscape architect?
Yep, that's correct.
Can you confirm where these notes are, which are covered also by the FOI request?
I understand that we do not hold them within our corporate database.
And where are we told about that? Where there's a comment about it. There's a comment column even, but it simply says no document.
That's a general response, that we release documents that we hold within our corporate repository. If they're not in our corporate repository, then we don't have them available to release.
On the 26th of July, there was an internal meeting and handwritten notes were taken as the basis for drafting the National Interest Checklist. Where is that document?
My same answer will apply to that as well.
In relation to September 17, which is at the second or third last page, September 17, we're told in the right-hand column that the resulting redraft is presented, but can you confirm whether we do or do not have the original draft of that document? Has that been produced?
Our policy is to release final documents, not drafts.
Well, were not the drafts covered by the FOI request, Mr. Halfide?
My understanding of FOI is that we're not required to release drafts, but only the final document.
Get from that the
earlier drafts of many documents do exist within our corporate repository.
And you say that not covered by the request, do you?
Didn't say that. What I said was my understanding of FOI is that we're not requested or required, to release early drafts of documents, but we release the final version.
So, that when at the paragraph 2, you're required to produce copies of all reports, advice, notes, meetings and emails, you have not done so because you believe it's a draft and exclude.
I believe that the letter is correct, that we have provided all that we are requested to do. So we provide the final document, but not earlier drafts.
Just so I understand my own friend's question, I think request 2 related to the landscape map of Scotland. Have I misunderstood that?
Sorry, I didn't catch that at all, sir.
So, my own friend suggested that Mr. Halfide had failed in respect of a request 2 in the letter. The request 2, as I understand it, relates to the landscape maps of Scotland, not the decision in this case. But I may have misunderstood that.
Well, our friend can take that up in re-examination if he wishes to. For the avoidance of doubt, Mr. Halfide, item 1, request 1, relates to all assessment, background notes, etc. Does it not?
That's how I read the request, yes.
Thank you. And item 3, all reports, notes of meetings, etc. And what you're saying is that you have not produced to us draft documents.
What I said, and I'm happy to reiterate it, is that our policy is to produce the final documents, not earlier drafts. And the reason for that is earlier drafts are just that, they are work in progress. So what we release is the final version of the document, that is the final version.
It hasn't occurred to you that it might be useful for us to see the progress and the earlier drafts to the position?
Well, this is a standard policy we have for the very reason that early drafts are just that. They're not the final product. And often through a process of finalisation, we will correct errors, misunderstandings, or additional material will be included. So it's the final letter, report, that we release.
So are we in agreement that there are earlier drafts of documents which you have failed, rightly or wrongly, to produce?
We have followed our corporate policy, so I would take issue with the use of the word failed. We have followed our policy and produced the documents that you requested.
Well, let's not be captious about the precise wording. Mr. Halfide, you have not produced all of the documentation for reasons you've explained.
No, I disagree. We have produced all the documents that you requested in line with our corporate policy.
Yes, well, that's a clever answer, Mr. Halfide. But as a matter of fact, if we ignore the fact of your corporate policy, we haven't got all the information, have we?
I would contest that you have all the information because earlier drafts are just that. They are not completed documents.
But do you not understand the importance of that? The suggestion is being made by the witnesses that they have been encouraged, not the precise wording, encouraged in the making of an objection. It is therefore perhaps all the more important, if not critical, to understand what the earlier draft of the document was.
I don't know what to say to that because, as with any piece of work, there's lots of toing and froing, discussion. Some of that is written, some of it is not. It's an iterative process. And what we have released to you is what you requested under Freedom of Information. Obviously, there's a whole bank of additional material, but that's all internal workings. What we've given you is the final versions.
Well, Mr. Halfide, let me try something further. Page 15 of the bundle. We see an email from Paul to Fiona and Fraser. At the full paragraph above the word Paul, do we see reference to a collated note that I prepared a while back? It's in the first line.
Yes, I see the reference.
Can you confirm whether that note has or has not been produced?
I think it was the one you referred to earlier on that I confirmed had not been available because we didn't hold it any further. We didn't hold it.
And if we go down to possible key at the fourth line, at Nick's email, which I expect is your good self.
It is me. It is I.
Has that email being produced? And if so, where is it?
I do not believe that it has, and it may be that we no longer hold it.
It may be. Do you know that, or is that speculation, Mr. Halfide?
It is speculation on my part because we deal with many FOIs, so we're pretty thorough about this. So it is my conclusion that if we haven't released it, it's because we no longer hold it.
You don't actually know that. Do you understand it would be important for us to see that email because that was the highlighting of the Wikipedia description and was a starting point for various pieces of work?
I can understand why it might be useful, but I would take issue that it wasn't the starting point for a piece of work. As the chronology shows, we've been considering issues about the location of this wind farm, proposed wind farm, and the significance of the area for some considerable time before that email was sent.
And if I turn to page 17, line 7, do we see reference to you again, Nick noted, and then 2 lines of... Have you found that? and 2 lines above the underline line, the connection between the 2 special villages, Nick suggested, is that a reference back to the self-same from you? I have just referred.
Sorry, I'm struggling to find the bit that says Nick suggested. I can see that Nick noted.
Right. If you go down to halfway down the page.
Oh, halfway down, right.
And there's an underlined line connection between 2 lines above that. Nick suggested.
Yeah, no, I can see it. I'm not able to confirm whether that was in the email or whether that was as a result of a conversation.
And do you realise that it might be important for us to understand what it was you're suggesting, because your suggestion was it could be argued that the core of an area was affected. If it could be argued the core of an area was affected, then the case of regional distinctiveness could potentially be made. So if that was in the email, it would be important to...
Yes, it would be important if there was anything further to be said beyond what's reported here.
I wouldn't normally pause a cross-examination, but I'm finding this rather distracting with the crackling, so I'm just going to ask you to try and sort out the audio. Thank you. I think, indeed...
So, I was busy talking through it, sir, but it's not satisfactory.
I've been told by Ewan that if paperwork is on top of the speaker, it can interfere, so thank you. If you want to continue, Mr. Steele, thank you.
Thank you, sir. Mr. Halfide, can we leave this little chapter on the basis that there are quite clearly a number of documents that you have not produced? Indeed, I think you described them as a raft of information that have not been produced in respect of the FOI.
Can I just, I'm sorry, I'm just going to interject there slightly. I'm a bit uneasy about this in terms of what this means legally.
Well, so am I, sir.
And I'm not sure, I mean, Mr. Finlay, it's your witness.
So far, Mr. Halfide has made his position clear insofar as he knows about matters. I will number of obvious points for re-examination if these documents are so important. Mr. Steele is trying as one of his general summaries. We'll see if Mr. Halfide accepts it.
Okay, we'll continue on that basis, Mr. Steele.
But, sir, just to make clear, I share your uneasiness about this from a legal perspective. I'll return to that later.
I was raising it in respect of the witness and Mr. Finlay representing him in terms of his answering, in terms of what may come or not as a consequence of any answers given. So it's for that reason I was raising it, but Mr. Finlay is comfortable at the minute, so if you continue.
Thank you, sir.
The question fully first, and if there's any concern of leaving Mr. Halfide personally open to any form of repercussion, then I might then intervene.
Mr. Halfide, I've rather forgotten the precise question, but I think it was to this effect, that can we leave this chapter on the basis that you have accepted that a number of documents have not been produced, and I think in answer to an earlier question you said there was a raft of material that had not been produced. I think these were your precise words.
No, I would actually rephrase the summary. We have produced the documents that we hold. Where it says in the column related documents, no document, it may well, my interpretation is that there is no document for us to release. We do not hold it within our corporate repository.
Mr. Halfide, you've already accepted that as speculation, and you do not know that, surely. And in relation to draft documents, you've accepted already that you have not produced them.
In respect, neither of those things is correct. First of all, Mr. Halfide is giving his understanding. Mr. Steele has not established that he was personally responsible for answering the FOI request. He's been giving his understanding throughout. He's quite entitled to give that. And secondly, he hasn't accepted the drafts that haven't been produced, that should have been produced. So no friend needs to be very careful, and I am conscious of the wording of the question there when he asks his questions.
My question was a precise one, sir, that certain drafts have not been produced. I don't accept they shouldn't have been produced, and it may be that that's the answer to it, but as a matter of fact, certain drafts have not been produced. I think we've agreed that earlier.
What I would say is that drafts of these documents do exist. We have not produced them because we do not, if I apply SNH's policy on dealing with FOI requests, we are not required to produce them.
And of course it follows that if that policy is contrary to the law in relation to FOI matters, there are certain difficulties, aren't there?
Certainly not a question you should answer, as my own friend well knew.
Mr. Halfide, core areas are suggested at page 17 for that, and it was suggested by you either in the email that we've talked about or in a discussion. That's about halfway down the page, is that correct?
I can see the use of the word core in relation to a comment that I've made, yes.
Well, you suggested that if it could be argued that the core area was affected, then the regional distinctiveness could be made out. Can you draw our attention, please, or my attention, please, any basis in policy?
I'm really sorry, Mr. Steele. I don't mean to keep interrupting you. I would like to pause proceedings for 5 minutes just to solve this problem because it's becoming quite distracting. Yes. So we'll take a 5-minute break. Mr. Halfide, I don't know if you've been involved in inquiry proceedings before, but you're in a position of purdah right now, so you can't speak to anyone on your side. Okay? We'll take a 5-minute break. It's not you. I'm going to ask you to investigate. Thank you. Okay, sorry to interrupt you, Mr. Steele. I think we've solved the problem. We continue.
Thank you, sir. Mr. Hyde, good afternoon again. Now, core areas, you yourself suggested, in effect, trying to promote an argument about core areas, and that's to be found about halfway down page 17 of the bundle of documents. Is that correct?
Yes, it might be useful if I actually read out what I actually said, which was I suggested that if it could be argued that the core of such an area was affected, then the case of regional distinctiveness could potentially be made.
Now, we've already agreed that you have got no landscape or planning qualifications, but can you tell me, please, anywhere in policy that would justify a core area within your Area 74? Just direct us to some policy or justification for that approach.
That is not what lay behind my suggestion.
Is there any policy that you're aware of that would justify that approach?
No.
Because it is that approach of identifying the core area that led you to suggest that you may be able to argue a case of regional distinctiveness. Is that not accurate?
No, that's not accurate. What led me to make that suggestion was my previous experience of dealing with wind farm cases in areas of where there was a strong regional distinctiveness case accepted, in particular at West Garty, but also at Upper Sonican. I was able to draw on both those cases to suggest to my colleagues that in both those instances, a case was made that within a regional landscape, there were certain parts of that landscape where the regional characteristics were particularly strongly expressed, and the impact of the proposal would be particularly strong on those areas of strong characterisation. I'm not expressing this very well. That was what lay behind my sentence there.
Let's just look at the sentence, please. Mr. Halfide, you'll, with a degree in English, understand it better than I do, I'm sure. Nick suggested that if it could be argued that the core of the area, of such an area was affected, then the case of regional distinctiveness could potentially be made out. The first building block in your approach was to establish the core of the area, was it not?
Yes, and it may help to explain what I mean by the word core, as it's come up often. Core, in my mind, when I said this, did not necessarily mean the middle of an area. What I meant by that, and it is shorthand, was where the characteristics of a regional landscape are particularly strongly expressed. It may not actually be in the middle of a regional landscape area. It may be on the edge, or it may be throughout. It would depend on the particular regional landscape.
Well, I accept that fully. Can I just confirm again, have you accepted that you can point to no policy basis for arguing a core area of, in particular here, at Area 74? Any policy basis for that at all?
The same answer as before. I am not aware of any policy in relation to this particular area.
Have you asked or instructed your staff to promote a core area in respect of any one of the other 74 distinct areas in Scotland?
As I mentioned earlier, I have discussed with colleagues for other cases within regional landscapes where certain characteristics are particularly strongly expressed, which is a longer way of saying that I have, in other areas, looked at where some of those features might be described as core.
And have you produced a core area map in respect of any other area in Scotland?
Not to my knowledge. That's not to say that my colleagues may not have done so, but they haven't brought those forward to me in my role as chair of the National Interest Panel.
You're chairman of the National Interest Panel as well, aren't you?
I am indeed.
So let's just, if we may, get this quickly out of the way, and I'll come back to this just in a minute. You were the person who decided that there should be an objection, is that correct?
I confirmed that SNH would submit an objection in this case.
And is it correct that that decision then had to be ratified by the National Interest Panel?
That is not correct. I convened the National Interest Panel to help me form my decision.
And you are chairman of the National Interest Panel?
Indeed.
So, going back to the question of the core area, one, we're unable to point to any policy about it, and two, you are not aware of any other core area map having been drawn up in relation to any one of the 79 areas in Scotland. Is that accurate?
That is correct.
And is it also accurate that this idea came to you some time after the application was lodged, but before you had decided to object formally?
I'm not sure I've understood the question correctly, but my understanding is, based on my experience of other wind farms, I had a discussion with those leading this case. But the idea of regional distinctiveness was raised long before this case came to my attention, as you see within the chronology.
Now, I'm asking about core areas, Mr. Halfide. The idea of the core area to justify the regional distinctiveness came to you at some time during the application process, did it not?
Yes, I refer you back to one of my previous answers. It occurred to me on the basis of my experience in other wind farms. So the idea of having, within a regional landscape, some aspects being more strongly expressed in some geographic parts than others is a well-known concept with my landscape colleagues.
Can you tell me, please, when was the core area map prepared?
I'm afraid I'd have to check that. I don't know that off the top of my head. Sorry, I can't immediately find a date.
It was prepared, I think, by Fiona, your landscape architect. Is that so?
Indeed.
can we agree that it contains fundamental errors?
Yes, we've already heard evidence about its accuracy.
Are you able to explain how errors of such a magnitude crept into this map or plan?
No, I didn't draw it up, so I'm not able to give an answer to that.
You haven't looked into that to find out how such a blunder could be made?
As I said earlier on, it didn't form a very significant part of the decision-making process.
No, that wasn't my question, Mr. Halfide. My question is, have you not taken steps to find out how such a blunder was made?
Well, I'll answer in a slightly different way. No, I haven't, because it's not that significant to the case that we were making.
Do you accept that we were not aware of its existence until we placed the FOI request?
I can't answer that because I don't know what documents you hadn't seen before you received the FOI bundle.
Well, would you be surprised to discover that we knew nothing of it until the FOI request?
Sorry, I don't have an emotional response to that. I mean, I wasn't surprised or unsurprised, I just didn't know.
Well, you're the director of SNH, and one of the matters that SNH is meant to adhere to is openness and transparency, is it not?
Indeed, we are open and transparent.
So if it be the case that we knew nothing about this plan until the FOI request, what is your opinion about that state of affairs, Mr. Halfide?
This was an internal document that we used, and as I've already said, it was not used very significantly. We have many internal documents that we use, and so it's not unusual for us to have a series of working documents to help form our final statement, and the final statement was the thing that draws all of that together, and that is in the public domain.
Well, I wonder if that's entirely accurate, Mr. Halfide, because what you recorded as suggesting is that if it could be argued that the core of such an area was effective, then you could move on to sustain a regional distinctiveness case. So the core area was absolutely fundamental to that argument, was it not?
It is indeed, but as I've said, what I understand by a core area are where the key elements of a regional landscape are most distinctly shown. And the map that we have referred to on many occasions does indeed begin to hone us in on that area, albeit is inaccurate, and we have acknowledged that.
Well, if it is fundamental to the argument you wish to promote, how is it that you can dismiss it as having little relevance?
The witness didn't dismiss the map as having little relevance. He dismissed the area of the RSA as having little relevance.
Not my understanding, sir, but it's yours that counts.
Well, I haven't noted down here that it was an internal document not to be relied upon very significantly, and it's not unusual to have working documents. So my reading of it was that you didn't place much weight on that particular map. Is that correct?
Yes, as I said earlier on in my evidence, I placed far greater weight on the detailed information and advice from our landscape architects, and also my day in the field going around with landscape architects to look at the proposed wind farm from a number of different viewpoints, both within the proposal, but more significantly from viewpoints including Sanquhar, I haven't said this bit yet, farm at Ochton Taggart, and also on the big Lowther Hills to the south.
Well, let's go back in case either of us have misunderstood the position, Mr. Halfide. Being able to argue that we're in the core of the area was fundamental to establishing the regional distinctiveness case, according to you. That's what's at page 17, is it not?
That is correct.
And that being the case, it was fundamental to establish that we were in a core area, to your argument as you saw it.
It was fundamental for me, when approving the objection, to be certain that the proposal was located within the area of the Lowther Hills that most strongly expressed the regional distinctiveness of this landscape type.
And are you anyway concerned, or indeed even apologetic, that the map produced for these purposes is fundamentally flawed?
I think I would have to refer to my previous answer. I mean, there's a lot has been made of this map in the inquiry, but in the decision-making process with this SNH, this was purely indicative and formed a very small part of the exercise that led to my decision. So it just doesn't have that much weight in me approving an objection.
There's to be no apology forthcoming, is that it?
Sorry, is that a question?
That was intended to be a question. I apologise if it wasn't clear enough.
I don't feel the need to apologise for an internal document that was of little weight. It would have been better had it been more accurate, but it was just not that significant.
And is it correct that that map went to the National Interest Party? National Interest Panel, sorry.
Yes, it is listed as one of the numerous documents that the panel considered.
And was it also stated wrongly to the National Interest Panel that the site lay within the Let me just take you to the document. Get the wording wrong. It also stated in words to the National Interest Panel that the site was within the core key part of the Lowther Hills unit.
It might be useful if I read out the appropriate part, which is on page 44 of the FOI bundle. Fiona Mahoney has prepared a map that attempts to describe in part why the wind farm proposal falls within a core or key part of the SNH Landscapes of Scotland map Lowther Hills unit. That's correct.
Now, if I go back to the FOI request, which is the front page of 8.27, do we see a request to provide the relevant documentation in relation to the map, the Landscape for Scotland map?
I think you're referring to the request under section 2, which says, please provide copies of all reports, advice, notes of meetings and emails relating to the formulation of the map, referred to either from personnel employed by SNH or by any external advisors?
Yes. Indeed I am. Can you draw our attention, please, where you have provided any information to meet that call, to enable us to understand the matter?
No, I'm not able to locate anything.
Is that because we can agree there is no such information provided?
I'm speculating, but this takes me back to where we were talking about FOI before. If we had such information available, we would release it.
You certainly should anyway, shouldn't you, Mr. Halfind?
Well, I'll just go back to what I've just said. Yes, if we had that information, we would release it.
Is it correct that you decided to make an objection on the 25th of August 2017?
That's correct, yeah.
Are you yet able to confirm the date of the core areas plan? Mr Halfine.
Not in the last 15 minutes, no.
And is it correct that the matter was not referred to your national interest panel? Sorry, it was not referred to the balancing decision takers for some number of months?
So I don't understand the question, sorry.
You decided to object on the 25th of August 2017, is that so?
Yes, that's correct.
Yes. Do you, SNH, or you, Mr Halfide, have a duty to carry out, fulfil your balancing duty obligations?
Yes, we do.
Just describe to us very briefly what these are and what's the purpose of that.
Yes, if I could refer the inquiry to document DS14, where we set out in detail what our role is in relation to the balancing duty. Do you want me to go through it? Would that be helpful?
I think we've been through it earlier. I have no need to do that, Mr Halfide. But in broad terms, SNH has to balance various aspects of the proposal, some advantages and disadvantages in deciding whether to object or not. Is that correct?
It's not quite correct, but I'm quite happy to say a little bit further. Our balancing duty requires us to do a number of things. And this is indeed set out in DS 14. Firstly, we have to work out whether or not the particular proposal in question, the case for that has already been agreed either in an Act of Parliament or is set out in an agreed local development plan or in national planning framework. And that doesn't apply in any of these cases. So beyond that, what we have to do is to be aware of the range of other interests that the development will deliver. But equally, we are not required, and indeed we are told not to, seek to balance out all of those in coming to a view on whether to object. The merits of the case are considered in this case by the Energy Consents Unit, or indeed the reporter. And it's clear at the end of DS14 that whilst we need to be aware of all these other interests, those other interests cannot, I'm quoting here, cannot override our primary aims and purposes. And that is further reinforced in a quote, in exercising its regulatory functions, each regulator must contribute to achieving sustainable economic growth, except to the extent that it would be inconsistent with the exercise of those functions to do so. So boiling all that down, our balancing duty means that we have to be aware of these other issues, jobs, impact on archaeology, etc., but they are not material in whether or not we decide to object.
But they have to be weighed in the balance, do they not?
No, they do not need to be weighed in the balance. We have to be aware of them, but they do not impact on whether we decide to object or not.
So the position is this. You decided to object on the 25th of August, and yet the balancing duties were not carried out. The balancing duty assessment was not carried out until the 23rd of October. Is that so? No,
it's not so. It wasn't documented until that later date, but the team were aware of the wider context of the development, and indeed, in its broad scope, that was discussed at the field visit that I went out on. So it was only the actual writing down the documentation that occurred at the later date.
Could we look, please, at the chronology and the date of the 23rd of October? Are we there told that the balancing duty assessment was produced after the 6th of October response and endorsed by you the following day?
That's correct.
As a matter of fact, the balancing duty was carried out in October, and you had decided to object some months earlier.
No, that's not correct. The assessment is an ongoing one that's carried out throughout the consideration of the proposal, all that happened in October was that it was documented for the audit trail.
Does it not say in this chronology that on the 25th of August 2017, you, Director of Operations, made the decision to object?
It does say that, yes.
And if we read the chronology and follow the documentation, is it after that that you suggested changes to the letter to, as it said here, accurately reflect the decision that had been made, although the documentation may say something rather different?
Sorry, could you just refer me to the bit you're suggesting?
As an example, the 5th of October tells us that you offered suggested changes to the letter to bring it into line.
That is correct. Having seen the draft, I suggested that a few refinements needed to be made so that it better reflected the decision that I had made in August.
So the bottom line is this. In August, you made the decision to object, and you're not a landscape architect and you're not a planner.
I can confirm that all of that is true, but I'm not sure what you're inferring from it. Sorry, I may have missed something.
Now, if we look at the documentation, please, and I don't want to get bogged down too much in the detail. Qualified. But if we look at the document at page 15, do we see that deals with both NLEI and Harryburn?
Sorry, page 15 of which document?
The bundle of documents, 8.27.
Yes, I see the reference to Harryburn as well.
And is it accurate to say that in assessing the effects, the two wind farms are run together and effects of both of them are highlighted?
I can confirm that they're both referenced on that page, yes.
And if I take but one example, at the bottom of page 17, it says, from the east, we could highlight the sense of leaving the M74 corridor, that you're quickly into an upland field, becoming increasingly remote and tranquil. This would be reduced by Harryburn, which would be very visible. And then we're talking about the Menop Pass and so on. Is it fair to say that no significant distinction is drawn between the two wind farms? They are both effectively run together.
My reading of this document is that some elements clearly refer individually to Harryburn and some to your application, but there are other occasions when, you're right, the two are considered cumulatively.
Can you explain why we weren't treated in isolation and why we were treated cumulatively, as you fairly put it? Because is there not a danger that confusion could reign?
My experience of these, though I'm not a landscape architect or a planner, is that it's important to consider applications individually, but also important to consider any cumulative impacts that may arise with either existing wind farms or those that might be consented in advance of the one that you are considering.
Now, I have the offending core area map at page 20, which seems to be attached to the back of this, but are you able to confirm whether that is what happened or not? Seems to be attached to the back of the document. Some early thoughts.
I think it's a separate document, but I'm not able to confirm that because mine are all stapled together, but I think it's a separate document.
And I think there's no date on the core area map that gives us any assistance, is there? Certainly not in my copy.
No, not in mine either.
If we then go to page 36, this is a document dated the 31st of July and relates to our proposal alone. Do you have the actual document, Mr. Halfine? I think you'll have to get it if you don't.
You know, page 36, I have it.
And that contains a statement that you will object to the proposal. 31st of July 17.
It is a recommendation, yes, from my landscape colleagues.
To Paul Taylor.
To Mr. Taylor in his capacity as the coordinator of the case, yes.
And is it right to suggest that, broadly speaking, there were three reasons for the objection? One, cumulative issues with Harryburn. Do you see that?
I see that. My reading is slightly different. One is actually, sorry, on page 36, the figure one is actually, there are two issues in there. One is overall adverse effects on key characteristics that define this distinctive area. And the second within that number one are adverse cumulative effects on the proposal in combination with the proposed Harryburn wind farm.
Well, can we agree this, that in one, there's the cumulative effect with Harryburn?
Yes, that is indeed part of one.
And two are the effects on the Mennock Pass? Is that so?
Yes, I can read that, yes.
And three, the effects on the setting of the One Lochhead village. Now, so far as Harryburn is concerned, that's no longer an issue, and so far as the Mennock Pass is concerned, I think it is agreed that that is no longer an issue. Are you aware of that?
Yes, I am aware.
Yeah. The detailed description at page 38 some 10 lines in, at the third paragraph, the proposal is located, etc. Is weight placed on the location of the proposal in relation to the RSA? It's the last full sentence.
Yes, I read it. For me, this is setting the context. So the paragraph begins, the proposal is located within this area. It is bounded, carrying on, bound by the A74. So it's a locational paragraph. I wouldn't say it gives it weight. It simply locates it within the context of the geography and existing designations.
Well, let me look at the sentence I'm interested in. The proposal sits within the RSA, which aligns with the Lead Hills and Lowther Hills SLA across the local authority boundary to form a designated area with a particularly consistent character that defines this key part of the Lowthers. First question, is wrong in relation to the RSA, is it not, that statement, that sentence?
I'm afraid you're getting me into a level of landscape detail that I will struggle with, but I can do my best. Would it help if we referred to another map here?
If you don't know, Mr. Halfine, because time is moving on, if you don't know, just say so. I'm keen to establish the process that was undertaken here, but the information that was given was that the site was within the RSA. That's what's stated here, isn't it?
It is indeed stated.
It's also stated it aligns with the SLA. That's also stated.
Yes, my understanding is saying that the Thornhill Upland Regional Scenic Area aligns with the Lead Hill and Lowther Hills Special Area.
For that reason, it is said that it forms a designated area with a particularly consistent character that defines this key part of the Lowther Hills. Now, if, as a matter of fact, what is stated there is factually inaccurate, that would rather undermine the particularly consistent character point, would it not?
I'm afraid I don't know.
Would you be troubled if that information was wrong?
I'm conscious that the witness is looking for something. Would it help for the witness to look at a particular plan?
But if the witness wishes a few minutes to collect his thoughts or his documents, albeit time is moving on, but these are important points.
What I'm looking for is the map that everyone keeps referring to, and I've had it and I've lost it.
Mr. Halfite, to save time, if you don't know whether it's accurate or inaccurate, so be it. But I can approach the matter hypothetically. If what is stated there is wrong, would that not have an effect on the suggestion, this is a matter of English, on the suggestion that it forms a designated area with a particularly consistent character? Because the justification for that is the RSA and the SLA.
It is indeed part of the information that would have been in front of me, so it has some bearing.
And if it was wrong, that would rather undermine the position, would it not?
I'm afraid I would need to take landscape advice about how significant that fact was in the overall case.
Now, if we then look to page 41 of this document, which is headed up being the response to North Lowther, do we again see reference to Harryburn and the smaller scale scenic glens and the settlements of Warnock Head and Lead Hills, which are visible from key approaches, we are told?
Yes, I can see references to that on this page.
Given that this was a response only in relation to NLEI, why on earth were there references to Harryburn and the approaches to Lead Hills and the likes?
For me, it's the title that's important, the adverse cumulative effects of the proposal. So, as I mentioned earlier on, it would make sense to me that we were looking both at the impacts of NLEI, but also the potential cumulative impacts of another wind farm that was at a slightly more advanced stage in the planning process.
So in taking a value judgment about the NLEI proposal, is it fair to understand that consideration was given to the effects that might flow from Harryburn?
In relation to a cumulative point, yes.
Well, it wasn't just in relation to the cumulative point, because it was also in relation to, in particular, Lead Hills and the approaches to Lead Hills, was it not?
I'm afraid getting into a little bit more detail on the landscape side, but my understanding was that if the Harryburn, you have to look at it cumulatively for both of those communities if both wind farms were to go ahead.
Well, reading this matter fairly, does it appear that some of the effects on Harryburn have been attributed in an assessment of NLEI? Is that a fair assessment of what happened?
I'm not able to answer that question. I don't know the answer.
Is this not the information that you had before you when you decided whether to object or not? This was the recommendation to object. Was it not?
Yes, it was.
You don't know what the report recommending objection means, Mr. Halfite? Is that the position?
No. What I'm struggling with here is the interaction between the two. When I considered this, we indeed did consider the cumulative impact of Harryburn as well as NLEI. Now that Harryburn is not proceeding, that's where I'm struggling a little bit to disentangle the precise information, but when I made the decision, cumulative impact was a significant issue, but obviously it isn't, that element is, as we discussed earlier on, no longer appropriate.
So at the time you took the decision to object, the cumulative effects, the effects from Harryburn were a significant issue. Is that so?
They were a factor.
Well, I think a moment ago you said significant. Mr. Halford, if you still need to find a document, I'm happy to pause because you're looking for something.
What I was looking for was to find our actual response so that I was able to confirm. Sorry, I'm moving between different documents.
Well, meantime, Mr. Halfide, I'm looking at, and I hope we are looking at, the recommendation from Fiona Galloway recommending an objection. And can we approach it in this way, that it ran both Harryburn and NLEI together, not just in relation to overall cumulative effects, but cumulative precise effects on Lead Hills and the surrounding approaches, did it not?
No, I don't think I can agree with that summary. We looked at the NLEI proposal on its own, and we also considered the cumulative impacts of that with Harryburn.
I don't want to take up a lot of time, but is it not perfectly clear if one looks at pages 41, 42 and 43 that approaches to the villages and the setting in particular of Lead Hills were matters that were taken into account?
Indeed.
And can we agree this then, that given that Harryburn has been removed from the picture, a significant element of your concern has been removed?
Yes, one of the bases of the objection is no longer relevant, given that Harryburn is no longer proceeding. The cumulative element in relation to that does fall.
Thank you. And just at the same time, do you also accept that the matter, the concern about the Mennock Pass has also fallen, as you put it?
I would need to refer to the evidence that you took yesterday, where I wasn't, or the day before when I wasn't here on landscape. But generally, I understand that the removal of those 5 turbines has significantly reduced the impact on the Mennock Pass.
Can you help me with this as a matter of process? Given the, I suggest, fundamental changes in relation to the Mennock Pass and your concerns about it previously, why was a further evaluation not taken, and why was the matter not put back into the balancing exercise? Because the scales had tilted, had they not, with the removal of the Mennock Pass issue?
Not in relation to our balancing duty. As I said earlier on, the balancing duty is not as you've described it, and in many ways it's a bit of a red herring, the balancing duty, in relation to whether or not we object. We look, in this instance, just at the landscape information as to whether we objected and as to whether we sustained that objection once those 5 turbines had been removed.
Right. Did I just hear you saying that the balancing duty is a red herring in deciding whether to object or not?
My precise words were a bit of a red herring, because as I explained earlier on, and I would refer you back to the document where we set out in detail how the balancing duty works. And I can go over that again if you want, if that's helpful.
Well, is it right that your approach in relation to balancing duties has more recently changed?
We have indeed refined it recently.
And why has it been refined, as you put it, or changed, as I would put it?
Well, we felt that it had become a bit of a tick box exercise of no value, and I think this inquiry has shown that it had become an administrative exercise where we simply had to fill out a form. What we have now done is to review it, and it's more about behaviours, how we conduct ourselves when we're dealing with applicants, with members of the community, so that we show that we understand the full context, but it hasn't changed the way we use it in relation to individual proposals and how we respond.
And given your new approach, might it not have been all the more important to let us know about the core area and the map that have been drawn up for whatever purpose?
So I don't see how the two are related.
Well, as I understand it, your new instruction in relation to balancing duties is to understand and respect other people's interests, their needs and aspirations. That must include the needs of my clients to understand what on earth your case is, including in particular the map that you had of the core area, which we knew nothing about, surely.
I don't quite follow that because, as I've said on a number of occasions, that map was of little weight in my decision, and our position is very clear in both our letters of objection.
But, Mr. Halford, I don't want to go over old ground, but do you not understand that the map might have been rather important to us? Surely you realise and recognise that.
What I would refer back to is the discussions that, and it's in the chronology that we had, and the point we made at a very early stage, that there were significant challenges in landscape terms from this site, including around regional distinctiveness. And in all the cases I've been involved with, we give this, whatever pre-app advice we give, we expect or hope that the applicant will go away and do further inquiry themselves.
Now, Mr. Halford, that really isn't an answer to the matter. Do you not realise that that map and a knowledge of it and an understanding of it would considerably have assisted us?
What I understand is I don't think there's anything in the map that isn't already in the public domain in terms of the material that it contains.
Mr. Halford, that's simply not right. We did not know of the existence of that map and the core area, which is fundamentally flawed, until the FOI request was made. Surely it would be fair to accept that.
I think what I accept is that the map contains, as I said, information that is already in the public domain. What we did was bring it together so that it would, in some small way, help us in our decision-making. It was equally available for your clients to do the same.
But it wasn't available to us, Mr. Halford, surely.
But the information was available to you.
Let's move on to page 60, Mr. Halford. As director, members of your staff, is that correct?
That is correct.
Yeah. And in that, you wish them to emphasise certain aspects of the case, remove tentative expressions, did you not?
Yes, I asked them to make sure, well, what lies behind this, I asked them to make sure that the drafts fully reflected the decision and the way that I had made it following the National Interest Panel, so it better reflected the decision that I had made.
Mr. Halford, this, was it not, is an email from you to your staff as to what, in effect, they were to say, was it not?
I'll give my answer again. It was an email from me to my staff to make sure that the formal letter of objection correctly reflected the decision that I had made at the National Interest Panel.
And in short, you wanted your staff to fall in behind that decision, did you not?
No, it was my decision and my decision alone, albeit informed by them. I wanted to make sure that the formal record of my decision actually reflected what I had decided.
Now, Mr. Halford, do you understand our concern about the process that has been undertaken here and the errors that have been made? Do you begin to understand that? Is there any expression of regret or apology?
I'm afraid I see it in a completely different way. I see that it's not perfect, what we've done, But I would say about 95% of what we have done is rigorous and professional. There are one or two errors within it, as there always are within a process such as this. But I was struck earlier on, I think, by some of the other evidence that was given that pointed to one or two words, loose phrasing. What struck me was just how professional the majority of the information was that I had been given for my decision-making exercise. So I stand by the process we've gone through, and what I see is staff working hard in a very professional way to deliver very competent advice on behalf of the natural heritage.
Mr. Halford, let me just give you one final opportunity. Would you care in any way to accept the clear errors that have been made and in any way to apologise to my clients for what has happened, or are you just going to refuse to do that?
I've already acknowledged a small number of areas where there have been errors made, but I would equally like again to point to the vast majority of the highly professional material that I was supplied with by my colleagues, on which I was able to then make a judgment.
And the second part of my question was, are you even yet prepared to apologise for those errors?
I regret any errors that were made.
An apology is going too far, is it?
I regret the errors that were made, of course. I apologise for any errors that were made, and I regret that. But there I would again put them in context of a large proportion of very professional work, and I stand by the conclusions that we reached.
Thank you. No further questions. Thank you, sir.
Thank you, Mr. Halfheight. I just have a few questions for you. Now, just picking up on some of your answers, you mentioned the balancing duty, and you took us to document, I think, DS14. I just want to confirm something. You said the first port of call when you were looking at that was whether or not there was any national issue, anything in the national planning frameworks or national development. You also said about local development plans, and I want to understand what you meant by that. Is it allocations or is it something else?
Yeah. I'll refer you to the end of that document in italics, and I'll read out, I'll read a couple of bits from that. There are very limited and specific circumstances in which SNH might decide not to object to a proposal that raises natural heritage issues of national interest. This is where its significant public benefit and importance has already been established and agreed. Examples of this would include where a clear allocation has been made for a proposal in an up-to-date adopted development plan, which I think is your point, where a proposal has been identified as a national development in the national planning framework, or consented in principle through an Act of Parliament.
So, for my purposes, this site, as you know, is shown within the local development plan within a spatial framework, and that area shows that it's not within an area of significant protection. And then another element of the development plan, not the local development plan, but the development plan is the capacity study. And there's been evidence led on that. But those points, they wouldn't come into this balancing exercise. Is that right? It has to specifically be allocations.
Indeed, yes.
Now, in terms of the map, which we've discussed in detail, the one that's been reproduced NEOI 20, and it's also in the FI pack, produced by Fiona Mahoney, is that right? I don't want to produce her name wrong. So, you said the map was of little weight, and what I'm trying to understand here is if it was of little weight, why did Dr. Wimble go to the lengths of finding the area and mapping it in document DS1? Can you answer that?
I can give you a speculative answer only. I think Dr. Wimble did, I presume he did that to provide some clarity, because the original map that Fiona produced with its inaccuracies was not helpful.
So I just want to be clear here as well. It wasn't you that instructed Dr. Wimble then?
No, I did not instruct Dr. Wimble.
Now, you did answer Mr. Steele in terms of identification of core areas. I just want to understand if it's your intention going forward for SNH to identify core areas for each or any of the 79 regional landscapes.
It is not my understanding that we will be doing that. I put a caveat on that because it's not an area for which I have responsibility.
Now, you said to me earlier about field work, and yourself particularly and others, and I'd like to discuss that a little bit. So, looking at the chronology, there's mention of site visits to viewpoints, and there's one reference to the site. Now, my understanding is that you visited viewpoints, and apart from Glengabber Hill, which is mentioned, did you or any of your colleagues carry out a full inspection of the full site within the red line boundary?
I'm not able to answer that exactly. I know for myself I didn't go to all of the viewpoints, but I went to a significant number. What is usual is that our landscape expert will visit all of the viewpoints, but I can't say that definitely because I haven't had that confirmation from her.
Okay, if we go to the chronology and we start at the 12th of July 2017. So that one, I appreciate, that was the previous scheme. 35 turbines included a visit to Lowther Hill viewpoint. That's one viewpoint outside the application site. 14th of July, site visit to key viewpoints along Glengabber Hill in the application site. The Auchentaggart Moor and the Croik Multiverse, which are outside the application site. 21st of July, that's when you took part in the site inspection.
That's correct, yes.
Yes. So site visits to a range of key views, including Lowther Hill, Upper One Head Museum, the Beam Engine, the Southern Upland Way, that's the one that's in the application site, Mennick Pass, Auchentaggart Moor again, and the Sanquhar Golf Course. And then below, Fraser visited this site with Roddy Fairley, area manager, and yourself. During the visit, there was discussion about key landscape concerns, and Nick answered queries on how the case for a regional distinctive landscape objection had been made for other proposals. Now, reference to the site there, is that reference to the site, the viewpoints that are mentioned in the paragraph above, or is that, did you carry out a site inspection across the site within the red line boundary?
That's reference to the viewpoints that in the paragraph above that we visited.
And so yourself and your colleagues, particular landscape architect colleagues, can you tell me how long they may have visited Glengabber Hill for?
From memory, having been to Monlock Head, we drove up the glen beyond the public road and parked. We then walked across the burn, up the hill to the hill, and spent some time with the visuals on top of the hill. So we would have been out on the Southern Upland Way for maybe a couple of hours.
Okay, so to be clear, you drove down what I think is called Church Street or Church Road down to the smelter, and then you crossed the burn and you walked up to Glengabber Hill on the Southern Upland Way, and you spent a few hours in that location.
From memory, that's correct.
And can you recall what the conditions were on the day that you visited?
We had good conditions for most of the day. Towards the end of the day, the mist started to come in, but we had good visibility when we were on the Southern Upland Way, in Monarch Head, the Mennock Pass, Auchentagat Moor, and the Sanquhar Golf Course.
Now, I'm just trying to understand then, it was the same question I put to Dr. Wimble. How could yourself or your team determine that the site itself, the whole site, would have regionally distinctive features if you only visited one location within that site?
Although that was the only time I visited the site, some of those that I had been with know the area extremely well. Dr. Roddy Fairley, who is our area manager, lives locally and through all his life knows these hills well, so he had a very good understanding of the relative topography of this part of the Southern Uplands as compared to other parts. And the landscape advisors that we were with, both on the day and throughout, have long experience of this area, so they were able to draw on that experience and expertise to inform that their consideration.
Right. Now, when I look at it, it wasn't those people you've described that drew the initial plan, though. It was Thank you, I don't want to pronounce it incorrectly. And from this, it looks like she visited the site on one occasion on the 14th of July. So was it sufficient for her to draw the plan that she did, having only visited the site on what's tabled on one occasion?
My understanding that she'd been engaged with this project for over a year before the site visits. So she would have drawn on discussions with colleagues, with Fraser and with Deborah Sandals. She would have looked at other documentation that she would have pulled together. And she was indeed on 2 site visits. No, there was a pre-visit review of LVIA in June and July, in which Fiona spent approximately 1 week in total preparing for site visits. And then she took part in the site visits on the 12th of July and the 14th. So it's the bringing together of her previous knowledge, the knowledge of colleagues, and also of her visits to the site.
So perhaps, although Fiona Omani's on maternity leave, if it would assist to have some information of the amount of time she spent on site, then we could seek to provide that. But, for instance, she went in August 2016 as well. So if that's a matter that you would like information about, we can see whether we can obtain that. But I know there's a reluctance to approach people on maternity leave.
I'm just trying to seek a general idea of what was done in advance of the plan being produced and after. I suppose my final question at that point, Mr. Halfhide, is if that was the case and all these site inspections were done in the wider area, why is it that the plan that was drawn up is drawn so clearly to omit things like the Dalveen Valley or other distinct characteristics in this region?
I don't know if I can answer that. I can't get inside Fiona's head. All I can say that this map is purely indicative and is no substitute for all the other work that we did, and that's why I keep saying we didn't attach much weight to it, because the more detailed written advice that we had from our landscape colleagues, but crucially all these site visits that, I only did 1 day, but as you'll see from the chronology, if we added up all the number of days, people days we had on site, that's considerable. And that's on top of existing knowledge of the wider area that I mentioned that Dr. Fairley in particular was able to bring to the site through growing up in the area and working locally. It was bringing all of that together.
Right, that's all the questions for myself. Mr. Finlay.
Just a few, given the time. You remember Mr. Steele was going through his FOI chapter of cross-examination. He identified some documents. In terms of the handwritten documents, just taking them generally, do you know whether they even still exist?
I don't know whether they exist or not.
In terms of the documents that are referred to in Mr. Taylor's note, I think there were two of them, has there been at any stage a request for those documents, even though the applicants have had notice of them since April of this year?
Not to my knowledge.
If there had been, would there have been any reason why you wouldn't have carried out a further search for them?
Absolutely none. We had a lot of FOI requests, and we have a very rigorous and professional approach to dealing with each and every one of those requests.
Pointed out to you that no documents have been produced in respect to the production of the maps of Scotland. Was there any follow-up request or appeal in respect of that, of which you're aware?
Not that I'm aware of.
You may not know the answer to this, but do you know whether the error on the map on which you spent so much time today was pointed out in any of the applicant's written evidence?
I don't know the answer to that question.
Okay, that's a point I can deal with in submission. Yes, you were asked a particular question, a series of questions about Harryburn. Could you see the letter of objection, which is CD 234?
Sorry, I might need a copy of that.
Yeah, I think whilst Mr. Innes is getting it for you, it's the letter of objection. The letter of objection, as you will see in due course, is split between an objection and then other areas in which S&H offer advice. What's the distinction between those two?
I can talk to that generally. When we're considering any planning application, we are in effect giving advice throughout. In some circumstances, we consider that advice to be so significant that we attach the word objection to it. So when we object, we think that the impacts are really very significant of national interest. Beyond that, we will often give advice that is still important, but which we don't necessarily think is of national interest, but which we think the decision maker should be aware as they seek to balance up all of the interests in a particular case.
I don't think we'll need the letter in the light of that helpful answer. If the reference to Harryburn and the cumulative impact falls in the advice section of the letter, how important was it then to the decision to object?
We would divide our letter into those elements which we consider to be so significant that they form an objection, and there will be a separate section where we are giving advice, which can often be quite strong, but is still advice only, and they are separate elements within the letter. I'm not sure I've answered the question.
I'm not going to put it to you again. That's a satisfaction for my purposes. The reporter asked a number of questions about the amount of time spent on site. Is that something that, in terms of ascertaining the impacts of a proposal, in your experience for other wind farms, is it important for you to have walked the full length and breadth of a site?
In my experience, it's really, really important for myself. I understand the weight of the decision that I'm making. To object has very significant implications, and I understand that fully, and I always try, if at all possible, to go out on site, particularly when it's a landscape issue, because there's absolutely no substitute for seeing the proposal in the cold light of day. And it's because I go out on site that in some instances I have not supported an objection. But equally, in some cases I go out on site and I see the full potential impact of the proposal, and that will help inform the decision that I have to make.
And just to make it clear, did you go out for separate site visits for Harryburn and NLEI, or did you do two together?
It was the same day.
Same day. And was it the same core area, for using that as shorthand, that you were concerned about for both applications?
We looked at them separately, but also looked at them cumulatively. So we went around the viewpoints, I'm not sure necessarily in this order, but for Harryburn, and then for NLEI, and in so doing, we also cross-referenced, so we looked at the cumulative impact of each of them on the other, although it was more about the cumulative impacts on Harryburn on NLEI from memory.
Actually, it's probably an unfair question. I think I asked Dr. Wimble about it in any event, so I needn't pursue that. You were asked by Mr. Steele whether there was a policy behind core areas, and you said no, and appeared unconcerned about the absence of a policy. Do you consider, what is your view about whether there needs to be a policy in order to ascertain where the most distinctive area within a region is, or whether there is an area that expresses the distinctiveness of a region and particularly strongly?
It doesn't bother me. It strikes me that it would be a huge amount of work to go through each of the regionally distinctive landscapes of Scotland, when actually there are relatively few cases where there's likely to be a case that we're looking at for a wind farm. As I said, there's only been 5 in the last, actually 5 that I've approved objections to, and then a couple that I haven't. So there's a relatively small number that fall within that category, and for which there's really quite a high bar.
And again, just coming back to the issue of site visits, did you or your staff make any noticeable difference in the approach to site visits in this case than for West Garty or Upper Sonican or indeed Harryburn?
No, as in all cases, I can only speak for myself. I try and spend a whole day looking at the site from each site from various different locations, and I expect that the staff who show me around have also already been out on site, and they come armed with all the visuals. So usually we get up a hill and the wind's blowing. We're trying to get these large visuals out so that we can hold them at arm's length as instructed and try and picture the proposal within that landscape.
I'm not going to ask you to apologise for the size of the SNH visuals or the injuries that they cause to people, but I sympathise with your predicament. Thank you very much, Mr. Halfhide. Those are all my questions.
Right, thank you, Mr. Halfhide. That brings to a close the inquiry session on SNH internal procedures. If we could take a 10-minute break just now, and then I'll ask Mr. Mundell if you want to make yourself comfortable at the witness table. Thank you. We're reverting back to the socioeconomics inquiry session and our final witness of indeed the entire inquiry programme that we've had. So, Mr. Mundell, I'm going to ask you, you have your precognition, if you'd like to introduce yourself and read through the precognition. Thank you.
Could I begin by thanking the reporter and the inquiry for your indulgence with my evidence. Obviously, I was not in control of my own availability, so I thank you very much for your flexibility in that regard. I am David Mundell. I am the Member of Parliament for Dumfriesshire, Clydesdale and Tweeddale, which includes the communities of Sanquhar, Wanlockhead and Lead Hills, and I have been so since 2005. Before that, I was a member of the Scottish Parliament for the South of Scotland region, which also included those communities between 1999 and 2005. Following my original submission, my views remain abundantly clear. As a Member of Parliament for Dumfriesshire, Clydesdale and Tweeddale, I am keen to reiterate my objections in the strongest possible terms to the proposed Lowther Hills wind farm in my constituency. I believe that local people deserve the right to decide what is best for their area, and I am clear constituents affected by this development overwhelmingly oppose it. I believe the area has been saturated by wind farm developments and the landscape overwhelmed by turbines. Indeed, my constituency holds more large-scale wind farm developments than any other in the United Kingdom. The proposed wind farm will detract from the approach to and setting of Wanlock Head and Lead Hills, and will be visible from higher ground surrounding both villages, and will have a serious and adverse impact on the Mennock Pass. Wanlock Head itself is a conservation area, has designated ancient monument sites, and there are also areas covered in SSIs with nesting sites of rare birds and other areas of historic and geological interest in the area, the protection of which and enjoyment of which will be compromised by this development and its construction. I also believe this can only have a negative effect on tourism in the area, the Southern Upland Way in particular, and the opportunities for further tourism development and related jobs. Tourism is identified as an essential to the future of the local economy in Upper Nithsdale. I'm also concerned about the prospect of water contamination by heavy metals and toxic chemicals as a result of the construction of this wind farm because of previous mining in the area. I understand that such issues have been raised with SEPA. There's a threat too to peat deposits in the vicinity, which is contrary to the Scottish Government's stated policies. I do not consider that the environmental reports adequately cover these issues. Finally, I think the cumulative impact of this development with other permitted or applied for wind farm developments in Upper Nithsdale, East Ayrshire and South Lanarkshire, particularly the neighbouring proposed development in Harryburn, are taken into consideration. Of course, since I made the original recognition, as we've heard in the earlier evidence, the Harryburn application has been refused. My constituents feel that they have taken more than their fair share of wind farm development, and the area is being overwhelmed by turbines. The character of these remote rural communities is being changed by these wind farms, and my constituents therefore feel strongly that this development should not proceed.
Thank you, Mr. Mundell. Now, Mr. Godfrey, Ms. Richford, do you have any clarifying points or anything that you would like to draw out from the witness?
I just have one brief clarifying point. Mr. Mundell, you've been an MSP and then an MP for this area for a good number of years. The views you expressed, are they on behalf of your constituents alone, or are they on your behalf as well, or both?
They are both, but they are particularly in respect of constituents in the communities of Lead Hills and Wanlock Head, who have overwhelmingly expressed a view, both to me and in other fora, that they are opposed to these developments. And I think to me, it's extremely important that these small and very distinct communities should have their voice heard. And that's what the planning process is about. The planning process isn't about the majority. It's about ensuring that everyone is heard and fairly represented in that process, and that's what I'm seeking to do.
Right. Thank you, Mr. Mundell. No further questions.
Thank you, Mr. Godfrey. Mr. Steele, do you have any questions in cross-examination?
Just one or two. Mr. Mundell, community having their voice heard, are you aware that Mr. Godfrey has been here throughout and has certainly had his voice heard, and I rather think he's enjoyed it as well, and has presented evidence on every topic and listened to evidence about everything. So I think it is fair to say that the Wanlock Head and Lead Hills communities have indeed been heard. So I take it you're supportive of that.
I am, and I'm very supportive of Mr. Godfrey, and congratulate him today on his efforts in relation to the Harryburn inquiry and ensuring an outcome which the community wanted to see there.
And so did we, by the way, Mr. Mundell, so suits us very well. Now, I don't intend to ask you questions about all of these matters, Mr. Mundell, because you have been in another much more important place dealing with much more important matters, and you have not heard all of our evidence. Is that in fact?
That is.
I don't think you've heard any of our evidence.
Well, the latter point is correct. The relative importance I leave for others to judge.
fair comment. But insofar as your evidence is concerned, there are a number of factual inaccuracies which I don't propose to take up with you. For instance, as one example, the men of Pass, there is agreement between the parties that there will be no significant effects now. Were you aware of that?
I wasn't aware of that. I was aware that there was some difference of views as to what might constitute the Menic Pass as such, and therefore, in my own view, which I clearly isn't necessarily the view of the parties, as you emerge from the Menic Pass into Wanlock Head, for me that is part of the consideration and enjoyment of the Menic Pass. So whilst a number of turbines that were going to have a more direct effect on the Menic Pass have been removed, my own mindset was as I've stated, but I understand the point that you're making, Mr. Steele, in relation to what the parties have agreed.
Right. Just finally, in relation to voices heard, you represent the community of Sanquhar, do you not?
I do indeed.
And I assume that you advocate that they should also have their voice and opinion heard as well.
I do. I do fully respect the views of the community in Sanquhar, but I'm very clear, and particularly reinforced by the opportunity to visit extensively the site with the reporter and others, that it is the community of Wanlock Head that is primarily and significantly affected by this proposal.
That's as may be, but can we agree that the community of Sanquhar are supportive of this proposal and their voice should be heard in that regard in the balancing exercise?
Their voice most certainly should be heard, but my view is that the community of Wanlock Head in particular, but the neighbouring community of Lead Hills, are the communities which will be directly and significantly and for a time coming affected by this development, and that their views in any balancing should be given due weight.
Do you see that the people of Lead Hills will be significantly impacted by this, Mr. Mundell?
Clearly, Lead Hills is not as affected in the now that the Harryburn development has been removed, because I think, and as I think has been discussed elsewhere, there's a concept that the two communities were being surrounded by wind development. But for those people, particularly those people from Lead Hills who travel to and from Sanquhar or through Wanlock Head, they will still have visual impact of this development. And for most of those people, they also have very significant visual impact of wind farms should they travel to Abington or to Elvin Foot. So the concept of your community being surrounded by wind farm development, I think, is one that does apply to Lead Hills.
So your concern relates to Lead Hills as well as Wanlock Head, is that so?
Yes.
Fine, thank you. No further questions.
Right, thank you, Mr. Steele. I just have one question, Mr. Mundell. I think you've already covered it, but I'd like to refer to this plan. It was produced by one of the landscape architects for the applicant, JW7. Now, this plan shows the combined visibility of both the North Lowther and Harryburn wind farms, but it also shows in blue the North Lowther blade tips, which would be theoretically visible on the road. And I want to understand, in terms of your reference to the Menic Pass, you've described this blue area, as far as I'm aware, which passes through the village of Wanlock Head. Is that correct? And is that the only part of the Mennick Pass that you're concerned about?
That is the part of the Mennick Pass that I'm now concerned about. I went at the point of my initial submission. Obviously, there were the 5 turbines that have been removed, but I still regard the the pass as being, from my perspective, and I understand what Mr. Steele said in relation to what the parties may or may not have agreed constitutes the pass. I regard that part as being part of the pass for the purposes of those enjoying that journey.
Thank you, Mr. Mundell. Any points of clarification, Mr. Godfrey, for re-examination?
No, sir.
No. In that case, thank you, Mr. Mundell, for your evidence. Now, that concludes the inquiry sessions. Can we take a 5-minute break and we'll just gather everyone around for the hearing session on conditions? Is 5 minutes sufficient for everyone?
If possible, perhaps 10 minutes, sir, because you probably want to move tables around as well if you want a less formal.
I'm not proposing to move tables, but we'll take 10 minutes and we'll just sit where we are.
I will not attend the condition session because I haven't been involved in that. Mr. Innes will deal with it. There was one procedural matter, sir. We were going to lodge additional evidence in relation to a particular point. The nuclear facility.
Well, yes. I have quite a few procedural matters to follow up, and I was going to do that at the end of all the sessions. Are you staying here, or would you prefer that I do those first?
I wasn't intending to stay for the condition session because I've got nothing to add, but on the other hand, if I'm required to do so, so be it. But it is a matter for you, sir.
Well, I'll get Mr. Finlay and, yes, to sit down, and then we can go over these 4, well, I think it might just be, it is 4 quick points. Thank you, Mr. Miller. And then we can have the hearing session after a 10-minute break. So the first procedural point is document NLEI 30. It was initially agreed. I'm just confirming now that has full agreement, Mr. Finlay.
Yes, sir.
Now, in terms of the table that I asked to be produced, where are we at with that?
So we have a draft, which is very much a draft. So, what I was proposing to do was to give it to you for you to have a look at, even very just briefly, over the 10-minute adjournment to see whether it was on the right lines or not. I don't know whether Mr. Van Grieken or Mr. Welsh have taken up my suggestion that they discuss it with Dr. Wimble after Mr. Harpide's cross-examination.
Just on that point, I think we would prefer to see it before anything is handed to you, because I haven't seen it, and I'm not sure that anybody at this side of the room has seen it. Well, so I think we would like to...
It's a document that you requested, sir, so unless you say it, we're not relying on it. There's no new material in it. There are some assumptions made in it. It's just for you to hand to you, for you to then hand back to me to see whether it's on the right lines. There's no point in you holding on to a draft.
No, I'm happy for Dr. Wimble and the other landscape architects to come together in this table and show it to me briefly together, and then I will tell you one way or another. And then my suggestion is we set a date to which you can submit that document and give you a reasonable amount of time to do that. When would be a week? Would that be sufficient, say a week on Friday, to produce that document? I would assume that you would both agree that what is in it is factually correct in terms of the information that's been submitted to the inquiry. And I'm just proposing, as we've done for other agreed statements, you could work collaboratively and produce that a week on Friday. Okay, I will have a look at that with you in the 10-minute break, and then we can confirm the date for you to submit that. Now, the other matter, of course, is to do with Eskdale Muir. Now, Mr. Steele, you're going to tell me whether or not you are comfortable with written submissions on that.
Well, sir, I think we're comfortable to lodge additional evidence with you, technically speaking, and I was going to propose a period of, say, 2 weeks to draw the information together, 2 weeks for both parties, to give a little bit of time to assess and assimilate the relevant information.
In general terms, very happy with that. I'm not sure whether that may have an impact on the timetable for closing submissions.
Well, you've got ahead of me, so yes. My proposal is I would produce, like we normally would, a procedure notice. That will give you 14 days to comment on the items that I list within the procedure notice, and then 14 days for both of you to reply at the same time. I mean, if you reply earlier, that's great, but you have that period of time. That, of course, then has a knock-on effect for the closing submissions. So I was going to propose that within that procedure notice, I set out new dates for the closing submissions, which I would take as 2 weeks beyond the procedure notice for the objecting parties and 2 weeks beyond that for the applicant. Is that an agreeable way forward?
It sounds very sensible as far as I'm concerned.
Okay, that's agreed. Those are all the procedure matters I have. Other than the one further point was that you'll recall Mr. Mackay gave evidence from the Scottish Rights of Way Society. That was his final inquiry. He told us in the office recently he won't be coming back, so I'd like to thank him for his participation in not only this inquiry but others. Thank you. So 10 minutes, we'll come back and have the hearing session. Unless Mr. Steele, you have something else?
Just simply, sir, for closing submissions, I didn't quite hear what you said, but is that to be moved back 2 weeks for both of us, or is that dependent on an earlier date? Not yet.
Yes, what I'm proposing to do is, when I can't tell you when exactly the procedure notice will go out, because I'll have to draft a procedure notice, put it into our office, and they will have to draft it and send it out to parties. That procedure notice, for the purposes of this inquiry, will only go, I would suggest, to the applicant and to the council, not to an SNH or the other parties, because they haven't raised the issue with Eskdale Muir. There will be a 2-week period for you to comment, a 2-week reply period, and beyond that, I would give 2 weeks for the objecting parties to provide the closing submissions, and 2 weeks beyond that for the applicant.
Very happy if that's the way you wish to do it, sir, but do we actually need a procedure notice to do that, or could we not agree now? Or it may be you have a reason for doing the procedure notice. That
I think for openness and transparency, it would be clearer to use the process that we adopt normally by issuing a procedure notice, and then there can be no ambiguity about the information I'm seeking.
if that's the way you prefer to do it, sir, yes.
Okay, and as I said, within that procedure notice, I will set out the new timetable for when closing submissions should come in. Okay, thank you. Right, we'll take a 10-minute break. Thank you. Mr. Godfrey, yes.
Mr. Edwards, could I have some perhaps guidance on the scope of what can and cannot be included within the closing submission, please?
Well, it may be that the two Queen's Counsel here can give you further information on what should be in your closing, or Mr. Innes there. But essentially, it should be your arguments and your findings from what has happened, from the evidence that we've had. You don't necessarily have to repeat yourself from what you've submitted before. Mr. Finlay, thank you.
I was going to say that, absolutely, sir. I think the main thing is that no new material can come in.
So indeed, there should be a summary of the evidence so far and nothing new. Otherwise, it's possible some people might react to that, Mr. Godfrey.
Certainly. Right, thank you.
You're welcome. Right, we'll take a 10-minute break and resume at 10 to 6. And for those leaving, thank you for your participation. Right. Firstly, just picking up on those procedural points, I've had a chat with Dr. Wimble and Mr. Van Grieken, and they've agreed to produce a table, factual table of the information a week on Friday. Is that acceptable, Mr. Finlay, and noted? Yes. I'm not going to, there's no procedure notice required for that. I'm simply requesting that. If it comes in before that, that's fine. If not, a week on Friday. Is that noted, Mr. Innes?
Yes, thank you, sir.
Thank you. Right, well, good afternoon, everyone. You should now all be familiar with the inquiry environment. However, this is the first and only hearing session we're holding, and the arrangements are slightly different. In contrast to an inquiry, a hearing session is less formal, with participants providing input into a discussion which is led by me following an agenda, which I've circulated. Now, everybody has a copy of that agenda? Excellent. Now, I'm not going to bother introducing you. I can, well, actually, if you'd like to start here with the applicant of who's going to take part in the hearing session, thank you.
Yes, good evening, sir. My name's Colin Innes. I'm a partner in the law firm of Sheffield Wedderburn. I'll be appearing at this hearing session together with Ian Sims from Baber.
Okay, and on this side of the table?
James Finlay and Andrew Robinson.
And from the One Lockhead Village Council, Lead Hills Community Council?
Gerard Godfrey and Andrew Richford.
Thank you very much. Now, we'll work our way through the agenda. So we've covered item 1, the purpose and introductions. In terms of item 2, can parties give me an overview of where we're at with the agreed conditions? I have a CD 15.16A, which was submitted at the start of the inquiry, and my understanding is this is the most agreed document that we have.
Well, what the document should have, it should have the original conditions that were submitted, and thereafter there was a round of further consultation with parties to this inquiry, and also those consultees which you named in the pre-examination note number 2. From that process, 5 responses were received. We then undertook a review of the comments and made alterations to a number of conditions to take into account comments that were made by the consultees. These were then forwarded to the Council, who agreed those, and insofar as the outstanding matters with the Council are concerned, they only rate to condition 1, 5 and 9 insofar as they're set out in the document.
Thank you, Mr. Innes. And that's your understanding, Mr. Finlay, this is the most agreed document that we can have?
Mr. Robinson is going to be the prime speaker in this event.
Right, thank you. Moving on to item 3 then, conditions to be attached to section 36 consent. My idea here is we're just going to move through the conditions in turn swiftly if we can. So, condition 1, that's duration of consent. Can I ask the applicant, why do you seek a 30-year consent?
30 years is becoming a more standard, certainly from our perspective, a more standard operational duration. In terms of the impacts, I don't think there's a great difference between 25 and 30 years. I don't think any assessments have really been based on 25 years that would be changed by switching to 30 years. More generally in the industry, turbines are now able to operate for 30 years. We're comfortable that we can operate a site for 30 years. The 25 had historically been based on the sort of assumed lifespan of a wind turbine and how long it might usefully operate. We think that can now 30 years quite comfortably. Moving on from that, there is also a viability point in 30 years in that with the removal of subsidy, with the need to compete in the current energy markets and the future energy market, having 30 years of operation does allow a project to clear that test, to clear that viability test.
Thank you, Mr. Sims. Just to confirm, are you saying that if there was only a 25-year consent, the project wouldn't be viable?
No. In terms of taking investment decisions, it's far easier to do that for 30 years. Likewise, the benefits increase, the community benefit would continue on the back of that.
So just on the framework for delivering that, the application letter did not specify a time limit, but I would have to acknowledge that in the environmental statement in the FEI, the period of 25 years is mentioned. Insofar as the application is concerned, it didn't say it was for 25 years. I think it's probably better if we deal with it in submission, but it's not uncommon at this stage when we're considering matters either in life extension terms or indeed in other terms to seek extended periods, and those frequently are screened out. And in the context of this inquiry, you will obviously have to have regard to the full environmental effects, and those which are significant. Insofar as the enduring significant ones, they are likely to be obviously certain of the landscape and visual ones, which are on an ongoing basis, and equally certain of the cultural heritage impacts that have been identified and specified. And those would obviously be on an ongoing basis. So what the consideration is does a further 5 years make a difference to that? And generally speaking, I would say the position has been resolved in the answer no. And it is a matter of discretion, and the decision maker has that discretion at this stage of the process.
Mr. Robinson, do you have any comment in terms of what's your concern with extending it to a 30-year consent?
Our only concern was the legality of it in terms of the EIA regulations. Obviously, the EIA has been produced and assessed based on a 25-year consent, if you like. So that is really our main concern. I would accept whether the impacts from in a 5-year, from 25 years to 30 years, whether the impacts would be that great. I'd accept it. It probably wouldn't be, whether it's 25 years or 30 years, but it really is just a case of whether that the EIA has covered that scope sufficiently.
Thank you. Mr. Finlay, in terms of the legal point made there, do you have any comment?
Well, yes. I think I accept Mr. Innes's point that it's a matter for your discretion, but the point I would make is the EIA does require some certainty. So if you're uncertain, there is an issue. And as Mr. Robinson has indicated, our concern is not with 25 or 30 years as a matter of principle. It's a matter of the underlying legality. So that's why we've raised it, not for any other reason.
Mr. Godfrey, you have any comment about whether or not there's a 25 or 30-year period for consent?
Well, yes, I have, as a laywoman and also as a villager, is that I'm imagining 30 years, and at the end, I mean, that's 2 generations already, and if at the end of that there's an extension in the lifetime of the wind farm, then we're talking about a perpetual view, so there is not the opportunity ever of that, being decommissioned, because technology will increase, and they, I'm assuming, but I would look at it as, 5 years is a long time. I feel.
Okay, thank you, Mr. Godfrey. Any comments?
It seems to me that in terms of the whole process that we've gone through so far, if the scheme is unviable unless it's 30 years, it does seem to be a sort of waste of everybody's time. But obviously we're in your hands, and I personally have got no strong view over it.
Okay, thank you. Any comment in return, Mr. Innes?
I just think if you look at the onshore wind farm policy statement, it's very clear that the economic considerations regarding the development of onshore wind is a key concern of the Scottish ministers. We are not saying that it wouldn't be viable at 25, but having 30 is likely to improve viability in terms of an investment decision. That is all.
Okay, in terms of the actual policy wording, is there any conflict between the first sentence, which refers to the date of final commissioning, and the second sentence, which refers to the date of the first commissioning?
Probably yes.
So, which should it be, final or first?
Usually expressed as final.
Is that your understanding, Mr. Robinson?
Just to clarify, is that the second, in the second sentence it should read final rather than first?
Yeah, is that your understanding?
I suppose if it's actually for a duration of 30 years, then that it would have to be that. It would have to be the date of final commissioning and then, written confirmation of the date of... No, hold on a minute. Written date of the date of first commissioning. So that is when the wind farm would become operational.
There is a problem if you have final commissioning, because you may never build your... I mean, there's the hypothetical that you build 29 out of 30 turbines, so you never commission finally. So I understand why it's not to be on the first turbine being constructed, which is, I understand, why it's commissioning. So for the wind farm to operate at all, you have to have a first commissioning. The final commissioning is an uncertain event unless properly defined. I'm really, and so it would be the condition would be uncertain.
Well, I could perhaps help you with the definitions, because why we have date of first commissioning is that it sets the date when the first export to the grid network. And at the back of the document, we get the date of final commission, means the earlier of one, the date of which electricity is exported to the grid in a commercial business for the last wind turbine forming part of the development directed in accordance with the consent, or two, the date following 18 months from the date of first commissioning. So it actually deals with that particular issue.
Yeah. Very grateful.
So the wording in this condition is correct then?
Because the notice comes to us on first commissioning, so it effectively sets the clock running for either 18 months or the so it is right.
Thank you. I'm glad we clarified that. You can see why I asked. Okay, is there any comments in terms of the second condition, commencement of development? No. Okay. The third condition, non-assignment? No. Serious incident reporting, any comments? Right. In terms of the fifth condition on aviation radar, can I ask what is the concern of the Council regarding the wording changes proposed?
It's purely from a visual impacts perspective. The way that the condition is worded is it would actually allow the turbine structure to be erected, and then we wouldn't want to be in a position where, for any reasons, not to say this would happen, it's just to point out that it could, that there was any difficulty in the radar mitigation scheme actually being implemented. We wouldn't want to be in a position where we've got sort of half-built turbines in the landscape for an unspecified period of time. And the condition that we've suggested is actually one that we've had with NATS and attached to wind farm applications quite consistently. And I think it was the same as what was agreed at the Harryburn one. There's obviously been a change in that, and that is purely the reason why it's really just down to mitigate a potential visual impact.
Mr. Innes, Mr. Simmons.
Well, if I could start off by just setting out the context. In terms of radar mitigation, it is a key issue for the delivery of the project. And what would happen, and this sits behind the planning system, is there are contracts in place between ourselves and the relevant operator. And effectively, what this condition here does is it supplements, in a public sense, that commitment. Insofar as what happens is that, effectively, as part of our construction process, we'll have to be satisfied that the radar mitigation scheme can actually be implemented before we buy turbines and start delivery of them. And so in that context, it is a key commercial issue that we'll have to be resolved at that stage. What NATS are saying is that in terms of the latter part of when they actually need to switch the switch and put the mitigation on, it's at the point that the blades turn. Prior to that, they would not switch the switch on because there's no necessity to do so. And insofar as the contract would be concerned, we would have contractual provisions covering these and the timing. And in that context, it's not a problem in practice. But the difficulty is I cannot control when effectively the operator turns it on. That's a matter for them to turn on. And what this does is it essentially gives the operator a carte blanche, whereas before, once we have got our contract in place, all that we need to have is a contractual provision that we won't correct blades until it's in place, and we'll make sure it is delivered. It's a very standard process. And as I say, if we're actually having to implement the thing whilst we're actually just putting essentially the towers up, it's not required from an aviation perspective at that point. So it's a question of necessity. The point at which it becomes necessary is when the blades start turning and the mitigation has to be in place. And quite frankly, it should be at the right time when it's required. That's a fairly standard provision in terms of a consenting provision.
Sorry, I'm just thinking about this 1 second in terms of the process. I wondered if it was to do with efficiency, that you were trying to get ahead of the game and get on with developing the site prior to putting the blades on and having this radar mitigation scheme in place. But reading the policy, the condition, so the bits underlined in blue, those are the additions from the planning authority, is that right? Yes. Okay, that makes sense. Mr. Robinson, do you have any further comment in terms of that condition?
No, I don't. I get it from an aviation perspective. We're just looking at the implications of the wording of the condition in the whole round, and that's really why we've made that suggestion.
And Mr. Innes, would there be any difficulty if I was to revert the condition and suggest that to ministers as it was originally written?
No, as it was originally written was as we agreed it with NATS. And NATS, in terms of the revised version, came back and said we prefer the original version because that's when it's needed. And we got a letter from NATS as part of that process.
Okay, thank you. Anything else on condition 5? Right, now, we had a discussion earlier in the week about the Hen Harrier project officer, and Mr. Bell suggested that that might be inserted as a Section 36 condition. Is that the case, Mr. Innes? And in which case, what, if any, of the wording, I guess, from condition 20 under the planning conditions should I incorporate?
I don't think it matters greatly as to who is likely to want to be involved. Insofar as condition 20 is concerned, what we've set out is a provision for the outline conservation plan to be delivered. Insofar as that relates, It is both in relation to on-site activities, which are essentially as identified. What the condition goes on to say is that shall follow the principles in the Land Conservation Plan and shall include the appointment of the Conservation Hen Harrier Officer, incorporated, provided for in terms of the approved HMP. And just to put it in context, I think we heard evidence yesterday. If I put it together, we've got on-site stuff that we're doing to benefit the particular species in question. I don't really want to go into the details of that. I don't want to have to switch the recording off. Insofar as the evidence that was given yesterday that wasn't recorded, there were certain indications that after the particular breeding period, the particular species dispersed, and a particular issue was identified by the dispersal of the birds off-site. And part of the role of the hen harrier officer is to try and address systemic issues in relation to how the particular species in question is dealt with off-site. And it's clear from the evidence that that is a material issue in terms of the particular species in question. And one of the points about, if I could take contrast, quite a lot of wind farm applications that I've dealt with have focused only on providing mitigation on-site. But if that effect can go off-site, and there is the potential for that, then that's how you get a biodiversity benefit, by addressing that. And that's the distinction I draw. And I don't think it matters where it comes. It could be a Section 36 condition, or it could be a planning condition. Both are perfectly competent. I mean, my experience of managing these things is it tends to be a local authority approval mechanism, because they actually have, well, perhaps not in this case, but people with some expertise in relation to dealing with these matters. Whereas if you look at the Section 36 consent conditions, they generally don't extensively discharge conditions. They have a particular interest in aviation issues, given the national interest involved there. But in terms of who's involved here, I'm, in terms of the condition as drafted, involving SNH, RSPB and the Planning Authority would seem to be sensible, given that some of the matters in that plan engage matters such as education, service and others. That seems to me a classic case where the Planning Authority quite rightly will have knowledge and understanding that can actually help implement the habitat management plan as set out.
Thank you. I think that I understand the reasons for this condition. It's simply back to what Mr. Bell said in terms of the 6 tests that we're aware of, and whether or not, one, this is a necessary condition, part of the condition, and whether or not it's enforceable. And I think in his view, he suggested possibly under, I can't remember, I think it was Section 36(2) or something, that ministers might have more powers to enforce something under there than under the Planning Act.
We'll cover it in legal submission in our closing submissions, but I drafted Condition 20 and I'm perfectly comfortable with its terms. I think it's valid and enforceable, and I think if one reads the evidence as a whole, and the evidence particularly from ornithological experts, there are issues off-site. And all I can say is there would be little point in doing everything we could to improve the production from our site if, at the end of the day, the wider issues are not adequately resolved. And that also means trying to pull together the information. I mean, that is the purpose of having somebody dedicated to it. There are other programs, for example, the Clyde Wind Farm on the same species.
I completely understand the reason for the condition. I'm looking at the mechanism of actually implementing this officer, and what would happen if the officer wasn't appointed. What action could the Planning Authority take?
Breach of condition notice.
Well, okay. Mr. Robinson, any comments?
A breach of condition notice, there is a power to serve it. The actual enforcement of it is very, very, it can be dependent on whether if you serve a breach of condition notice, it's not complied with, and then you submit it to the Procurator Fiscal, you have this whole issue of whether they'll even accept it, and then if they don't, it falls by the wayside. So that is where it can be difficult to enforce such a thing. I mean, yes, we could serve a breach of, only if it's in the public domain, though. I mean, if nobody was to actually submit a letter of complaint on it, we wouldn't be really justified in serving an enforcement notice. We have to demonstrate that something's in the public domain and part of our enforcement charter.
Okay, I mean, taking it slightly further, the council had no issue with condition 20 as it's written, though.
I don't have, no, I mean, it looks very similar to the sort of conditions we attach for habitat management plans anyway, so I don't have any issue with the whole principle of it. There is a question mark over the enforcement of appointment of a conservation hen harrier officer. That is a grey area, I'd admit that. But generally, we don't have any issue with that condition and consider it's pretty standard, to be honest.
Any other comment on that before we move on? Oh, Mr. Innes.
I've got no comment on that. I think it's largely a legal matter to be resolved.
Who will be paying for the officer?
Unless
I missed it.
It would be the applicant.
The legal applicant. Okay, thank you.
Mr. Innes.
Yeah, the only thing about a Section 36 breach is it goes directly to criminal sanction. There isn't an enforcement notice mechanism or a breach of condition notice mechanism. I suppose it's fundamental to whether the ministers want to get involved. And my general view from what the standard conditions are is they tend to take the overview conditions which control the key things about implementation, length, etc., are all kept within the Section 36, and clearly the consequence of that is any variation has to go back to the ministers if you're changing those through the Section 36 variation procedures. And I can understand that from a regulator controlling the overall position. General experience of them getting involved is that they really don't have the necessary people to really deal with discharge of technical conditions. That's not really the function of the consents unit, and I think it's not to say they won't, but I think the local authority, even with their planners, who actually are quite used to dealing with these types of issues, can actually see something, would probably take into account the comments of SNH and be able to deal with it. I think that would probably be the mechanism.
Okay. Thank you, Mr. Innes. Okay, moving on. If we look at the conditions that might be attached to deemed planning permission, Condition 6, implementation in accordance with approved plans. Any comments? No. If you want to make a comment, just raise your hand or look at me. We'll go through. Condition 7, design and operation of turbines. Well, I'll ask, is it actually necessary in the reasoning, that's in italics, to refer to the development plan policies and supplementary guidance as part of the reason? And that's consistent for all the reasoning given. Is it actually necessary to refer to those?
I would admit that I've added that. Obviously, it's out of date. And actually, when you look at Circular 498, it actually says if you state something like if for reasons in the interest of visual amenity is not sufficient. My understanding when you read Circular 498 is you have to link it to a reason of policy. So I appreciate it's probably quite wordy, but it's really just to try and link it to a policy reason. I appreciate that it's quite common to see reasons given of just simple in the interests of, or what's a common one is to define the terms of this planning permission, but it's not actually, or it's something that the Circular 498 actually says you need to expand further upon and link it to a policy reason. So it's more for completeness, really.
Any comment on that, or can I move on?
Move on, sir.
Right, Condition 8, design of substation and ancillary development. Any comments? No. Condition 9, micrositing. Now, why would it be appropriate to delegate the approval of micrositing to the Ecological Clerk of Works, Mr. Innes or Mr. Sims?
We're not seeking to delegate the whole micrositing distance to the Clerk of Works, but it's appropriate to have some flexibility on site to microsite and respond to conditions you encounter as you're building the development. To require prior written approval for any micrositing during construction. So, for example, if a contractor is building a track, comes across some unexpected ground conditions and needs to move that track by just a small distance to get around them, it's pretty impractical to halt work, go back to the council for, say, a 10-metre movement of that track to avoid that particular ground condition. If that happens a number of times, which invariably you do risk finding expected ground conditions.
I may have to throw. My understanding reading this is the micrositing that you're proposing would allow up to 50 metres. Is that right?
That's correct.
And is that for all infrastructure?
The trouble is, if you move anything, it tends to have to move within the micrositing allowance. If the turbine moves 50 metres, the track has to move as well. So virtually everything has to.
That's what I'm trying to understand here. So it's not simply moving a track 20 centimetres, 2 metres. You could effectively be moving a turbine 50 metres and asking for the Ecological Clerk of Works to sign that off rather than the Planning Authority. Is that right?
It is absolutely right, and is a standard practice designed to deliver a better environmental performance of the construction process. And the difficulty with saying that there shall be no micrositing without approval is that if the site is mobilised, everything is, there's a whole construction programme, and there'll be all sorts of issues that if you get knocked on the delay, that can have major consequences for the deliverability. This allows, and the ECOW is not some person that's in the pocket of the developer, they're appointed and take their role very seriously in identifying the suitability of the requests for micrositing that they make. And I think one of the things that has developed since the early days is the expertise of the Ecological Clerk of Works, who are very well used to working in the environment, technically understand what is proposed, and if at the end of the day they are in any way unhappy, can refuse to permit the micrositing in question. And the difficulty with imposing any constraint on that is you can't build a wind farm if every time you move the access track 5 metres, you have to go back for approval. It will never stop and start. It will be the real difficulty is, if you can understand, the contractor has to bid on a construction contract based on the conditions. If at the end of the day they can't be satisfied that they have a certain leeway in mitigating certain of the effects, they will have to price the contract differently if that wasn't there. And it is a standard part of wind farm construction that there is an allowance for this, effectively, the micrositing within the site.
I can appreciate that. It's the distance of 50 metres. I'm trying to understand where that comes from and why. Well, also where does it sit once the Ecological Clerk of Works has signed something off in writing? Where does that piece of paper go? Is it copied to the planning authority so they're aware? Well, we thought the turbine was going there, but now it's actually moved, or indeed all 30 turbines have moved 50 metres in one direction or another?
There's absolutely reporting requirements on the Ecological Clerk of Works. We also have a planning monitoring officer as well to monitor it. So we've got a plethora of people whose role it is to ensure that there is this is built in accordance with the consent and adequate controls are in place. I mean, some of them, Section 36 consents, have had up to 200 metres micrositing.
With an Ecological Clerk of Works citing that off? Yeah. Can you cite any?
I think it was Whiteley originally had 200 metres.
Mr. Robinson, any comment?
Yes. I totally understand and don't dispute any of what's been said there. The reason for our comments on this is really based on legal advice that we have been given. As some of you may or may not be aware, we currently have a case in the Court of Session at the minute for Hopsrig Wind Farm, and one of the challenges that our advocate has put in is that the reporter, when approving that appeal, gave an Ecological Clerk of Works similar authority, and the QC who has put in our challenge has raised doubt as to whether that is permissible under the Town and Country Planning Act, if whether really it should be the planning authority that can only give written approval of such variations. So based on that advice that we have been given from an advocate. That is the reason why we've raised that.
Okay, what was the wind farm description again?
It's Hopsrig Wind Farm. Hopsrig, yes.
The reason I have to be careful, I'm the QC on the other side in this case, seeking to defend the permission. So Mr. Robinson has chosen his words carefully.
Okay, I understand that. Any reply to that, Mr. Innes?
Well, it is utterly standard practice to allow micrositing of this type of infrastructure. And it happens all the time. And in terms of others, national infrastructure projects, you get limits of deviation and all sorts of issues that are allowed to be formulated in terms of final layouts, etc. Insofar as it is genuinely an appointment whereby the ecological clerk of works isn't changing the development, but is permitting minor variation in where matters are placed, having regard to the and I think I'm about to get referred to I'm under a duty to disclose what we actually said in the ES. So at paragraph 4.53, we suggested up to 30 metres was sign off for the ECOW, 30 to 50 on Dumfries and Galloway Council, and 50 to 100. Updated assessment and communication to provide the Dumfries and Municipal Council for approval through conditioned discharge process. So I would have to acknowledge that having set that out in the assessment, I would probably be stuck with that, because that's the basis on which the de minimis distances have been set.
Well, where was that in the ES, sorry?
That is at paragraph 4.53. We'd be happy with those distances. It's very unlikely, although we asked for 50 metres, it's unlikely you're going to look to move all your turbines 50 metres once you start construction. Something's gone wrong if that happens. I mean, that's unlikely.
Okay, noted. Any further comment on that condition?
From our point of view, the actual shifting of the turbine 50 metres could, if it's on a ridge line, if it's tucked behind at one period and then it's moved over, the impact could be quite considerable. I'm less bothered about something like a track moving a few metres. The impact would be far less, and I just wondered if it would be possible to differentiate between the conditions between the moving of something like a turbine and the shifting of the position of a track, of ducts, and other ancillary structures.
Thank you, Mr. Godfrey. Any comment?
You would need the flexibility to move both, I think. You are more likely to move tracks during construction. You're more fixed on your turbine locations prior to starting construction, but you do need some flexibility there.
Noted. Thank you. If we can move on then. Yes, ma'am.
Can I just ask for clarification? I read here that there is a 100-metre possibility of moving, and I expect this is standard, as you just said earlier. Supposing the land that you're proposing to put the turbines is such that you need to have a lot of things moved, and it significantly changes the design, is a provision for that kind of thing? Who looks after that kind of thing if we suddenly discover that the design has totally changed?
I think in light of paragraph 453 of the ES, we would be happy to adopt that, I think, in the condition. The ECAL will not just blanket sign off any movement. If that makes some impacts a lot worse, say you're moving the turbine a lot higher up and making it a lot more visible, the ECAL will take account of that. And I think what we've said here is 0 to 30 metres, the ECAL will take account of that. 30 to 50 metres, Dumfries and Galloway will need to look at that and sign it off. 50 to 100 metres, we would provide an updated assessment, not of the whole scheme, but relating to that movement to see, does that change things?
That clarifies matters. Thank you. Okay, condition 10, Borough Pit Scheme of Works. Any comment? No. 11, Borough Pits Blasting. No. Condition 12, Planning Monitoring Officer. Any comments? No. 13, Ecological Clerk of Works. I take it all parties are happy to add the Nith Salmon Fisheries Board as a consultee? Yes, you're all nodding. Similarly, for the Kemp or the Condition 14 Construction Environment Management Plan, you're happy to add Nith Salmon Fisheries Board? Yes. Yes, Mr. Godfrey.
I've got. I think we've got an issue there on clause V. This is the sampling strategy that was sort of talked about in the inquiry. In the second line of that clause, after the word undertaken, could we add in consultation and agreement with SEPA? Would that be possible?
I think that's set out at the very start of 14. So the whole SEMP would be signed off by SEPA. So by default, also Part B.
Sorry, I missed that.
The whole of the SEMP would be consulted through SEPA. They're included at the very start of Condition 14. So,
right, that's
so
fine.
Part B
that
would automatically go to them, yes.
Could I suggest maybe also adding, in consultation with the Council's contaminated land officer, to that point, actually. Some of that I think we added to try and take into account comments from our contaminated land officer, who didn't object to the proposal, but there was a request for details along those lines.
I mean, in practice, it says here it's been submitted to and approved in writing by the Planning Authority in consultation with SNH and SEPA, so that the Planning Authority would be within your remit to go to the contaminated land officer. Is that sufficient?
Yes, it could be, fine.
Condition 15, construction hours. Yes, ma'am.
Well, we are concerned about the times, from 7 a.m. to 7 p.m. and the Saturday 7 to 4. Living in One Lock Head and being in a basin, we do have echo, and we've mentioned that before in our different scoping stuff. But, you know, I could be outside my garden talking to my neighbour, and people will be able to hear that conversation at the other end of the village. And so that happens. We have an echo thing in the village, and we're wondering, although the proposal will be just not in anywhere near the basin of the village, it's just outside of the basin, on the rim, if you like, we wonder, I'm wondering, because I don't know, you know, the noise, how that noise will be.
So in terms of this condition, are you asking for different construction hours to be adopted then?
Yes.
And what would they be?
Well, I think it would be, you know, later, finish earlier than 7, and also maybe start a little later, 8 till 5. And
any comment, Mr. Innes?
Having lived next to a building site for the past 3 years, all I can say is all I ever wanted was it over quickly. There's an element here that there's a balance to be struck between getting the project completed as swiftly as possible and also the working hours. These are standard construction working hours for the wind farm industry. Lots of the people are employed and that's the nature of the working hours. And not everyone's working those hours, but there will be working aspects that they have to complete. So as soon as you start saying it's 5 o'clock, work can't get started. It just drags the whole construction programme again onwards and extends that period. So I don't think it is straightforward, and these are relatively standard in terms of the wind farm industry.
Okay, both your points of view are noted. Mr. Godfrey, briefly. Yep.
Yes, I'd agree with Mr. Innes. There are certain types of work, such as doing a big concrete pour for the foundations. You can only do it in a wanna, and those are the standard hours. And I think the villages of Wanlock Head are protected by the noise condition further on. Also, I think the access to the site is away from Wanlock Head. So I don't really see that would cause an issue in actual fact.
Okay, well, I mean, I'll bear in mind what you've said in terms of changing construction hours and what Mr. Innes has said. Okay, in terms of condition 16, traffic management plan, any comments? No. In terms of 17, details of off-site accommodation works? No. 18, post-construction carriageway works? No. Access routes, condition 19? We've already discussed, hang on, back to access routes. South Lanarkshire Council's requested involvement in the abnormal route planning. Would the condition allow for that, Mr. Innes? I apologise, I'm not actually sure it's that condition it would apply to, but is there a condition here that would allow South Lanarkshire Council?
Is consulted. The difficulty with having two decision makers is it makes it rather hard if there's an impasse. So essentially there's a consultation process which I think the host planning authority will essentially liaise with both South Lanarkshire Council and the Transport Scotland.
Okay, is that your understanding, Mr. Robinson?
Yeah.
Okay, condition 21, Archaeological Clerk of Works. You're all in agreement to remove Historic Environment Scotland as a consultee? Yep. Condition 22, Programme of Archaeological Work. Is that agreed? Any comments on condition 23, fencing around archaeological features? No. Condition 24, replanting of forestry. My only question from myself is, instead of referring to the Forestry Commission Scotland, should that refer to Forestry Scotland? Yep, okay, that's correct. Condition 25, peat landslide management. Any comment? No. Condition 26 on noise. I assume we should remove reference here to Harryburn in tables 3 and 4.
So that's no longer applicable.
Are we to assume, because there is quite a lot on noise, are we, as a laywoman, am I to assume that there will be noise? And, you know, we don't know what we're expecting or to be expecting if this proposal is granted. Can somebody enlighten me, please?
Well, very briefly, and Mr. Innes could come in here, the council can. There has been a noise assessment. The details of that are within the environmental statement, and this condition effectively protects properties which are listed, I think, within the tables, Table 1 and Table 2, and if the decibel level exceeds those tables in certain parameters, then this condition deals with the action that might arise as a consequence of that. Is that correct?
Yes, sir, and there is quite a lengthy framework of people having to be appointed in the event that there are any complaints to go and test that. And of course, that's set out, because it sets out all the procedures that the assessment will have to go through, who it would be, etc., and the whole process. It's probably the most detailed monitoring condition there is, and if it's triggered, the council will ask for that to be done.
If there are complaints, because it can be heard, what can you do to mitigate it, please?
Well, the condition doesn't say it won't be heard. The condition says there are maximum levels of specified noise with the measure that can that can occur at the various locations specified. If at the end of the day parties feel that those levels have been exceeded, they can make a complaint to the council, who have, in terms of condition 26, a panoply of procedures to go through to test whether or not the turbines are performing as anticipated and within the limits specified.
Does that answer your question, Mr. Richard?
Well, there is all this procedure, but ultimately, could there be any remediation on that?
Well, that's what the condition seeks to do. So it's a scheme where, as I say, there are tables. If someone has a complaint, they can then use this condition. The council can investigate using what's set out in this condition, and ultimately there could be a mitigation package. Is that correct, Mr. Innes?
Well, it's the process is a well-worked one, and the other thing is that the cumulative schemes are far enough away not to complicate matters. So, yeah.
And could I just confirm again, this might be as you recorded for the abnormal loads, South Lanarkshire Council, have they been involved in devising the condition?
No. Well, somebody sent it to them as part of the note and never got a response. The difficulty with South Lanarkshire being involved is the noise emanates from Dumfries and Galloway, and the control is in Dumfries and Galloway. So if there's a breach, it's on the operator where it exists, and that's where it would be caught. Yeah.
Okay, condition 27, shadow flicker. Any comments? 28, television and radio reception. No. Private water supplies. Condition 29, no. Condition 30, redundant turbines. Any comments? 31, aviation safety. 32, aviation lighting. Are parties happy to accept the reworded version of this condition?
Yes, sir.
And Mr. Robinson, you're happy with that too? Yeah, and you're happy? Yep. Condition 33, site decommissioning, restoration and aftercare. Parties are happy with that? Yes. Condition 34, financial guarantee. Parties are happy? Yes, Mr. Godfrey?
I just wondered whether it was specific enough, in particular in the second paragraph there, just where it says contained in condition 33, then it leads on to the value of the financial guarantee shall be reviewed, etc. What do we actually mean by the value of the financial guarantee? I mean, what scope is there in terms of, you know, there might be a change in the cost of the works that would impact on the total restoration cost eventually, and there may well be as well. You know, we don't know what might occur in terms of inflation. So, I mean, I just wondered, you know, whether that was specific enough. That was the point I wanted to make.
This is the standard condition. It works in practice, and effectively there is a mechanism for ensuring that there is ongoing revaluation of financial guarantees in respect of the potential decommissioning costs. I would say that the general, there was, I think, pretty widespread broad agreement of the various costs involved, and certainly there are now individuals and firms who are suitably qualified and independent to provide those particular valuations every 5 years, and from that there'll be an increase or decrease.
Okay, I'm quite happy to accept that.
Okay, Mr. Governor. I mean, it would be my understanding this bond or financial guarantee would have to be acceptable to the planning authority, and it would be for them to check whether or not it was index related or linked in some way, and what mechanism they use for that. Is that correct, Mr. Robinson?
That's correct, and the period of every 5 years is pretty standard, not just for wind farms, for mineral sites particularly.
Now, in terms of condition 35, extraordinary damage to roads, is that a competent condition to require a legal agreement to be signed, Mr. Innes?
It has its challenges, but it's quite a regular position. The reality of the situation is actually it's in the developer's interests to enter into those relevant agreements, because we're using the road systems, and what the mechanism for Section 96 gives is we record the record of the road before and during construction, and if we've damaged it, we repair it. And equally, there is legislative provision which, if we do damage the roads, we can be obliged to repair them in any way. I suspect this is almost, it is difficult to say that there should be a legal obligation to enter into another agreement, but at the same time, it is something which a lot of authorities want to have to make sure they're put in place. And it is a suspensive condition rather than an actual requirement, and therefore there is a debate as to its legality.
But you're comfortable with it?
Comfortable in the sense of it's a suspensive condition that requires us to enter into an agreement relating to extraordinary expenses, which we would do in any event.
Mr. Robinson?
Yeah, I mean, the reference to other parts of legislation is not something that's a competent condition, but there has to be some. This is why generally we would normally request such a thing as part of a legal agreement, but obviously there's the Scottish ministers are quite keen to ensure that there is not many planning obligations, but there is definitely tension in referring to other legislation within a planning condition.
So, indeed, do we need to, in fact, refer to Section 96 of the Road Scotland Act at all? Could the condition not just require the company to enter an agreement with the planning authority, and the planning authority can determine what form that agreement would take and whether or not it requires entering into a Section 96 agreement?
In reality, it probably would be a Section 96, but it doesn't need to be listed.
Are you comfortable with that, Mr. Robinson?
Yes. Yeah, I think so, yes.
And I'm going to go back again because we're on the border here. South Lanarkshire Council, within their representations, has said that they would like a separate legal agreement for road repair. Could that be covered here? I'm in liaison, as you said.
We need to enter into it with the authority that controls the development, because that's really the enforcement mechanism. Because South Lanarkshire Council can't stop us commencing development. It's not in their area.
Mr. Robinson, would that happen in practice? You'd liaise with your colleagues in South Lanarkshire Council?
It could be added in the condition. I suppose there is an issue of whether they respond. Ultimately, there has to be the lead authority. I mean, if it's there is obviously access routes proposed through South Lanarkshire to access the site from construction vehicles. I'm thinking in the Croik Valley route, so it would obviously be in their interest. I suppose that I've no objection to consulting South Lanarkshire Council, but then that would all it have been required. And if they weren't to respond, then we would have to proceed on that basis.
So we could change condition 35, possibly no commencement development until the company enters into an agreement with the planning authority in consultation with South Lanarkshire Council with respect to extraordinary expenses in repairing roads damaged by heavy vehicles, etc. I notice it says etc., which maybe isn't very specific, and also there's no reason here for the condition. I'm assuming the reason is to repair the road to a reasonable standard. Parties happy along those lines?
Yes, I think it might be, rather than an agreement, it could be a scheme that's submitted, or a scheme or other mechanism.
I agree.
Yep.
Now, we're almost there in terms of condition 30, and I've called it 36. These are the additional conditions. Species mitigation and management plan. Now, RSPB suggested a legal obligation or other legal agreement be used to secure the conservation management plan. Is that required, or are you quite comfortable with the conditions proposed?
I'm very comfortable with the conditions proposed, sir.
And from the council's point of view?
No objections.
Again, you're happy to add the Nith Salmon Fisheries Board as a consultee into that condition? Yes. Telecommunications Infrastructure 1 and Telecommunications Infrastructure 2, any comments? No. Terminology, has anybody got any comments in terms of the terminology? Well, I would say the definitions provided at the end of the conditions there. No? Okay. Moving on to item 5 on the agenda then. I assume there are no legal agreements or obligations required then? No?
No.
No, Mr. Robinson?
Our general, we do prefer things such as restoration, television reception as planning obligations, but Scottish ministers have other ideas on that matter, so I think I'll just leave that there.
Are there any other relevant matters in terms of the conditions? No, in that case, thank you very much for your participation. That draws an end to the inquiry proceedings. Thank you all for your participation. As I said, I will issue a procedure notice shortly, within a week or two, asking about Eskdale Muir and setting out when closing submissions will be required. Has anybody got any questions? No, in that case, can I thank you all for your participation, particularly those in the community who aren't being paid to be here. So thank you.